My name is Sal Hernandez. Good afternoon. If you'll please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure your appeal is filed in a timely manner and that all procedural requirements have been met. Mr. Fields circulated last month's meeting minutes to the commissioners ahead of today's meeting. Have the commissioners had an opportunity to review the draft minutes?
Yes.
Is there a motion regarding approval?
Move approval.
Second.
All those in favor?
Aye.
Motion passes. We have an NDOT update on the pilot project for e-bikes up next. Mr. Fields?
Can we defer that to later in the agenda?
All right. Yes. We also have next public hearing. We have our annual emergency wrecker zone assignment public hearing. I'm told no new applications or zone alteration requests have been filed, but we do each year have a public hearing to address this issue. Ms. Fields?
Each year you are required to have an annual meeting to consider any applications for new emergency companies and or alterations to the zones by existing the existing emergency companies. There were no applications. As in the past, you probably need to open the hearing. There is nothing to hear. So then you would actually close the hearing and you would have fulfilled the requirement. Unless Ms. Costonis wants to do something different this time. We're good.
All right, we'll go ahead and open the public hearing. Did anyone submit a request to speak on the issue?
There's nothing to speak on.
All right, we'll go ahead and close the hearing.
Now, we do have some of the companies here. If you'd like to hear from any of the companies, that would be the commission's authority. I don't know that all of them are here, but many of them are here and shaking their heads. So,
I'm happy to hear from you or not. It's no, I will not consider it that you don't want to speak on the issue, but I'm happy to hear from any of you. Go ahead.
I'm Jim Mitchell with Dad's Towing in West Nashville, and also the president of the Davidson Emergency Towing Association, the zone companies. And on behalf of the zone companies, I'd like to just say thank you for allowing us to provide service for you, the community. You know, this has been a challenging year and a half now, and for many of the businesses I know have all had some battles. We've had lots of battles, but we continue to provide a service for the community and all the entities, police departments at a reasonable and fair rate, protecting our citizens as they travel through Nashville as well. And we appreciate the opportunity to do it again another year, and I think I speak for all the zone companies.
Thank you, Mr. Mitchell.
Thank you.
At this point, we'll close the public hearing. I'm sorry, I missed your hand.
this is on emergency wrecker zones.
Is there anyone else who would like to speak on the issue? All right, we'll close the public hearing on the emergency wrecker zones. Ms. Fields, do we need to make a motion regarding reapproval for the zone assignments?
Yes, sir. Yes.
Okay. I also move we approve all the requests listed in the agenda, which I don't have. Second. Yeah, I mean, so we do have the agenda.
existing assigned emergency wrecker zones will be left intact.
Yeah, I think the motion should be a little more specific. If you could, Mr. Rogers, do you need a copy of the agenda?
Is it on there?
Yes,
No.
It would be appropriate, I think, if the commission were to reconfirm the existing emergency zone assignments.
You mean read them in the record?
It would be appropriate.
Oh, okay, sorry. Okay, I move that we approve the annual emergency wrecker zone assignments for A.B. Collier Wrecker, Bailey's Wrecker, Chapman's Wrecker, Cotton's Roadmaster, Dad's Wrecker, Donaldson Wrecker, Martin's Wrecker, Mike's Custom Towing, Smith's Wrecker Service, Tom's Wrecker Service, Tow Pro, and West Nashville Wrecker. Second.
All those in favor?
Aye.
Motion passes. All right, thank you. Next item on the agenda is under wreckers and towing services. We've been asked to review a new application for priority towing. Mr. Fields.
As you recall in your meeting last month, Priority Wrecker made application to be a general wrecker company. After your discussions, you moved to deny. They've reapplied. There's not a portion in the ordinance exists or in your rules that identifies when a company can reapply. So they have reapplied and would like to be considered.
Mr. May? Sure.
And Mr. May is here. Good afternoon. My name's Rocky King with Adamson Reese, and I appreciate y'all's time today. First off, I want to thank Mr. Fields and Ms. Costnosis. They helped us navigate this reapplication process, and we had a good discussion on that, and that's what brings us here today. In reviewing the record previously, one of the main issues with Priority Wrecker Services application was, to use a term, it got ahead of its skis, or to use another term, it stumbled out of the gates and began operating in Nashville without a permit from this commission. That was a mistake. They acknowledged that was a mistake. When they retained counsel, as we laid out in our letter, we acknowledged that was a mistake. But as also, as Mr. Fields and I discussed, their application was otherwise satisfactory as to the insurance requirements, their ability to provide services. So one of the things that we've done to try to help us get up out of that stumble out of the gates was to implement, as of June 8th and 7th, when we first were retained, procedures to stop any services in the Davidson County metro area, to make sure that dispatchers are confirming that the tow or wrecker service is not originating in Davidson County or is not terminating in Davidson County, but rather is operating completely in the outside ring or the surrounding areas outside of Metro. Priority Wrecker has been successful in weeding through those issues and making sure that they are not operating in Davidson County at this time. As that was the main issue, this is a company that is licensed in other jurisdictions. They're licensed in the city of Chicago. They're licensed in Illinois to provide wrecker services. They would like to be licensed here in Davidson County. And the concern that this commission expressed, as I watched and listened to all of your concerns, was that is this stumble something indicative of their inability to comply with the rules going forward? I think it's a telling statement that when Mr. May was denied and had time to actually look at this issue, he sought legal counsel. And we are now his counsel, helping him navigate through these ordinances and implement policies and procedures to prevent him from stumbling further. So with that, I'm happy to field any questions you may have about this company, but we are seeking reconsideration or reapplication. Ms. Costnosis and I had a long discussion of what the proper procedure mechanism should this be called. And as I suggested to her, I can understand hesitation that this commission may have, given the last hearing. We're amenable to probationary status, that we're put on come back and talk to us in 3 months and have inspectors make sure that we are doing what we need to do. But this is a company that is committed to getting it right, to stepping up from their stumble, and to make sure that they are a good corporate citizen in this jurisdiction.
And you said Mr. May is here?
Yes.
This afternoon? Is he prepared to give testimony that he has not been operating in Davidson County since the last month's hearing?
I want to be very careful in how I word this and be transparent, because last month's hearing was May 26th.
Yes.
June 8th is when he is prepared to say that he has cut off all issues, ensuring that he has not operated in Davidson County. Mr. Fields and I had a conversation beforehand. He was very kind in letting me know that there may have been a citation issue. Mr. Fields could not recall the date, and that's fine, that he may have operated inappropriately after May 26th to our June 7th retention. And I don't know the facts of that citation. Mr. May and I spoke in the hallway before this commission meeting started. He's not received the actual citation as of yet. So without knowledge of the exact details, I can't get into the granular assessment of what the facts are in that case. What I do know is I believe he is prepared to testify that as of June 7th, it's cut off. The procedures were put in place to ensure that dispatch, he's hired an individual to ensure that when dispatch is contacted, the exact questions are, is this tow wrecker service originating in Davidson County, or is it concluding in Davidson County? Because there is a provision about transient services in the ordinance about 5 times a month. We're trying to avoid even the implication of that provision, members. We want to just comply and come and start anew with this commission. I know that there was a mistake made. I know there was ways that it could have been handled more diplomatically at the first commission hearing, and unfortunately I think we wouldn't be here today if our retention was 8 weeks ago, as compared to June 8th, today's June 23rd, 15 days ago, or 16 days ago. So we are prepared to do all that is necessary to be in compliance. I think he is prepared to testify that he is in compliance as of June 7th, the date of his note included in our reapplication materials. And we will continue to work with this commission, be it through a probationary status, be it through any other type of oversight to ensure that this company remains in compliance.
All right. Thank you, Mr. King.
Thank you for your consideration. Does anyone else have any additional questions?
Mr. Fields, do we have the details on the ticket
Inspector Morris
citation?
is present and can share information related to the incident.
All right. Mr. Morris, would you mind please stepping forward? And I didn't ask this of Mr. King since he was really representing his client, and Mr. May has not given or offered any testimony, but if you'll please repeat after me. I swear or affirm that the testimony I'm about to give is the truth, the whole truth, and nothing but the truth.
I swear or affirm the testimony I'm about to give
Is the
the whole
truth,
truth, and
the whole
nothing
truth,
but-
and nothing but the truth?
nothing but the truth.
Thank you. Mr. Morris, could you please give us the details of the citation?
Yes, sir. On June the 1st, approximately 6:18, I observed a priority wrecker on I-65, pretty close to the Rosa Park exit, hooking up to a vehicle at that time, was already hooked to it to do a tow. Took several pictures of it from the Rosa Park exit. After I took the pictures, I then drove down the interstate, come back, parked in front of the vehicle, walked back, spoke to the helper who told me he was not the driver, pointed the driver to me. I then spoke to the driver and told him that he was doing an illegal tow because the company was illegal. He told me that it was not an illegal tow, that he was not towing the vehicle in Davidson County. I told him that he was. he said that he wasn't. And of course, I didn't want to argue with him, so I went ahead and left. Went on, and they actually towed the vehicle over truck stops of America and dropped the trailer. I went back. I notified Director Fields, told him that what had happened, that I need to go ahead and write a citation. He told me to wait. He was going to talk to legal. Then he came back later and advised me to go ahead and write a citation, and which I did, and that citation has been mailed.
And Truck Stops of America, that's in Davidson County?
In Davidson County, yes, sir. Over close to Nissan Stadium.
Okay. All right, well, thank you, Mr. Morris.
You're welcome, sir.
You need photographs?
Do you have the photographs?
Yes, I do.
All right, if you could provide those, and if you could share them with Mr. King.
These are copies.
Mr. King, would you like to add anything?
The only thing I would like to add, Mr. Chairman, is that timeline actually does line up, and it makes me a little bit satisfied in the sense that that is before our retention, the procedures went into place. As a procedural matter, I know you didn't swear me in as counsel, but I do know that my client, Mr. May, if he was sworn in, would attest to my factual representations as to be true and accurate, as we have discussed. I don't know if that's a point of procedure for the commission more than anything, and I wanted to flag it. Like I said, the problem that we have here is we had a situation where he made a mistake, and he came out of the commission and was giving instructions to not originate tows and not have tows terminate in a loop, for lack of a better term, originating in, closing in Davidson County. Dispatchers were at some points receptive to that, some points didn't understand if the original request was to go out of the county, if it could originate in the county. That's a mistake, and we have now implemented procedures to make sure that this company is not operating in Davidson County. That's what our letter and representation to this commission says as of June 7th. Unfortunately, this is before June 7th, so I can't go back and correct that. Again, I would suggest and recommend if the commission would like to hold this in abeyance or put us on a probationary period so we can demonstrate compliance or demonstrate our otherwise ability to comply with these rules. We're prepared to accept that. We would welcome that. We would welcome that oversight over our shoulders. What we can say is that since June 7th, since the retention of this law firm and thus having concrete legal guidance on what these ordinances mean, how to comply with them, we believe that this company's been a good corporate citizen. Thank you for your consideration.
I have a question for you.
Yes, sir.
Just to be clear, your client retained you on what date?
We were retained. He came into our office on June 7th.
After the Sunday. Okay.
Oh,
that's all
I just.
That's it. Thank you.
Thank you.
Sorry.
Appreciate it.
Thank you, Mr. King.
Thank you.
Do any of the commissioners have any questions for Mr. May? Would they like to hear from Mr. May?
I definitely would like to hear from Mr.
If you would have Mr. May come forward, we
Thank
do
you.
have some questions for him. Mr. May, if you'll please repeat after me. I swear or affirm that the testimony that I'm about to give
I swear or affirm that the testimony I'm about to give
is the truth, the whole truth, and nothing but the truth.
is the truth, the whole truth, and nothing but the truth.
Thank you.
You're welcome.
Mr. Carr?
Mr. May, so it's my understanding that you retained this law firm on June 7th. Was this after you were made aware on June 1st that you had received a citation for illegally towing in Davidson County?
I was not informed that I received a citation for illegally towing in Davidson County until today.
So no one in your dispatch or this person who was dispatched out, you had no knowledge that they were picking up a car on Rosa Parks?
At that moment, no, I did not.
And so it's my understanding that you were clear when you left here that you were to cease and desist from all operations in Davidson County from the day that you left. Yet this is 2 weeks after you left. You were still operating in Davidson County. Can you explain to me why that was still happening?
That was an honest mistake. Everybody was made aware in our dispatch office, and there was just some things, as Mr. Rocky King had explained. You know, our dispatch team didn't get together and let one slip through the cracks, unfortunately, and was serviced in Davidson County. It was not supposed to happen, though, and we do apologize for that happening. So, you know, it was not intentional.
So you're saying in that 2 week period of time when you were actually given the citation, this was, to your knowledge, the only incident of a tow in Davidson County?
To my knowledge, yes, but I don't know of a citation until today.
Do you keep records of your tows in terms of where
We do.
where they originate, where they terminate?
Yes, we do.
Are you able to get your hands on the records from May 27th through June 8th to be
We
able to
could.
tell us which tows originated or terminated in Davidson County?
We could, yes.
But this is the only one that you're aware of today that occurred in Davidson County?
Yes, I work between both locations. I go between here and Chicago, and this is the only one that I'm made aware of as of today.
Have you taken the opportunity to inspect your own records?
Inspect them as far as
Between
records
here
or
today-
records?
Records.
Records?
Yeah, between today, like you knew you were gonna come talk to us, and you probably knew that somebody would ask you this question. Did you look at all the tows that happened that happened through the company in Middle Tennessee to see if there were any others?
So what it is, I did do a quick glance and I didn't find any other evidence of that. And then I also went ahead and implemented this system from meeting with Rocky King to make sure that we do not, you know, furthermore, at all do any operations, because his informative information was to double check and make sure we're not doing that.
I'm trying to make sure I'm understanding the timeline as well. So you retained the legal representation with Mr. King. I guess what was your purpose in that? The way you're explaining it sounds like you're doing it because you wanted to make sure you were not towing here. But why did you wait till June 7th to do that? Why wouldn't you have done that right after the meeting to ensure that no tows were made within Davidson County, just to be on the safe side?
I did both. So, like he said, the other one did happen in the meantime, but the reason for retaining Rocky King was to make a reapplication for reconsideration.
And then what was your process after last month's meeting in informing your staff, your dispatch, that they were not to operate?
They were informed that if any calls came in with the Nashville, Davidson County area originating in, were to tell them that we didn't have anything available to do so.
So just verbal, nothing
Over
in
the phone, yeah.
writing?
I mean, to our customers over the phone, but to the meeting, to our.
Yeah, to your staff,
We don't have a
but-
huge staff like as big as you guys here. We only have a few dispatchers, so there's 4 dispatchers, and we hired an additional dispatcher to make sure this doesn't happen. His name is Tony.
There was one other issue that was brought up the last time you were here,
Okay.
and it sounded more like of a transference of service where calls were coming in through your service but actually being transferred to other tow companies. Has there been any more issues with that since that time?
We have not subcontracted a tow since, no.
Mr. May, one of the things that we're going to be considering, I believe, is a new rule for the Transportation License Commission, that if an application is denied, substantively denied, that the applicant can't reapply for at least 90 days. That's not in our rules currently, but that is something that legal is is proposing that the commissioners consider implementing. So that's actually something we're considering here with regard to your application. We denied your application last month, and so now you're here. The one major change is you've hired capable counsel to, argue your case, which I commend you on doing that. But we also now have evidence that you were operating even after May 27th, at least one time in Davidson County, and that you're going to be receiving a citation from that, from our inspector. So it doesn't seem like that the circumstances have changed enough from last month's application and your denial and this month's, with the exception that you've testified and your lawyers argued that you're not operating currently, at least as of the time you retained counsel. Is that a good recitation?
It was my understanding during an application process, you cannot operate. So during this application process, we have not operated within Davidson County.
But for the one time that you're going to be getting a citation for?
We hadn't reapplied then yet. I'm hoping that we can look past that to get this thing legitimately straight and work forward with you guys in the best manner possible.
Are there any other questions for Mr. May? Thank you, Mr. May.
Thank you.
Would anyone like to make a motion regarding the application?
I'd like to make a motion to not necessarily deny, but defer the application until said time that Mr. May does bring us those tow records to show that this was just a one-off and he just did not adamantly look over our instruction not to tow, even though I understand, trust me, I service in multiple states too, that you cannot be everywhere at all times, but you are responsible. And you need to make sure that your staff is responsible, and this council is here to hold you responsible. So if you, I would make a motion to defer and ask you to bring in the records of your towing in between the time that you spoke with us
May 26th.
May 26th and now, before we even consider the reapplication. Not to deny it, but to defer it.
Mr. Fields, what was the date of last month's meeting?
May 26th.
Is there a second regarding the motion?
I'll second.
All those in favor?
Aye.
Any nays? Motion passes. All right, the application's been deferred.
Mr. Hernandez, just a point of clarity, it's deferred till next month's meeting.
Yes.
For the record submission, just a little bit of, would you like all records pretty much as of the date we submit them? Because as each day rolls by, this is another day we won't be towing, this is another day we won't be towing, this is another day demonstrating compliance. Would that be acceptable to this commission?
That's fine.
Thank
Yeah.
you.
From May 27th.
May 26th, of course,
Yeah.
that's the start date.
Yeah.
I totally understand
Yeah.
that. Thank you for your consideration.
All right. Next item on the agenda, we have 3 record driver applications. Mr. Fields?
The applications, we've had a couple of changes. Mr. Brown has withdrawn his Christian Brown has withdrawn his application. Richard A. Lucas has withdrawn his application. Mark Brown's, Christian Brown has been withdrawn. Mr. Mark Brown, I believe, is here and ready. We did a secondary review of Mr. Lucas and determined that it does not require your action. So we only have, under records, we only have Mark Brown if he is present.
Mr. Brown? Good afternoon.
How you doing?
Are you Mark Brown?
Yes, sir.
All right. Mr. Fields, could you give us a preamble as to why Mr. Brown's application is before us?
In making his application, he failed to disclose a 2017 original aggravated domestic assault charge that ended up in a guilty plea of a assault with physical contact, and that was not disclosed. He did show a battery. I could not find battery maybe he disclosed that as a battery, but it's certainly not aggravated, not an aggravated assault arrest.
Mr. Brown, could you please describe to us, why this particular arrest and charge was left off of your application?
It wasn't. It was the battery. That's what, they lowered it down, and it was all like a big joke. She just said I beat her up, and there was no proof of none of that. I was just trying to get my stuff and leave that house.
Is this what you've listed on your application, assault 2018 dismissed? Oh, thank you. I was looking at Christian Brown.
I did the same thing.
I was looking for the battery.
Yeah, they lowered it.
That's correct.
She had 6 or 7 priors of doing that to other people. I didn't know at the time, but
Mr. Brown, were you placed on probation in 2017?
no. Oh, wait a minute. That's for that battery. All I had to do is my community service. I paid my court costs, fines, and community service.
But you were not placed on probation for any period of time?
Not that I'm aware of, no, sir. I met with him. I met with the guy twice to pay my charges, and the second time to turn in my community service.
And that's related to the arrest in 2017?
Yeah, I don't know.
Yeah, 2017.
Just wondering if that falls within the 5 years.
The arrest date was 1/19 of 17. Incident date 1/19/17. So we're just past the 5 year. Oh, we are past it. It's 1/19/17.
Right.
I have 5/22/17.
That would be the 5 years.
Look at the bottom of this page.
This one? That's 1999.
Well, while they're looking that up, I had a little more simple question for you. On your application, and you may have updated it, where it has, have you read the Metropolitan Ordinance, Wrecker and Towing Services, and the Commission rules related to wrecker services? You put no. Have you since read those?
Yes, ma'am.
Okay.
But I guess that's May, it's not June, so it counts. Both the guilty plea.
In making his application, if I may, Mr. Chairman, from our review, nothing would specifically disqualify him in terms of time periods and that sort of thing. As you can see from his criminal record, he did have some other issues in the late 90s. However, as you go forward in terms of your timing, based on our review, we did not see that it would be a violation. I think the greater challenge was the fact that the issue of, again, the battery, it was, just so you know, your record does not indicate battery at all. What it indicates that you pled guilty to assault with physical contact, and that happened on July the 22nd in 2017. You were sentenced to 1129. It was suspended for time served. They waived the fine, and then you were told to have no contact with, I assume, the complainant. Does that?
Yes, sir.
Does that all sound right?
Yes, sir.
Just
So
a
the
matter
rule
of
says-
correction for the record, that's May.
May 22nd, not July, it's May
Yeah.
22nd.
May
May,
22nd.
not
just for a
July.
matter of,
You said July.
for the record.
I'm sorry, May 22nd.
So the rule
month
says an
matters.
applicant shall be disqualified if the applicant has been convicted, pled guilty, placed on probation or parole, pleaded no low contendere, been released from incarceration within a period of 5 years prior to the date of the application for any of the following offenses under the laws of Tennessee or any other state of the United States. And those are homicide, rape, aggravated assault, kidnapping, robbery, burglary, or auto theft, child sexual abuse, any sex-related offense, leaving the scene of an accident, criminal solicitation, or criminal attempt to commit any of the above, perjury or false swearing, in making any statement under oath in connection with the application for a driver's permit, and K, the felony possession, sale, distribution of narcotic drugs or controlled substances.
It says assault with physical contact's not on that list.
I mean, aggravated assault is.
I don't have an aggravated assault.
Yeah, it's assault with physical contact.
So that's,
How many years? 5 or something?
5 from date of application.
Mr. Brown, what was the you pled guilty in 1997 to facilitating first-degree murder?
Yes, sir. I witnessed a murder and refused to testify.
Are there any other questions for Mr. Brown?
I have a quick question for legal. So as it is your understanding, he is eligible and not disqualified because of the...
If the May date is correct, he would be disqualified from the date he pled guilty, it appears, unless he was subsequently placed on parole or incarcerated.
so,
Were you subsequently incarcerated? Were you incarcerated at all after?
No, sir, it was not.
2017?
And even if this did apply, he could possibly, at the next hearing, reapply and be past that statute.
well, it's technically been 5 years, right?
Yeah.
Does revenue records
As
allow
of today.
reapplication if they're denied?
No, if you deny, it's 90 days for a record driver.
So you can defer.
That's what I meant. By deferring it to the next meeting, he would technically be allowed outside of the statute.
It sounds like he's within the.
Yeah, he is not, he does, the assault is not a automatic disqualifier, had it been
Okay.
aggravated assault.
Okay.
So you can take action either way today. I
Yeah,
think the issue would have been on his previous charge. Had he been incarcerated for the full extent, that would be a problem. It indicates he was at 30%, which would have placed it beyond the 5-year limit of being removed from probation and/or parole or incarceration.
I'd have followed even further. It's just I'm a truck driver, so, I mean, it's hard to take that time off work and provide for my family at the same time.
Make sure he wasn't still on probation.
We were just trying to determine if we were in the time frame for something that's already set in place for us to even consider the application.
Yeah, I looked at it before I'd done it. You know, that's why I had the battery down on there, but I knew I qualified.
And I think at TowPro, is that correct?
Yes,
TowPro
ma'am.
is the company you'll be working for, and is there a representative of TowPro?
Yeah, I've met Mr. Brown a handful of times.
Would you please state your name? I know
I'm
who
David
you are.
with TowPro, David Williams with TowPro. Met Mark four or five times. He's been completely upfront with everything on his record, including the 97 charge. He has his Twix card. He served our country years ago. We feel pretty confident that he's going to be a fantastic employee. Just waiting on your approval.
Is that 2 years of experience working with you all as a
Nope.
helper? No?
No. He has rigging experience with Louisiana
Crane.
And over-the-road experience. So
I done heavy haul for Kodiak Heavy Haul Division.
Mm-hmm.
They're out of Kansas City, and I done heavy haul for Heisinger Construction, which is all large construction equipment.
he's been hauling
Army tanks.
140,000 pounds, things like that. He's pretty well qualified, just waiting on the approval.
Did you move to Middle Tennessee recently, or have you been here for a while?
What's that?
Did you move to Middle Tennessee recently?
No, I've been here for a while. I had a Wisconsin driver's license because my sister's disabled, and I take care of her, and I got a house for her.
All right, well, thank you, Mr. Brown. Would anyone like to make a motion regarding Mr. Brown's application?
Could make a motion to approve.
Second.
All those in favor?
Aye.
Any opposed? Motion passes. Thank you. Next item on our agenda is under horse-drawn carriages. We have the driver application for Landon Millett.
Landon Robert Millett's application was withdrawn by the company earlier this morning.
Thank you, Mr. Fields. Next item is under taxi cabs. We have a driver application for Bola Imad Tadris.
Mr. Tadris has learned that he's going to have to return to his home country for a family emergency. Asked that this be deferred. Oh, he's not. The company said he would be present. They are not prepared to, they don't have a position for you. They were supposed to call you. So obviously he can speak for himself.
I have get hired today for a new company for the Music City. At the violation.
Are you Mr. Tadris?
Yes, it's me.
And you're applying for a driver application with a new company now?
Yes.
Do you want to forward that to Mr. Fields?
Yeah, that would what we would need. So the company was not going to accept it. It was my impression he wanted to continue to work for that company when he got back. Obviously, there's something going on I was not made aware of. So this would be in order if American Music City Checker wants to hire him, he would be eligible after you have your hearing if you choose to give him a permit.
Is his application otherwise in order?
In making his application, he did fail to disclose a 2018 aggravated assault arrest. He only listed one arrest in his application. He was arrested on September the 16th in 2018 for aggravated assault. He was placed on, it was a misdemeanor. He was placed on probation in 2019. I'm sorry, he was convicted of assault, bodily injury, and placed on probation. Not unlike our previous hearing, except there was no probation listed on the other. But again, this is not aggravated assault, it's assault with a bodily injury, but he failed to disclose.
Is this also assault, aggravated deadly weapon?
The initial charge was, and it would have been pled down to assault with bodily injury, according to the TBI record.
Why didn't you disclose that on your application, Mr. Tadros?
It was very simple and long time ago. I was right, like for the first, I was think it's kind of, if I have any tickets or anything like that.
All right, well, Mr. Tadros, on the application, it says in bold, it says to list each violation of a federal, state, or local law with which you have ever been charged or arrested, whether convicted or not, and include expungements. So it's not limited to driver-related arrests. What were the circumstances of the charge for us and your conviction of assault with bodily injury?
Why was?
What were the circumstances?
What happened?
What happened?
What's happened was, or
what happened?
what happened was friends. We just play around, and then the police come and give us charge for both sides.
You were in a fight with a friend?
Mm-hmm.
You said the friend was charged as well?
I think so. He was with me in the court at this time. And that was a long time ago. It was in some mistake.
So is it your intent not to go home at this point, that you are going to stay and drive for, what's the new company?
Billy?
What was the company that you submitted?
American Music City,
American
Checker
Music
Cab.
City? So is it your intent that you're not going home, you're going to stay here and drive for American Music
Yes.
City?
I was waiting for ThinkApp to, he's protect me to give me a number, but he called me today and then he said, I don't have any numbers for you. He was give me, stay in the waiting list, and today he say, I don't have any numbers for you. So I have to go look for another company, and then I'm getting hired for American Music City.
I guess, can you give us the details on the property damage, the crash report that you did list? What happened?
Last time,
Yeah, in
It's-
2020?
and the crash damage, what is the, in 2020, what's date? What the date?
No, it says it was, I'm sorry, March 21st, 2020. It's the one you did list on your report.
Yeah.
You had an accident, can you explain the accident?
I was having a deer accident. I think this is the last one I have. 2019.
2020?
Mm-hmm.
Right, we were just wondering
I
what
was
the
going.
details.
I was going home, and then I saw deer, and then I had a deer.
Were you charged in connection with that car accident?
What's that?
Were you charged or arrested in connection with that car accident?
No.
On the, going back to the incident that happened on September 16th, 2018, what was the weapon that you were found to have used in connection with the assault?
It was a steak weapon,
It was a what?
like a steak, a plastic. That was a long time, and it was a mistake, and then I wouldn't know if it's coming up for in the application, so I can write it down from the first time.
Thank you, Mr. Tadros. Would anyone like to make a motion regarding Mr. Tadros's application?
Maybe one more clarification question. Does the application need to state where he's going to be employed? I know he has a new potential employer.
What he did, he actually brought in the document. It should have been transferred on. He brought the original document is attached to the application that was shared with you, which is this company affiliation.
Now it's,
When he would reapply, what you're seeing is his first application. What he would do, when he failed to disclose, he would be asked to be reapplied, and so the second one should have had that on.
so it should be American, what'd you say, it's American Taxi?
American Music City.
American Music City. So- That I remember. But I think we can approve on the condition of just working there, is that correct?
Correct.
Okay. So that's an option, if that's a concern. Well, I would make a motion that we approve his application to work specifically for American Music City / Checkers.
Second.
All those in favor?
Aye.
Motion passes. Thank you, Mr. Tadros. We also have a driver application under other passenger vehicles for hire for LaCory Moore. Mr. Fields.
In making his application, Mr. Moore disclosed a speeding charge in 2022. He failed to list any arrests, which are a lot of driving, but that's a little different. But he had charges in 2016, again, suspended license, had, again, a public intoxication in 2013, a criminal trespass in 2014, misdemeanor in 27, disorderly conduct, failed to disclose any of those.
It looks like there's several going all the way back to 2006 on the, according to the TBI report. Good afternoon, Mr. Moore.
Good afternoon.
Mr. Moore, why didn't you disclose your arrest and charge and conviction history on your application?
I was under the assumption, since I was doing a background check with the TBI, that they would print all of that for them, because I don't remember. It's, as you see, it's a lot. I don't remember the dates and times and whether it was dismissed, null. I don't, I needed the paperwork for that. So I have it. Here we are.
Can I ask you, what made you think the TBI was gonna send this over to them? Did they tell you they were gonna?
Doing a background check, they print out every time you do a background check and give every party involved a copy of it.
How many traffic violations do you have?
I don't know. I haven't counted them.
It'll take a while.
Yep.
as you can see from the road, the last, in terms of driving, the last history we have would have been 2019, which would have been would have been the 2020 in March where he was speeding, going 43 and a 20. Prior to that had been 2019, and then 2018, and back to 2015. So there are many, but they are over a period of time that dates back to 2004.
Dates back to high school. So most of these I was a teenager, young 20s.
Yeah, we just want you to understand, the only reason that you're here before us and we're reviewing this, there's nothing that I can see that would keep your application from going through. Only reason you're here is because on this page right here, it says that you are supposed to disclose everything. The one that you filled out right there.
Mm-hmm.
This little part, I guess, you know, some of us are good test takers, some are not. I'm guilty of that myself. But the only reason you're here is because you did not list the information that you assumed the TBI would share with Mr. Fields in his office. There's nothing disqualifying you other than the fact that you didn't put it on your application.
And the company you would be working for is Three Guys in Bow Ties?
Well, 3 guys in bow ties and Uber.
And what?
Uber Black.
Uber Black.
Say that?
I didn't have Uber Black. It's on
Okay.
And Mr. Carr is correct. The issue was you failed to disclose. You asked, and anytime you fail to disclose something of this nature, then you'd like to review it.
There seem to be several entries on here where you didn't pay your fine. Is that true?
It could be, couldn't be, I couldn't tell you. I've paid fines, there might be fines I haven't paid.
So you're saying that some may be outstanding?
Not to my knowledge, I have current driver's license, I don't pay
You
any.
think you've paid them all off?
Yeah, I think I paid them all off.
Because you've got a payment plan for one of them.
Yeah, my license was quite a bit. It was like $8,000 to get back, so I had to do a payment plan.
It does say reinstated.
Hmm?
Yeah, this does quite a few reinstatements on here where the tickets were paid.
And you've never been charged with a DUI?
No.
That's what it says. So when was your last crash? I'm trying to figure it out here. There's a lot of entries.
My last crash. I couldn't tell you. Gallatin, maybe?
And you were also
2000.
driving
2014?
while your license was suspended.
Yeah, 2014.
It appears from the record that his last crash would have been on December the 17th, 2015. His license would have been suspended and then, according to this, reinstated on September the 10th in 2018. That also appears, again, matching records that follow on his payments back to the state. And then had a crash. It could have actually been back to the original crash. So so it would appear 2015 would have been the last crash that he was charged in. Again, the issue would have been the fact they just failed to, reveal.
Assume the company, three guys in bow ties, is aware of your speaking record. And others, okay.
Would anyone like to make a motion regarding Mr. Moore's application?
I make a motion to approve.
I'll second.
All those in favor?
Aye.
Any nays? Mr. Rogers?
Why don't you show me as an abstention?
All right. Motion passes.
All right, thank you guys. What I do now?
You can, if you have any questions, you can ask Mr. Fields.
7:30 in the morning.
All right, next on our agenda, we have been asked to review a request to change the name of Mustafa Limo to Black's Ride. Mr. Fields?
The application was made to make the change. Any change to the certificates as issued by the commission have to be approved by the commission. Everything is in order. Staff recommends approval.
Make a motion to approve.
Second.
All those in favor? Motion passes. We also have several other passenger vehicle for hire company applications. Mr. Fields?
Only alteration is Tasty Tour has been withdrawn, determined that their vehicle is too heavy to be licensed under this section. So we would ask that be removed. They asked to withdraw. Dollywood Transportation, Elite Smooth Ride Limousine, Halter's Limo, Coovley Transportation, Nash Transportation LLC, Pumride Share LLC, Safe Driving Plus, Sewer Love Limousines LLC. They filed the applications. Everything appears to be in order. And we would suggest approval.
You said share?
Sorry, Safe.
Oh, okay.
Safe Driving Plus.
Oh, no, Ride Share.
Pum. Yeah, Pumride Share. I'm assuming he is he would call himself a ride share, which is a different term, so it's really just the limousine, the OPVH for us.
It's not the problem. Very well maybe, but it's not our field to
Not under our jurisdiction.
Yes.
Everything is in order? No
Everything's
reason?
in order.
I'd like to make a motion to approve if everything is in order. I'd like to make a motion to approve Dollywood Transportation, Elite Smooth Ride Limo, Halter's Limo, Coovley Transportation, Nas Transport LLC, Pumride Share LLC, Safe Drive Plus, Sure Love Limos LLC.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next item is under pedal vehicles. We've been asked to review an address change for Nashville Bar Bike to 904 Arbor Creekway, Nashville 37217, and also to add Zoe Gray as a manager. Mr. Fields?
As in the last one, anytime there's a change to the certificates, information has to be approved by the commission. Everything is in order. They file the appropriate paperwork. Staff recommends approval.
I make a motion to approve Nashville Bar Bikes address change as well as manager change.
Second?
All those in favor? Motion passes. Thank you. We also have on the agenda today, under entertainment transportation, a continuation of our deliberations following the closure of last month's public hearing regarding adoption of rules related to the operation of ET companies and vehicles. Mr. Fields.
At your last meeting, there were questions and comments and thoughts about rules. You asked staff to go back and review based on your comments and your thoughts as well as other information gathered, and so we've gone back. We captured what you asked us to study. There were a couple of things we also brought back for you to consider. So we have given you some recommended rules out of the department. I think it would probably make the simplest thing to do is, again, we do have a PowerPoint on that would help, just would show you what we're actually talking about. You also have copies, hard copies that we provided on the desk today, so you would have those rules that you passed on May the 26th, and the NDOT recommended changes are in red.
You know, I had a question, Mr. Fields, and I should have raised it even at last month's meeting, and it's under the insurance requirements. There seems to be a distinction, and I'm not sure why, between a entertainment vehicle and then a entertainment vehicle that happens to be a truck or tractor pulling a trailer.
On the uninsured issue, both should be one. We would recommend one instead of two on both issues. It appears that the ink didn't come out on one of them, and I apologize for that. But both of those should have been shown as in red.
And
our reasoning after the meeting, we did some additional research. We spoke to Metropolitan, our Metropolitan Government Insurance Advisor. He was satisfied that $1 million would be very adequate for the uninsured motorist if you chose to do that. He too may actually be unattainable in many cases. Not, you know, it could be appropriate from a standpoint, but it might be actually unattainable and not available for maybe any of the vehicles.
What was that?
One apparently is.
Well, my first question is, why is there a distinction between entertainment vehicles and then those entertainment vehicles that are tractors or trucks pulling a trailer or a wagon? Because they're under 030C, there's this general rule that we passed that ETs need to have $3 million known as combined single limit insurance coverage for medium and large buses of 16 persons or more capacity, and then $2 million of single limit for those with fewer than 16. And then we have I guess under D, there's no passenger reference. It just says holders of who are operating tractors and trucks pulling wagons or trailers also ought to maintain commercial auto liability insurance, and then it goes on to say $2 million per incident known as combined single limit insurance coverage. I'm just wondering, is D necessary? Wouldn't they be covered under C, either under 1 or 2, depending on how many passengers they hold?
You could certainly cover. D was if it's going to be, the difference was, if the tractor originally should have stayed at $2 million for the general liability, it should have gone to $1 million for uninsured motorists. It's just as the other one. You certainly could delete D and cover everything under C if you chose to do that. The initial idea on tractors and conversations with insurance, Metro Insurance, is the tractor was moving slower. It was not interstate worthy and so forth, so it would not require as much liability insurance from the standpoint of the slowness of the vehicle. So $2 million would have been adequate based on Metro, area manager of insurance for Metro, as opposed to $3 million for the entertainment buses, or $2 million for the lower capacity buses that were carrying 16 or fewer.
Did you talk about the fact in that conversation that the tractors can't go slow under the terms of the rules?
Slow as in they have to keep up with the speed of traffic.
That's correct.
Correct.
So
now, what they were talking about, they couldn't go 55 miles an hour on the interstate. I think that's what he was talking about.
20 or 30 miles an hour.
25, 30. And I apologize, he is out of the office today and was unable to be with us, Mr. Cobb.
And I think part of the distinction, just speaking from a little bit of the transportation part, is that in normal insurance, the regulations, you have to insure tractor and trailer because they're separate units and not one whole unit. It's, for example, a 26-foot box truck is considered a trailer. I mean, a one unit. Right. But a semi, you would insure the trailer and the semi itself because they're separate units.
All right, and I see that NDOT was recommending that we lower the uninsured, underinsured motorist coverage for all types of ETs to $1 million.
Correct. As I said earlier, that's based on availability.
And if you recall, when we rounded up from $1.5 million because they said they couldn't get it for $1.5 million. The $500,000 increment didn't exist at the time.
Well, apparently when they went back and then we did some checking, it appears they can't get to either. Mm-hmm. In most cases. There may be some, but in most cases they cannot. According to the agents who have contacted us, and there have been multiple ones. And then to verify, we went to Metro Insurance and they said $1 million's adequate.
Yeah. I don't think we were trying to be punitive with the $2 million. It was, we responded to the $500,000 increment wasn't available, and
but,
we went to $2 million.
But we're not recommending a change in the insurance, the liability coverage, only in the uninsured.
So that in 030C3, you're saying that should have been lowered to 1 as well? Did I understand that correctly? Okay.
Yeah. We recommend all sections that discuss uninsured would go to 1 million. The others would stay as stated, 3 million, 2 million, and 2 million.
Okay. And I think that first D number that's in red would actually stay at 2.
2, it would.
Correct.
Yeah, that one was corrected. I think it was just the 3 that didn't have it. And this may not be an issue. It's like where they have, state metropolitan government as an additional insured. Does that need to say Nashville or Metropolitan Government of Nashville, Davidson County, or is it understood that because it's a document of Nashville, Davidson County?
That's probably okay.
Okay, all right. Just checking.
We also recommend a change to sections G. Those are the two in 030. We recommend that no vehicle be able to operate unless they are in full compliance with insurance at all times.
So in 030, if we omitted or removed D, we would replace it or add on to.
Well, I'm fine leaving it, given your explanation as to why. Okay. I was just questioning whether it could be more efficiently addressed, but I understand the distinction you're making.
I would also share with the commission, again, we're not making this recommendation. There has been many of the, and it's in information that you've received, there's been questions about the alcoholic beverage insurance, about their availability. Again, we do with the pedal carriages. Some of them have said they've talked to many carriers that did not, won't provide it. I can't report, again, the pedal carriages have to do that, and Metro Insurance recommended it. So that's the only thing I can say along those lines. And it was already approved last month, so you don't have to deal with it unless you want to revisit it. So we'd recommend approval of those issues.
So we're just talking about the 030 right now? Okay. But I guess we'll need to go back and do 010 as well. Is there some red in that?
We can certainly go back to B, and I mean, if you would like.
Anything in red is different than
correct.
what we voted on.
So it's
need to.
correct. It was actually taken out. We actually placed it later in our presentation
that's fine.
to
I just wanna make sure we don't
make
forget
it
it.
fit,
Okay.
even though we'd be referring back earlier in the minutes or in
sorry.
the.
I wasn't looking at your PowerPoint. Sorry.
No, we're okay.
All right. So this is just 030, C3, and D.
To the fees that were recommended for the sightseeing vehicles?
That would actually come later. We wanted to talk about the rule on sightseeing, and then assuming that you agreed with that, then we would come back to that. In other words, we didn't want you to approve fees before you actually approve the idea of sightseeing.
I'm just thinking about the Old Town Trolley and the Gray Line bus tours. At least from what I've seen, like a double-decker bus can carry 70 or 80 people or more, so they sell more tickets, have an ability to maybe make more money. And I'm just wondering why we set their fees lower.
What we are going to be recommending at that particular point is the idea that it actually takes less enforcement for those particular vehicles. Okay. There is no history of any complaints, any violations or anything else. We believe it will take fewer staff. We're estimating that it would take probably a half of an inspector. We think that will be about $35,000, maybe at the upper end $40,000 to fully equip half of an inspector. And that the fees we're recommending, assuming depending on what you approve, then would fund that particular position.
Yeah, the fees that are collected have to match an estimated cost.
Right now, we need to vote on the 030 if discussion is finished.
Yeah, so you want to lower it at 3 million on the coverage.
Here.
Yeah. I'm just trying to follow the PowerPoint now.
No, I think it would be fine to lower the uninsured amount. I've read a lot of the material that you forwarded to us, Mr. Fields, and noted one particular person who was rather sarcastic in his email to I believe it was well, I just wanted to state for the record that we are under no circumstances considering these limits casually. We are being very deliberate about them and choosing to raise them on purpose because we believe they're necessary. Would anyone like to make a motion regarding the recommended changes from NDOT regarding 030? And with the caveat that they are not recommending lowering the combined single limit liability insurance coverage, so it would remain at $2 million.
Is that in, are you speaking about in 3? In 030?
Yes.
In section 3?
Yeah, it was an inadvertent change. Again, what we're asking you to do is to approve a reduction of $1 million, as well as require insurance upon entering service. Insurance has to be available. There's also a motion later in the meeting that we'll suggest you make that has timetable for when everything, the payments and insurance has to be in place.
Are they voting on that last one too?
It'd be on those two. The issue would be those two. It'd be G, replacement for G, and changes to
C3 and D.
to C, change to D, and then a replacement of G with a new verbiage. That would be what would be appropriate for a motion.
3 instead of starting with 4.
Well, I will make a motion that we accept the recommended changes in section 030C3 for the uninsured, underinsured motorists from $2 million to $1 million in each category, as well as in D for the uninsured, as well as replacing the language previously approved in G to the recommended entertainment transportation vehicles will not operate unless in compliance with insurance requirements mandated by this rule section.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Right, so there are other recommended changes since our last month's meeting. In particular, we passed a lot of rules last month. One main area that we left open was coming up with a good definition for enclosed vehicle versus unenclosed vehicle, and taking special consideration of a subcategory of entertainment vehicle that would meet the definition of a sightseeing or charter tour type vehicle. And so NDOT's made several recommendations in that regard to us, presented those changes to us a few days prior to today. And 010, under certificates of public convenience and necessity, NDOT's recommended a new section B. Have the commissioners had a chance to review that change? Essentially, when it comes to deciding whether there's a public need or that it would be a separate question with regard to sightseeing versus entertainment vehicles, it wouldn't be deemed sightseeing or charter tour. Is that correct, Mr. Fields?
Yes, we spent a lot of time in multiple levels trying to make a determination of what made sense. We considered an additional ordinance that would actually describe what a seated sightseeing tour might be. It was determined that from a practical standpoint it would make sense and would be appropriate to carve a separate section out under the Entertainment Transportation Code, since though we believe those types of vehicles do meet the definition of entertainment transportation as described in by the state of Tennessee. Ms. Gastonis is certainly more adequate, but in terms of this language, it was what legal had suggested.
We're only doing it in the regulations, not in the
Correct,
code.
correct.
Okay. You said code. I was
No, I was
confused
just
by
saying
that.
it would.
The only thing that we did not recommend was subsection C, transportation furnished by a sightseeing or charter tour vehicle is a service rendered to the public that occurs to and from points of historic, scenic, cultural, or aesthetic interest. Just from a purely legal perspective, that's superfluous. The distinction that's important from this commission's role and mission is public safety. And the distinctions that make a difference from a public safety perspective are being seated and serving or allowing people to consume alcohol. So if you assume that people are safer when they are seated and not consuming alcohol, then it makes sense from a safety perspective to allow the vehicles that meet that definition to be unenclosed as opposed to those that don't, which have to be enclosed.
And this is the NDOT recommendation in 040A is just to establish what is an enclosed vehicle.
There was already a definition of enclosed vehicle, but I think this might have some differences from the original 040. Is that right?
I think
Correct.
we did not vote on
You did not take
last
action.
didn't.
You did not take action on 040 last month. We reserved the section. We actually reverted to to language that the Metropolitan Council passed in an ordinance last year.
Yeah, it was skipped completely.
Yeah.
I'm sorry, I didn't quite understand. This is the exact language that was in the ordinance?
From the ordinance, and I think it was 2021-911.
It may have been pre-amendment language.
There was more amendments later. This is the original language. The language we recommended was a little more, was modeled more after the second ordinance. Based on your conversations, we came back with this, trying to describe what you described at the last meeting.
And we would be just voting on to adopt this definition.
Of
Well,
enclosed.
and also,
B, C, and D.
Well, yeah, B, C, and D as well, but as it pertains to enclosed vehicle,
yes, you'd just be voting to adopt the definition. Or section A, if you want to characterize it that way.
I have a question. In 40A, the NDOT recommended language, it says that it may contain windows capable of being opened, but all windows shall be fully raised while the vehicle is in operation and any passenger is in possession of an open container. So the windows need to be open.
And we use the language that the council has.
Closed.
Closed is what the council intended with that particular
Okay,
language.
because it's, I think about raising a window rather, but I guess on a bus maybe
They are
raised,
raised.
the window's
I was thinking of
closed.
school bus
Yeah,
windows, you
okay.
raise them, but I guess some other ones you do. I think we changed that to closed at some point. But not in the original 0911 version.
That's a good clarification.
So we should change that
So
to
it needs
fully
to be
closed.
changed from fully raised to fully closed?
If the commission's intent is for them
Yeah,
to
that's up
be
to you.
closed, it might make sense to make it clear.
Mhm.
It would be your amendment, how you want the rule to read. But raised, our belief, that means closed, based on the original orders, but closed means closed, so that certainly would be fine.
Yeah.
No questioning.
I Although, Billy, I will say that, I'm sorry, I'm just noticing this, but I think possibly if we adopt D, that last provision of A is not really needed, where it begins. May contain, that while the vehicle is in operation and any passenger is in possession of an open container. Because it just says really entertainment transportation vehicles are required, D says, are required to be fully enclosed with the exception of those meeting the definition of the subcategory, seated sightseeing or charter tour vehicle, I think that should say. Seated sightseeing or charter tour vehicles are exempt from the requirement applicable to other types of entertainment transportation vehicles that the vehicles be required to be enclosed.
Correct.
So I think if you meet the definition of, or rather, if you meet the definition of an ET, but you don't meet the definition of the subcategory seated sightseeing vehicle or charter tour vehicle, then you are required to be enclosed at all times, period. So it doesn't really matter whether you have a passenger in possession of an open container at that moment, although one of the distinguishing things in the definition between a seated sightseeing vehicle and a regular ET would be that alcohol is not served on the former and is served on the latter. Or not, maybe
Vice
served and
versa.
maybe consumed. Yeah, could be BYOB. So I just think you could take out and any passenger is in possession of an open container. That's what I'm saying. Yeah.
N-O-4-O-A, you mean?
Yes. I don't think that distinction makes that much sense in the context of having D.
That makes sense. So the period would be after operation, and then
Yes.
delete and any passenger is in possession of an open container.
And then you were suggesting on C that we take out from points of historic scenic, is that correct?
I was actually, I mean, I'm not necessarily, NDOT, I guess, is recommending C. I'm just saying that language did not come from legal, and to me, it's not related to the safety distinction.
Teresa, where in the proposed rules, ET rules, is the definition of sightseeing?
That is in B, where the vehicle consistently operates on one or more fixed routes, where all passengers are required to remain seated at all times while the vehicle is in operation, and where alcohol is never permitted or served on the vehicle. The vehicle may be classified as a seated sightseeing or charter tour vehicle. So that definition will come back into play with regard to 010 also, but Billy's doing it in a more logical order.
Just stick to the numbers, man.
Don't confuse us. I think in one of our letters we received, somebody had mentioned that there is a state law that allows, even though they don't encourage it, they don't advertise it. Let me see if I can find it. Let me look it up for you.
Are you referring to the letter that allows alcohol on? There are certainly state laws that are different. However, from it's our understanding, obviously, if they want to be licensed in this category, you have the authority to limit what they're allowed to do, and if they choose to be licensed locally.
Yeah, so that is a good point. 5510-416 was indeed a state law authority that was cited by the Metropolitan Council in kind of the discussions leading up to BL, I can't remember the numbers now, 2021 9/11 and 2022 1089?
Yes, those two.
I couldn't remember what the years that applied to each were. So I know that was in discussion, and it's possible it's even referenced in the like whereases or recitals, but I think that language is more captured in chapter 724, which is like the beer board chapter of the code, which is where kind of they ended up putting all the alcohol stuff in. And then when they came back with 1089, I think, had the beer board stuff already been passed by then? Mm-hmm. And so they may have just kind of left that to the beer board. So they may not have invoked 5510-416 as much at that point. But 5510-416, well, I can just pull it up and read it to you. But it basically says that the legislative body of a municipality has the authority to decide whether you can have open containers of alcohol in vehicles while they're in operation. So I'll look that up to confirm my memory.
But that would kind of muddy the distinction of the sightseeing vehicle if...
So the definition is for two purposes only. One is for the purpose of determining which vehicles get to be closed versus unenclosed, not which vehicles get to operate. The other distinction that it's for is going back to 010 that Billy's going to talk about subsequently, which has to do with making different determinations or findings of what the public necessity and convenience is. The thought was that those two types of vehicles were distinct enough that maybe they would serve different public needs, and so making separate findings for them might make sense.
Along with alcohol as well as fees.
Yeah, so you can have alcohol at 55, I forgot the next slide. 5510-416, you can have alcohol. It's not like the police won't arrest you for having alcohol in the vehicle as a violation of state law, but you won't meet the definition of a seated sightseeing vehicle if you have it.
Correct.
Right.
So
and that
none
would
of those will need a beer license, obviously.
Right.
Okay. Well, all of the others need a beer license.
If they're actually going to serve it as opposed to BYOB.
Oh, okay.
And having that beer license would take them out of the distinction of sightseeing, which would also change their fees.
I would say that anyone who allows, even if you don't have the license, but you allow your customers to bring beer on, to drink BYOB, then you're still not a seated sightseeing vehicle.
And you're an entertainment vehicle at that point.
Well, they're all entertainment vehicles, but this is like a subcategory of entertainment vehicles, because we're trying to go off the state definition of entertainment vehicle, which is a little broader.
I guess that's where I'm confused as I read this person's letter. It says, we do not allow liquor, clients in Tennessee, under Tennessee state law, are allowed to possess, consume, and/or transport any type of alcoholic beverage in any type of vehicle. So I think that's what we were talking about. It kind of muddies, you know.
If they let them do that on their vehicle, then they are not a seated sightseeing
Okay.
vehicle.
And
So
could
they
not be
do have the
certified.
right to say, no, you can't bring
Yes.
the alcohol on here.
I mean,
Our
sure, it's a
permit
contract
determines.
when you
Okay.
have customers come onto your vehicle. you
Okay.
know,
Or at
you
least
can
the
tell them what to
distinction
do.
of saying, you can allow them to come over, but
you'll have to change
your
your
fees will now
status.
change and your status will now change.
Correct.
Okay, I think that's, I just wanted to make sure that, because if we're gonna enforce those on others, that
Yeah, no, I mean,
there's not a
like,
loophole.
you can, in basically a contract, you know, when you do business with somebody, you know, you can require additional requirements of them that go above and beyond what the law requires of them. And if they agree to
So
that
some-
and you all make a deal, then they're bound by that contract.
Okay, again, I just want to make sure they're not going to come stating this law from the state to say, yes, we can bring it. I just want to make sure the companies are protected and that others aren't using that as a loophole too.
I think y'all are making pretty good legislative history here that that's not what was intended. but-
Could you
Okay.
repeat that, because I can't hear.
Oh.
Okay, sorry. So what I was saying is, Commissioner Warren was talking about, hang on, let me see if I can actually find the
sorry.
provision, just to be really thorough. Almost have my TCA open.
While she's looking at that, it was the letter that we received from, sorry, I gotta get my glasses on. Glammy's Party Liners. And then, I think it's, yeah, the second to last paragraph where she references a state law that does allow people to consume alcohol. And I was just trying to make sure that they do have the right, if they want to be known as a sightseeing tour and be able to be unenclosed and not have the same restrictions, that they are allowed to say, no, you can't bring that on here, that they can go against that state law,
You're not
and that
going
others can't
against
use
the
it.
state law, you're just requiring more than the
Right,
state
well,
law
that's what I
does.
meant, yeah.
In other words, you can require more, you can't require less.
Correct.
Gotcha, okay.
Well, A is really for the driver, which is different. So I think C is the section in question, and C says a section shall not be construed to prohibit any municipality by ordinance or any county by resolution from prohibiting the passengers in a motor vehicle from consuming or possessing an alcoholic beverage or beer in an open container during the operation of the vehicle by its driver, or be construed to limit the penalties authorized by law for a violation of the ordinance or resolution. So like I said, I think that is part of what they were intending to do when they first enacted BL 2021-911, but as 1089 kind of changed the ordinance, and it was more, you know, the beer board does what the beer board does and the TLC does what the TLC does, you know, I think that fell out of it a little bit, but so it's clear that from the state law, it's absolutely clear that drivers cannot ever have an open container.
Right.
But it doesn't say that passengers can't. But then, the section C says that a municipality can, through its legislative body, adopt something more strict, saying that even the passengers can't have it. But effectively, our council did not do that, but can we ask the companies with the certificate holders to require their customers to agree to the term that they not bring alcohol on board? Sure they can.
Okay. Thank you. That's very thorough, thank you.
And only when considering the designation of seated sites of tour.
Right, well, it comes in play, the seated sightseeing definition comes into play in two contexts. One is whether the vehicle gets to be enclosed or unenclosed. If you're not a seated sightseeing vehicle, then you have to be enclosed. If you are a seated sightseeing vehicle, which means no alcohol, everybody's sitting down, that one does not have to be fully enclosed. That can have an open roof or whatever. And then the other distinction is in the finding of public necessity and convenience.
Okay. If nobody has any more discussion on 040, I'd like to make a motion.
Teresa, what about the NDOT recommendation that a definition of a sightseeing vehicle has to consistently operate on one or more fixed routes?
I think that's less relevant to the safety, but maybe it's somewhat relevant to the safety, I don't know.
I think what it does, it just basically is another delineation of the kinds of vehicles they are. Their tours are they're seated, they're alcohol-less, they are moving you would be allowing them in a much wider area than we will eventually be allowing the entertainment. Because they would be going to Curtiswood Lane, for instance, see the Governor's Mansion, or they might be going to Traveler's Rest,
No, I'm not sure they'll meet the definition of an entertainment vehicle, period, if they're going that far afield under the state law. I mean, let me see if I can pull up. Let me go to Tennessee.gov.
But they don't all go that far either.
The state law says something about only driving around downtown. And we don't have authority to regulate them if they don't come within the state law. Do you have the state law handy?
I do not. I'm not sure what I was thinking. I did not. That's the one thing I did not bring today.
But some of these.
They could go to the Omni and the Country Music Hall of Fame.
Right, they could go out to the Parthenon, they could go out to Cheekwood, they could.
You've got it. Spring.
They go out to Mesa
Apologies, I think it's HB 1392.
Here's a copy of it.
Oh, very good, thank you.
We tried to bring everything we could think of today.
TD is very prepared. Entertainment transportation means a motor vehicle that is designed or constructed to accommodate and transport a number of passengers for hire, the principal operation of which is confined to the area within the corporate limits of cities or counties and the suburban territory adjacent to the cities and counties. So that is broader than I was thinking, so that you could go to the Governor's Mansion or whatever.
We believe the state law allows anywhere within the metropolitan area.
Whether it is operated on a fixed route or schedule, so it can be either one, and where the passengers hire the motor vehicle, not only as a means of transportation, but also for some entertainment or social purpose. Entertainment transportation includes, but is not limited to, a wagon pulled by a tractor or other motor vehicle. Entertainment transportation does not include a limousine, sedan, shuttle, or taxi cab.
So what about, what does NDOT mean by where the vehicle consistently operates on one or more fixed routes? So I'm going to give an example and then see if it applies. So Glammy's Party Liners, take them because it seems like they're right. Maybe they're a sightseeing, maybe they're not. But if they're hired to transport a wedding party from the church to the reception, and they serve alcohol on that charter,
then they are not a seated.
They would be they would be on the entertainment, so they would not qualify if
sorry, they it's BYOB.
If there's beer, alcohol.
BYOB, they're still not a seated sightseeing vehicle.
Right. Alcohol is one of the defining.
If they don't serve alcohol, are they a sightseeing vehicle?
No. And they also have to require that people be seated at all times. And the language does say operate on a fixed route.
So is that a fixed route?
From to a wedding, to a church, to a reception or something
Yes.
like that? No, that would not be a fixed
So
route.
they don't meet the definition of, so they would, are they,
I mean, whether
do they fall at all
of these
under this?
rules and every word of all of these rules is entirely up to y'all's discretion. So if you want to change them, you
Right,
can.
I'm just trying to make sure we don't inadvertently create a problem where one doesn't exist. So I am cognizant of that.
So from a legal's perspective, like the historic, cultural aesthetic is not really, it's not really an important way for this commission, which cares about public safety, to make a distinction between two different kinds of vehicles that are otherwise similar. But like requiring that people be seated as opposed to be standing while the vehicle is moving, you know, I mean, I saw an article, a study that was done in Spain where they studied their buses and found out that more people were injured if they were standing than if they were sitting. So, you know, I mean, that's like an obvious safety conclusion that you can draw. Also with the alcohol, if people are drinking, you know, they're not going to be as careful. So you could kind of draw a safety connection there. With the fixed route, I mean, I think that's maybe a less strong safety argument. I mean, I guess, you know, if the driver knows the route really well, then they can kind of anticipate trouble along the route, and perhaps, you know, it's more anticipated by Billy and PD and his staff in terms of what that. So I can see some safety connection with having a fixed route, but I don't think it's as strong as an argument as the other two factors.
So we could take out.
If you
it
want
would just
to.
be.
Yeah.
Well, and I don't know if we should take it out in the sense that that's one wedding. That's not a fixed route. That's one church to one reception. And are they serving that church and that reception hall every time? Almost unlikely.
So also, you know, if their purpose is transportation, they are not an ET. If the purpose is to get people from point A to point B, they are not an ET. They're only an ET under the state definition that TD supplied and that I read to you all, if there is an entertainment or social purpose that is not just a purely transportation purpose. So if the bus is being hired for transportation purposes, then it is not an ET. But if it's like a party vehicle or, you know, really even a tour, I think, can be entertainment. You know, if there's some kind of, like you may start and stop at the same spot, for example. You're not trying to get from point A to point B. You are just trying to have a party while in motion, or whatever.
Or be entertained.
Yeah.
What if they do that sometimes?
Right.
You're a bus that doesn't discriminate, right? So like we had letters that, you know, Mr. Fields asked some tractors to help pull people. Well, they're normally for partying. You look at these guys' website and they've got a bachelorette party package, a bachelor party package. They've also got a brewery tour. And
So if you do it sometimes, I think you're going to have the certificate.
And that's what we believe the threshold is pretty simple. If you're going to be doing entertainment transportation, if it's a bus that's primarily entertaining, it's a party, it's a situation, you know, you can carry 40 people, but you don't have 40, I mean, you have adequate seats, but it's not like a bus that you get on and go from here to Toledo.
What about the brewery tour that says, okay, we're going to go to these 4 breweries, and this bus is going to take you from point A to B to C to D and then back to A?
That's not going to come in under the state definition unless all of those breweries are within Davidson County, which they may be. I guess there are a lot of breweries in Davidson County.
But if there's entertainment, and if there's beer and alcohol being served on that, then it would qualify under ET. If all they're doing is providing transportation and nothing else, then that's a different, that'd be something different completely.
Okay.
The same, which is what we think in sightseeing. We think sightseeing is different because you're seated, there is no alcohol, you're going on fixed routes. And
there is entertainment, so it is an entertainment transportation.
But the subcategory.
But it's a subcategory that is
So if any of these, because I think we keep going back to the Glammies, but I know there were others as well. Sometimes they do just do purely transportation, but occasionally they may do a tour.
If they do 100% purely transportation, then they do not need a certificate from this commission. If they ever do entertainment transportation, then they do need a certificate from this commission.
And that's how I understood it.
So it becomes a business decision. If they choose to be just straight transportation, however, if the other is introduced, then they meet the quality, then they would meet it, and they would be in violation of local ordinance.
And I guess that could be added to C, to say if any variation from this at any one point in time, that classification is nullified. Because like they said, they could do it 90% of the time, and during football season or during wedding season, they all of a sudden use that bus for a different purpose, or their company goes into that category just for that season because it's profitable in that season.
I mean, I think the existing language kind of covers it because it says, where all passengers are required to remain seated at all times while the vehicle is in operation, and where alcohol is never permitted or served on the vehicle may be. So it seems to me like if you do it sometimes, you don't meet that subcategory definition. Because
Gotcha.
it's not all, and it's not never.
So we believe they should be classified, they cannot be classified if they do violate either one anytime, either seating or alcohol.
Yeah.
But they could
It
certainly
can
still
happen.
do those other jobs, but they would have to have the other.
They would have to, do it for the purpose of just pure transportation.
Right, and we're just trying to make sure nobody slips through that crack to say, oh, we only did it 2 times, or we only do it.
We will be enforcing.
We only do it on
do it.
Sundays, yeah.
Yeah, it's, I mean, I guess it's a little bit like the record case y'all had earlier, you know, I mean, like, you're looking at, like, a knowing violation, like, after you've been clearly instructed that you can't operate under certain circumstances.
Right.
You know, then you proceed to do it. You know, then you would be in violation of the Metro.
So even if it's once a year, you need to have that specific type of permit.
Yeah, you would be in violation of
Okay.
these rules, and you would be susceptible to either citation or,
Okay.
well, actually, disciplinary action probably wouldn't apply if they didn't already have a certificate, because you can't suspend or revoke a certificate that doesn't exist.
So because now I'm really confused. Not confused, but have a question.
Mm-hmm.
So let's say that I call Signature Events and I want to rent their van, the
Mhm.
biggest one they have, to go, and I have a group who's staying at Opryland,
Mhm.
and they want to go to the Titans football game.
Mm-hmm.
Then, and people are gonna go on there with alcohol.
So even if they're gonna have alcohol in those circumstances, the point of it is to get from point A to point B.
Right.
Right.
There's no entertainment, they're not going on a tour, they're not learning. I mean, I guess someone on the bus may say something, but the purpose of it is just
Yeah, the
transportation.
business is providing a transportation service. The
Right.
business is not providing an entertainment service.
It's the intent.
With a company like Glammy's, they do both of those things.
So they would
It
still need a
sounds like from their
certificate,
letter.
yeah. Unless they wanna, like, change their business model to only
Mhm.
do the one thing, then they would need a certificate.
And fall under the higher fees.
Yes.
If they allow, but she says they
And
don't
have to be
allow
enclosed
alcohol.
and be subject to a separate,
Yeah, well, she says they don't allow that
Finding.
permit. So she should be fine as long as she continues that rule. All right. I guess, I don't want to cut that up, I guess on D, so is this where we're deciding whether they have to be enclosed or not?
yes.
Okay. I think
So
my-
if you approve of B, you can adopt that definition. If you approve of A, you can adopt that definition, although we did talk about a change of closed, phrased to closed,
Right.
and the deletion of.
And any passenger.
Right. And then, C, like I said, that was not the language that legal recommended, but I think it was recommended by NDOT. I think it's from Atlanta, if I'm remembering the discussion last month correctly. Like I said, I don't see it as essential to the safety distinction, but it is entirely up to you what you want to adopt. And then finally, D is basically the exception for the seated sightseeing or charter tour vehicles, saying that they are allowed to not be enclosed, whereas everything else must be fully enclosed, which
So-
we took at the last meeting is what you all were instructing us to track.
So if we adopt 040, A, B, C, and D, it automatically puts into place 020, B, C, and D.
What's O2, OB, C, and D?
It would not necessarily, you would need to go back and take action if you believe they should pay a lower fee, and staff recommends a lower fee, again, because of lower level of necessary enforcement, based on what we know today. Again, a lot of what we're doing, we don't have data, but we have anecdotal data on some of it, so what we're gonna need to do, we may very well need to come back in the future and say, here's what it really needs to be.
My recommendation was going to be in 010 and I guess 020 is maybe when you refer to the seated sightseeing, also include a reference to the definition in 040B. Just to be for clarity so that people are like, oh, what the heck is a seated sightseeing? Okay, here's the definition.
So 040B should be referenced when in
Although currently
010.
040B and C are a part of the definition of a seated sightseeing or charter tour vehicle right now. So it's up to you all whether you want to include both of those or just one.
But in making a motion in 020, B, C, and D, for clarification, we need to bring up, I'm sorry, 020, B, C, and D, we should reference 040B.
I think so. I think that would be helpful just for clarity. It's not absolutely legally necessary, but I think, you know, if you're researching it and you're not familiar with it previously, it's helpful to see, you know, the link to where the definition that's relevant is. Yeah.
I guess one question I have on, as we make a final decision on whether they should be fully enclosed if they are serving alcohol, is there a legal issue with the fact that we don't require that at the pedal carriages? I guess what is the reasoning?
We would have to make not a legal distinction so much as a safety distinction.
Okay.
And I don't know if the safety distinction would be that the pedal carriages go like 2 miles an hour or...
I think it's a completely different issue in a different
Okay.
section.
Well, that's my question.
Yeah, we would have to go back and visit it.
Yeah.
And if y'all chose to do that, what we would do is then prepare the research and come back.
Yeah.
Okay.
That's a good answer.
Okay. I just, I saw that being...
I think they'll also apply to a couple of other things that are in here related to operations.
Okay. All right. But your thought is that is some of it, though, is the fact that it doesn't go as fast, and there's also... Okay, sorry.
I'm not the safety expert. I'm more the
You're
legal
legal.
expert.
Gotcha. All right. So we're still on 040?
Yeah, we're still on 040.
Is it time for a motion, Mr. Chairman?
Yeah, I think it's, yes, we can entertain a motion.
I'd like to make a motion that we accept under 040, item A, with the change of raised to closed while the vehicle is in operation, and to strike and any passenger is in possession of an open container. Item B, as presented, that based upon legal's recommendation, we not include item C, and that we accept item D.
No. Why are we not
Doing
taking
C.
C?
So, I mean, like I said, you can do C if you wish to do C. C is just, it was not the...
Safety.
Yeah, Mr. Fields referred to the language that legal suggested. That was not included in the language legal suggested, because we thought the important distinction between the vehicles for the purposes of, you know, what this commission is dedicated to care about is public safety. Not like where you're going and why.
Is there a second regarding Ms. Williams' motion?
Second.
All those in favor?
Aye.
Aye.
Motion passes.
Can I make one other little suggestion, just in D? Seated sighting or charter tour vehicle is the defined term, and the word tour is left out in 2 places in D.
Oh, yeah.
Should,
Top of that page.
should seated in the new C, former D, and should sightseeing in D be capitalized as a defined term?
I think that's
That would be
Sure,
typical.
probably
That
better.
would be typical.
What we need to do is probably capitalize it in B,
Yes.
and then could capitalize it in other uses.
The last
So
line
what are
of
we
D.
capitalizing?
Up on-
Seated sightseeing or charter tour vehicle.
Here.
Okay.
You could probably even turn that into an acronym if you really wanted to be
Why
wonky.
The other thing I noticed, just generally, Ms. Costonis, in the draft recommendations from NDOT and the rules, there seems to be a lot of interchange use between the acronym ETV and ET. And
When we're using ET, we're talking about the company. ETV means we're talking about the vehicles. So that's our effort, was to not have any, make it clear. Again, it's been edited many times, but I believe we're pretty consistent.
so, yeah, that's not clear to me at all when I read it. So ET refers to a company and ETV is the vehicle.
Correct. That was our intent.
Maybe there should be a C on that ET.
Yeah, ETC and then ETV.
Should be a C on that.
Let's do that.
ET company versus ET vehicle.
ETC.
Yes.
I mean, I'm a lawyer and I was reading it and I was getting confused, so.
That should be easily fixed, yeah.
So do we need to?
I mean, we
put
can
that in?
define it in the beginning, but I would,
I think that's a good add to, especially when, if you are on the site reading it,
There's
to add that C
clarification.
to the ET. If we're gonna add the V to distinguish the vehicle, why not add the C to distinguish the company?
Yeah.
Just consider it
There
done.
is it's in 010, so you could put a parenthetical ETC in 010.
So under A. is
But
what we're
also
talking about.
sometimes we refer to the company as the certificate holder. Holder of the certificate.
Right, and that would explain itself, but if we're gonna add the ET in place of it, I
In
think
A,
the C would clarify.
In A, it says operate an ET company, so that would give us the ability to add the C, so we can move on from that. We'll
And
get
then
it
it
done.
becomes et cetera.
It is art, just consider it edited in,
Yeah.
with no action necessary, I think.
Well, if it's confusing legal, I'm gonna defer to the fact that if it's confusing legal, it might confuse the layman.
It's a good suggestion.
Okay.
Certainly you can do it.
Do we need to go back and,
That would be an
Revote with the
010,
changes.
but we're gonna get to 010, so
Here.
we can probably do that.
Yeah.
Work
Yeah.
it out.
on 040?
Oh,
Or is
and
that
so
just
in
more?
B,
The motion.
in
is still being
010B,
Okay.
so we're referring to ETV there, right? Not,
yes,
it says ETs,
yes.
okay.
Oh, okay, I'm still here.
No. Oh, well, no. We skipped on you. After
Again,
we-
I think based on the other
approved all
language
four
in
that
the
we
previous, in A, we should be able to make sure that we're
that's
clear
what you see.
that it's either the vehicle or the company.
ETCs.
Okay. Okay.
I think the motion was pending. I think I messed it up and stalled y'all by suggesting that we add the word "or" to D.
So do we need to alter
We're
the
still
motion?
back on
We actually
040.
voted.
Yeah,
Yeah,
the
motion
motion
passed.
Okay,
Yeah.
I always miss that.
We added.
But Ms.
that was a part of
Costonis,
it.
Do we need
Ms.
to
Costonis,
revote?
after the motion passed, pointed out
Okay.
looks like a letter, or a word was omitted
Indeed.
tour.
in subpart D. The last sentence should read seated sightseeing or charter tour vehicle.
It's actually in there twice.
Where's the other?
The first sentence.
The first sentence, there,
Just the word "tour" is missing.
there, and there.
Can the vote be accepted as it was presented, or do we, okay.
It's just a typo. Okay.
Okay,
That was my question.
as long as we're legal.
Moving on.
Thank you.
All right.
Are we going
We're
deeper
going to the
in,
next
or are we
slide.
going to 010?
All right, now we can go back. I think it makes
Oh, the
sense
slide.
logically
Oh, the slide, okay.
to go to,
The next slide.
to 010, the recommended change to 010.
Yeah, so 010 is, I think, on the screen.
It's still 040.
TD.
Well, that's kind of about 010 though.
Yeah,
Oh, okay.
because of the subcategory ET, yeah, that's.
So you basically, you have one definition, but it serves multiple purposes. So the definition in 040B of seated sightseeing or charter tour vehicle, we put this additional language in A that says that it serves an additional or distinct public necessity and convenience different from that served by other ETs. And because of that, we're recommending that the commission would make a separate finding of fact with regard to the existence or lack thereof of a requirement that further or additional seated sightseeing or charter tour vehicles are required to serve the public convenience and necessity. So that's just copying the language from A, which you would do that anyway, like you would do with any of your categories of vehicles that you regulate, taxis and, horse-drawn carriages and pedal carriages. You're always making that finding of public convenience and necessity as to really how many vehicles are necessary to serve that requirement of public convenience and necessity. And here, with this type of vehicle, we are suggesting that you actually make two separate findings. One for seated sightseeing vehicles and one for all other kinds of ETs.
That's what B is.
Relative to the applicants, we've got,
Yeah.
is it Old Town Trolley and Graylon and the seated?
I'm sorry?
Relative to the applicants.
Yeah, the applicants would have to meet the definition of seated sightseeing vehicle in 040B. So I was recommending that in 010B, after the word seated sightseeing or charter tour vehicles, we would just add in a parenthetical saying as defined in section 040B.
Okay, so it's defined in 040B. All right.
And then the policy decision is yours as to whether you want to make that distinction for the purposes of making your findings of public convenience and necessity.
So 3 changes. Changing ET to ETC.
ETV.
No, in A, it is a change to ETC.
Yes.
Right.
ETC.
I thought you were talking about B.
Oh.
So change it to ETC, adding the reference of 040B. And then adding the word tours.
I think tour is in there.
Tour's
this
already
time.
in this one. Sightseeing, but it's not capitalized, so do we need to do
Yeah, we
that?
could add capitals.
Capitalized is a defined term.
Doesn't need an apostrophe because it's not possessive.
So you were saying in B we need to change like ET capital or ET apostrophe S to ETV?
Or is it the company?
No, ETC.
In B?
Because it's a subcategory of
Because
ET.
It doesn't need an apostrophe because it's not it's not possessive.
Yeah. It's in B, because of the subcategory of ETC, because you said that's the designation for the company, and ETV is the designation of the vehicle, and we're specifically talking about the company. So in that first sentence there, it's the ETCs, I mean the ET apostrophe S should just be ETC.
Got it.
Although in B, it does say where the vehicle consistently operates. not the company.
Yeah, I think it's referring to vehicles.
Also, that should be changed to V.
ETV.
Okay.
Yeah, ETV. Because it was my understanding that you guys used ETs as, for companies.
Like Billy was drafting some, and I was drafting some, and we
I
may
gotcha.
not have been completely
Well, that's what we're here for.
Editorial. All right, so ETVs. Okay.
Any other changes? ATV.
So we'll make the editing changes on the section B.
So would anyone like to make a motion regarding 010, the recommended change to 010B
And there's one to A too, just adding
and A?
Oh, what's that one?
Just adding an ETC as a defined parenthetical after the first.
Oh,
piece
to
of the
operate an
ETC
ET.
copy.
Okay. I would make a motion that we approve the NDOT recommended changes in 010 in addition to adding ETC after ET company in A and adding V in B next to the ETs and removing the apostrophe, as well as capitalizing sightseeing or charter tour vehicles and then adding in after vehicles as defined in 040B.
I second that motion.
All those in favor?
Aye.
Motion passes.
020 fees. And just to defer back to Billy, the reason we were considering lowering the fees is because we did create a subcategory of sightseeing versus regular entertainment vehicles, and found that the sightseeing vehicles would require less policing, less cost.
That's our belief at this moment, and through our study and looking and trying to ascertain where complaints have come from and where public concern has been, and facts from the police department, which have been none on any of these types of vehicles, that we believe there's probably 6 out of those applications that clearly would meet the definition. Could be more after we hear whatever we hear, but we believe there's at least 6 out of the initial 33 applicants.
Makes sense to me.
Okay. Makes sense to me.
Any insider or comment on the fees?
No, I think we're relying on the department's recommendation there and trying to line it up with
Certainly you can change
expected costs.
just a half a person.
So I'd like to make a motion to approve the fee changes or additions in 020 as the designation for sightseeing certificates and vehicle annual fees.
Commissioner Carr, I'm sorry, did you want us to reference the definition of that?
I think that would be helpful. I mean, maybe we could even just drop a footnote where it says sightseeing certificate. We could just say, like, sightseeing refers here to seated sightseeing and charter tour vehicles as defined in 040B, something like that. Just something to give people the reference.
Or for B.
Mm-hmm.
No, you go ahead. You're better at it. You go ahead. I'll let you do
it. All right, well then I will make a new motion that we accept 020, the changes that NDOT recommended with the defined fee prices for sightseeing certificates and annual fees and add a footnote to B, C, and D that references what the sightseeing vehicles are as referenced or defined in 040B.
Amen. I second that motion.
All those in favor?
Aye.
Motion passes.
My English teacher would be so
Okay, now we're on to 050.
So this is, falls under safety, and, you know, we've implemented and made changes to 040, where we adopted the definition of an enclosed vehicle. And also the recommendation that entertainment transportation vehicles are required to be fully enclosed. So there's some now moot.
Would item E, Mr. Chairman, cover the sightseeing vehicles that would be open air?
Possibly. But we need to, I think we need to talk about that because it requires them to be seated. In order to be a sightseeing.
Yeah, the only unenclosed ETVs that would be allowed to operate would be the ones that meet the definition of seated sightseeing or charter tour vehicle. So
And
could
seated being one of those focal
keep this safety
points.
provision in E in there to regulate them, or you can take it out altogether. But because their passengers are required to remain seated while they are in the vehicle.
So would it be your recommendation that we keep that, move it to another section covering those vehicles specifically, or?
Do you think it's needed if people aren't standing up?
Well, I'm just wondering.
Well, I think from a safety standpoint, you know, we just want to again, for us, it's all about the safety. Since we have not been able to regulate them, we're not familiar with the vehicles yet. When we will be able to make some determinations once we're physically able to see them. I think railing is appropriate, even if they're seated. We want to make sure that they are not able to accidentally fall out, even if there's something that would happen. I mean, the more safeguards we can have, the better we're going to be. It may be we would come back to you next month and say, hey, we've looked at them and here's what we've seen. So we could clearly come back. I'm not sure it would be something you need to deal with at this moment.
Do you know if there are any federal regulatory standards for like big double-decker buses?
That's what I was wondering about, like old trolley tours. I mean, are their sides 4 feet tall?
No.
I didn't think so.
I mean, that safety recommendation may have been written with an envision that people will be standing.
Correct. This was written for open vehicles for standing, and if you wanted to amend it and say although they won't exist. Under
or you
what
could
you
just take it out for
Right.
now
Just
and
remove
let
it.
Billy
Imagine
do the research
a chair
and come
with
back with a
a
different
4-foot
recommendation.
rail.
You could remove it. We could come back.
It would be a little redundant.
You could just simply say that this applies to vehicles that people will be standing.
But none of the
None of-
ETs are
yeah.
you allowed
It's a
to
moot
stand
point
in
if they're all
other than
closed.
seated sightseeing tour vehicles.
I wouldn't think you would need a 4-foot rail over a chair. even if you had that squirrel reaction,
Yeah.
it'd be a pretty hard, it'd almost be a Superman reaction to get up over a,
I mean, could we just say rails must be used?
yeah. I mean, if you did it from the seat itself, 48 inches would mean the measurement would change to in the vehicle
If
to that
anyone
height.
is here from one of the companies, they may know more than we do.
The thought is that since we've moved in the direction of enclosing the vehicles, and we're allowing it to be plexiglass, plexiglass is not necessarily very sturdy. If a rail is there, it is going to be providing safety from someone hitting the plexiglass and falling out. If the plexiglass is there, there's a chance someone can fall outside the vessel, if that's how they decide to secure it and make it enclosed. So perhaps maybe since the sightseeing is now been defined as they're seated, maybe perhaps that this would be, if there is the opportunity for them to be standing, we would be requiring rails that would be protecting, additional safety protection of the vehicle, especially if they're using plexiglass or that type of a material.
And I think I was more concerned with the height. It's at 48. So even if we're going to require something for a seated vehicle, a rail versus a plexiglass falling out, that it not have to be 48 inches. That's way up there if you're sitting down.
But I think she's saying is it
48 inches comes
Well, I
with building.
think 42 inches, like I think about, I hate to say this, but when you go to an amusement park and you're a young kid and you go on a ride, they require you to be 42 inches. For
Like a
safety
little
reasons.
drop.
Well,
Yeah.
that has more
Yeah,
to do
for
with
safety.
gravity.
Yeah, it does, but so does this, so the rail would be a protection to keep people from falling out. So I understand your concern about 48, so maybe hit in between 3 feet and 4 feet, because 48 being 4 feet, 3 feet being 36 inches, 42 inches kind of puts it in the middle. Recommendation for consideration.
I was thinking more like 22.
The Metropolitan Building Code actually,
22 when you're sitting down.
Director Alicon is correct. The building code actually goes from 42 inches to 48 inches. So,
Yeah.
so if you went to 42, you'd be a building code minimum.
Has to have an enclosure.
But I think what you're saying is even for the enclosed, if it's just plexiglass, that's meant as an additional
So
safety
this would
measure.
not, I would say we put in some language that this does not apply to a
the
sightseeing
Right.
instances because they're going to
They're
be
seated.
seated.
Right.
Right.
This would be in the case of
just
someone not
defined.
being seated.
Okay.
It's possible that there are federal regulatory standards for this. And if so, another option might be to say consistent with federal regulations.
What does the federal regulations say, Teresa?
I'm trying to look it up now. I have not
haven't.
thought to look it up previously, I'm afraid. If somebody from one of the industry who has a bus like that is here, they may know.
Hey, could we ask
Standard 42
Derek Free to come
Anybody?
up?
Code
Or
is 42.
Good afternoon. Susan Pisatola of the National Party Barge. In regards to the railing regulations, every company is going to be different. Some vehicles are going to be different, the truck's going to be different, the tractor wagons are going to be different, the buses are all going to be different. I agree with her, come up with some kind of standard where a medium and anywhere between probably anybody else can speak to from like 40 to 48 inches. We're all going to be different. Mine are at 40 inches, but that's based on their lower back to the top from my benches.
Well, that's what I was saying, from the highest point of the truck.
Right.
So if your vehicle, the people sit this deep in the vehicle, then it would be different than someone, say, the seating is this deep in the vehicle.
Exactly.
The railing should be from the point of origin, not, from the top of the vehicle to the seated position, not necessarily, because you might have this much truck from your seated position, and they only have this much truck.
Exactly. And it also should not only be from the seated position, but from the standing position. I stood in the back of one of my vehicles today. When I stood...
Well, we're only talking about the...
Yeah, but 40 inches came to right below my breast line. So it's going to differ and vary from each vehicle. So they've got to be a wide variety of number there for all of us to meet, for all of us to be able to meet what you guys are asking.
I think, our intent was to measure, just as the codes department measure from the floor up. Our intention at 48 was to measure from the floor, the base of the vehicle, not talking about the seat at all, but from the base of the to a rail. 42 inches is reasonable. We actually talked about it. We got to 48, and actually it was discussed at one of the meetings that you thought 48 was better. So we started working around from what we were trying to respond to you. We're satisfied with 42 inches, and be happy if the commission wants to do 42 inches, we're good.
Or even provide a scale, so given
Sure.
what was just raised, if y'all want to consider 40 to 48 inches, because then that way, that may not require as much retrofitting
Sure.
that the different
Absolutely.
entities would have to do. That's a consideration as well.
Yeah.
But I would definitely say, please do 40 inches from the floorboard would be the lowest I would recommend going, because anything less than that, someone can fall over it.
So 40 inches from floorboard.
So if we could say rails must measure a minimum of, and that would cover it then.
From the floorboard.
From the floorboard.
Yes.
From the floorboard, correct. And then if your vehicle was higher than that, it's serving the same purpose anyway.
Yes, sir. Exactly.
But
I understood what you were saying.
But we're really only talking about sightseeing vehicles at this
Sightseeing
point,
vehicles.
because all the ETVs that aren't sightseeing, they're gonna be enclosed anyway, so no one's falling
And I
out.
think what
Yeah,
she's saying is
but
some of them are
plexiglass
enclosed
is an
with
option.
plexiglass.
Some of them are going to be enclosed with plexiglass, and plexiglass is not always very durable
Correct.
to resist or to stop someone who hits it and falling
Oh,
out. That's
good
why we're
point.
recommending the rails.
Okay.
The weight
So it's
resistance.
really more in line for those that would be
So that-
an enclosed vehicle where people would be standing and dancing.
Like that.
We want to make sure that if they hit the plexiglass, they're not going out with the plexiglass. There's a rail there to protect them and to stop them from falling out.
Reinforcement.
You could
Yes, sir.
change E to say, instead of saying rails must be used on all unenclosed ETV, to say rails must be used on all enclosed ETV that are enclosed with plexiglass.
But then do we also still need to do something for the sightseeing that are unenclosed? Or is that the
Well,
one we want to?
Most of the sightseeing, when you're sitting, you're at the windows up and you're protected. So I don't really feel like it necessarily needs to be.
But like even the double-decker buses that
Yeah,
are
well, the
open on
double
top?
decker, it's automatically built that way. They're not gonna get it
They're not,
insured
okay.
unless they have a protection that's going to it. But remember, they're requiring people to sit and they have so you won't have a window, but they have their rails built up so that from a sitting, as you had pointed out, they're
Mhm.
protected.
Okay, so you were suggesting rails must be used on all enclosed, all
Enclosed
ETVs that are
ETV that are
enclosed
enclosed
with
with plexiglass, if plexiglass is the
Or
worry in
or
terms
if
of.
they're retrofitting, I would say,
retrofitting, okay.
a vessel.
And my only intent was to not make the sightseeing vehicles that were seated have to put a rail against something
Correct.
that was already there.
So I would say that this would not apply if there's going to be a requirement for seating. So if it is a definition of side seating, I'm not necessarily I agree with you. I do not feel it's necessary to add a rail. However, on the other vessels, especially if they are going to be retrofitting them to enclosed, we would be recommending that a rail go in because again, they're retrofitting and we want to make sure people stay intact and not fall out.
Right.
So in chapter 677 of the code does also already say that you have to follow all other, federal, state, and local rules and laws and so forth.
Okay.
And so if there is like an NTSB or NHTSA rule that provides some safety issue that relates to these, then that would incorporate that by reference.
We can check
Okay.
that too. There are some standards through FTA that we can check.
Just on all retrofit ETVs and must measure
Talk to
minimum.
There's some.
I was trying to do a quick search and it's just too complicated.
I imagine.
From a safety perspective.
Height, okay.
Because then you're just talking about this, a whole lot of designs and
I mean, there's worries like what if a vehicle flips over,
Mhm.
you're seated but.
So was there language that you had then for a motion to deal
I didn't know
with?
if we were discussing anything else before.
I
wrote down the language that we suggested for 050E. But I can tell you what it is if you want to.
Yeah.
What I have is rails must be used on all retrofitted ETVs and must measure a minimum of 40 inches in height from floorboard.
Well, I know I thought we were talking about 42 inches. Did you mean to say 42 or 40?
I thought we switched it to 40 because
Or
they were saying.
a range of 40 to 48.
Well, I think that's what we said, a minimum
A minimum.
of 40.
A minimum.
So they can certainly be higher, but they have to be a minimum of 40 inches in height from the floorboard.
And you added the word retrofitted into
Yes.
that, yes.
Yes.
That, I
Yeah,
was
that,
gonna-
and I
All
left
right.
it as rails must be used on all retrofitted ETVs, regardless if it's sightseeing or not, because if they retrofit theirs, they should,
And we're referencing 050E.
correct, 050E.
Was that a motion?
Well, I didn't know if we were.
Yes, is there a second?
I second.
All those in favor?
Aye.
Aye.
Motion passes.
And then, do we need to talk about F2?
Yeah,
Okay.
because that was a recommendation.
Safety just passed all of it.
Now, in F, my thing was, this is open to allow NDOT to determine the hours of operation based on a study that you guys are gonna do every year, or?
Yes, sir.
Okay,
We actually will do the analysis to determine what is the peak hours in which the vehicle would be operating, that this would be applied to.
now would this leave them open to basically insert that on their own, or would it need to come before the board every year for us to agree that those hours are agreeable?
I believe this is asking us to leave it up to the discretion of NDOT based on the engineering analysis that we would be doing.
But I feel like wouldn't we need to have have that part of the annual public hearings?
Hearing.
Otherwise, how do operators know?
And I think that's the intent in talking with Brad Freeze. His intent was to, on an annual basis, unless there's something else to determine,
Right.
determine an annual rush hour based on current vision of what's happening, as well as establishing special, if there's special events or special occasions that may need some
Right.
alterations, applying Monday through Friday. It would certainly be a simple thing to do at the annual meeting when we determine it for the NDOT.
Yeah, but this language doesn't say that.
Yeah, it just kind
So
of
it's
sounds like
like
they
It
decide.
leaves it open to them just to make that without any review or.
We
Or
could
announcement.
certainly bring it to you on an annual
You could
basis.
say, and that's required to be published on their website or something like that. Is that okay?
I wanted
We'll
to
be more than
say we
happy
have
to.
to approve it.
Yes.
Okay.
If annually is fine, but I don't wanna leave it up to them.
Right.
Sorry.
I would
think it
like
makes
to.
it hard for police too.
Exactly. So it wouldn't be fair
Annually,
to the
I
people.
appreciate very much, and then if there is something that happens, so for example, if we were to do a major change in the traffic flow pattern or something
Right.
like that, we would wanna have some flexibility to bring that in, because that's gonna change the analysis, and we'll bring that before y'all at that time. So I would say at least annually, if we could say it that way, sir, if you would
Yeah.
consider.
That'd be fine.
Thank you.
So if you were to add a sentence that's saying, recommendation will be presented to MTLC at its annual hearing for review of
And
entertainment.
approval.
For approval.
What you were correct.
I was just
would be
gonna
a-
add in subject to the approval of TLC right there.
Okay, you could do that. That would,
So just so in F where it starts, to enhance safety and encourage traffic flow, vehicles must travel in a manner consistent with the flow of traffic and may not operate during the rush hour periods to be determined by NDOT, subject to the approval of the TLC.
Okay, thank you.
all right.
Got it.
Could you read that
And
again?
then we could add between the word determined and the word annually, you could say at least.
Determined.
It looks like the,
Say that again.
at least based on the study,
Quite what I had in mind, but that's good.
rush hour was, the recommended times were gonna be, rush hour was 3 to 6.
There it is.
3 to 7, but that seems like
3
an
to
awfully long
7.
time.
3 to 7 in the afternoon. AM peak time is actually 5 to 9 a.m. and then afternoon peak time is 3 p.m. to 7 p.m. And I do have someone from our engineering department here if y'all have any more technical specific questions.
Are we gonna consider adopting this today?
That would be our recommendations, yes.
Okay, I wanna hear the methodology.
Okay, Jason, can you come to the podium, please, sir?
Yeah.
Good afternoon, Commissioners.
Good afternoon. If you'd
My
please
name is
introduce
Jason Oldham
yourself.
with NDOT. We have the slide up. Any questions? There's a 4-hour period. 2 hours is build up for each period in the morning and the evening, and 1 hour for restoring traffic to normal. So that's what you're getting, and you're seeing a marked. Well, actually, it's not showing up. The average peak hour period. Let's see. It's showing 4-6, and then the yellow highlight for the morning showing at let's see, 7.
Would you explain your methodology?
This is just based on just volumes of traffic in the Nashville area, and you can see the source.
Area, not just downtown.
Just, yeah, according to TomTom, in downtown Nashville area.
Is that with the inner loop?
I believe so. I think Brad worked.
How do you measure that?
This is just source data from TomTom for traffic volumes.
It's basically what, number of vehicles per hour?
Yeah, yeah. Just like on some of your apps about when a store is busy, you know, the volume of people, you know, purchasing things at a store is kind of the same thing. We have cloud data, the source, people's cell phones.
What are you measuring? You got, say, 42% at 2:30 p.m. on Friday. What are you measuring? 42% of what?
I think it's just the percentage. I did not calculate this table per se, but it's just the percentage increase, like over your traditional volume, like you'll see.
What's traditional volume?
Well, I'm just saying.
What's your base?
I don't have the base volume numbers.
Okay,
on
I'm
this
not
table.
asking for the exact number. I'm asking for your methodology. Is it 43% of some peak?
Well, like 4 a.m.
What's the
is
peak?
0%.
What's the absolute number?
So that might be. the
That's kind of what I'm saying. It's like your hours, like in the morning AM, where there's 0 traffic. So it's just a percent increase.
Increase.
Yeah.
Increase over what?
I did not come up with this table. I'm
So
sorry.
it's going to be taking your traffic, your volume traffic, and then at that particular time, you have 43% more of the traffic volume than your base. And that base is the number he doesn't know off of it, but there is an average that we figure out of how many people are moving in a car, a vehicle, whatever, on the roadway. And then, but at these particular times, there is 43% more than that average time.
And it
volume
looks like the
of cars.
base is at 4 a.m. It looks like your base is 4 a.m.
Yeah,
So you take it all day long and you're measuring against that and you take
4
the
a.m.
average
is
and that
0.
becomes your base.
So it's 43% more at 4 p.m. than it is at 2 a.m.
Correct. And you do look at a 24-hour period. And you have to, because the amount of traffic that is occurring throughout the inner loop, so it is defining it in the inner loop, does go until late times in the morning. So
Yeah, but I don't.
The problem with this is we represent 1% of the traffic.
Well, that's not the only problem. The problem, I mean, comparing 4 p.m. to 2 a.m., I mean, your base, I would say, is your methodology fails because the way you're creating your base. I'm sorry. I mean,
no,
the situation.
I hear you. I mean, we can get it better defined for you as far as what that base and number is. So if you want us to bring this back at the next meeting, we can. If you, along with the methodology, I'll be more than happy to have that more laid out for you.
Yeah.
It's
because
the
it's all
average,
about what you're measuring from.
It's an increase over the average daily volume is what this is
the
based on.
average daily volume. need to be careful here.
As long as they
It's not
bring it
the base
before
that
us
should be
before
used
we
to
determine
measure
it.
4 PM compared to 4 AM. You
So-
understand what I'm saying?
So
I mean,
instead of
it's
using a
really-
24-hour period, using a lesser condensed
Yeah.
amount of
No, I
time to
understand.
determine that base.
Yes.
Got it. I got it.
Because even when it's a 43% increase over your base, which
Yeah.
is not proper methodology, okay, sorry, that's meaningless, because of course there's an increase at 4 PM.
Yeah.
Okay, so it's not 43%.
You're
Is it
thinking
4% or
you're
10%?
thinking it's 90% because the base is from
Oh, yeah.
7 AM.
I'm arguing your
7 PM.
42% is meaningless.
Is low.
No, I'm saying it's probably high, because they're measuring 4 PM compared to 4 AM. Or 4 AM is part of the base.
But if you take
4 AM is the
out,
base.
if you take-
It's gonna make it higher.
If you make 4
It's gonna
AM
make the-
out,
Not necessarily. No, you're lowering the base by including 4 AM with 4 PM. The base is gonna rise, therefore the increase at 4 PM will be less.
Well, I think if we put in,
Sorry.
if we adopt the fact that we have to approve
That's
to determine that it would come before us before it was put into action anyway.
Yeah, but that's what I was asking, are we
trying to
considering
pass
this
something,
today?
so they have some type of-
Well, I do
Well,
think it's
right?
important to consider it today, because I want to leave here today with some set concrete rules for everybody. But a simpler thing to do is just to say, you can't operate between 4 and 6 in the afternoon and 7 and 9 in the morning. And then consider recommendations from NDOT on a regular basis, but that's the base.
Right.
The base
What-
being that 2-hour frame.
What are the times for say the pedal taverns that are already in?
7 to 9.
But what you just
The-
Four
said.
to
the
six.
7 to 9 and, yeah, same hours.
That I'm okay with for now.
7 to 9 and 4 to 7.
you drive around downtown every day.
Yeah.
I do.
Yeah, I
I
understand,
do,
but is
at
it
like
40
2 o'clock, 3 o'clock, particularly.
But it's always gonna be there.
No.
Yes,
It comes to a crawl
because of the number of cars.
because of the number, because it's
Cars.
rush hour.
Because of the number of cars.
There
Yeah.
were hours in
That's
terms
the
of how
base,
late
the
they can
number of
go,
cars.
but maybe not how early they can start.
I think it said 9 AM.
I hate that.
No, we're not using entertainment vehicles as the base. It is the
Correct.
volume of the cars that is
Volume of the
determining
The cars.
this time. It is not,
Take us out, nothing changes.
Well, the other thing is, we're going to decide on how many permits we are going to allow, and that too will make
you're
Change the
absolutely
percentage.
correct.
So I like the idea of starting with which I think somewhere in here we already approved that they can't operate before 9 AM. So the 5 to 9 is, or 7 to 9, and maybe I made that up, but I feel like I reread that.
What you have now.
UTV may begin operations after 9 AM and must cease operations from the public roadway at 11 PM is, 070F.
Okay, but
So-
I like the idea of starting with 4 to 6, because that's what we've imposed on the pedal carriages and those. That's a good base, and we can see what kind of difference it makes, and also based on with the permits. And I don't disagree that there's traffic prior to 4 o'clock, but I feel like that's a good base to start versus, a 4 to 5 hour period. But
Yeah.
I agree with that, and are we going to define routes?
We're in the process of, we've just gotten information early this or late last night that are going to be showing us all of the population centers as well as construction and so forth. We do have an intent of not necessarily routes but zones. Under the way your rules read, you can choose or staff can choose. What we'd like to be able to do is, I can already tell you ahead of time, staff's going to be recommending we don't go into the Gulch. We're going to be recommending you don't go to residential areas like 12 South and Edgefield and those sort of things. We're also looking at a downtown population where we have a high level of development, and what we're going to be able to present to you is, and again, we had not brought it today. We have some information we can show you. We certainly know that everything south of Division, or at least KVB, south to the river, and then south of KVB east to the river and then west all the way to the inner loop is a massive set of developments, including many, many residentials. So there's going to be there are clear defining lines when you look at that data that we would be presenting back to you saying, this is as far as they can go here, 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 and here.
Well, the point of my question was to define rush hour on in those specific zones so that we can then determine the hours of operation or non-operation during those times in those areas.
And yeah, if you're in an unpopulated area, it's not a problem.
Yeah.
It's
Right.
when you're on Demumbrian at 5 o'clock and it's one.
Yeah.
And they want to operate in those populated areas. They're not gonna be, so typically, the zones are the area that we're looking, which is, again, staying within the inner loop. If you look at that, the rush hour is typically the same. It doesn't vary by much.
Will we, though, also be able to allow them outside of the inner loop? So that every neighborhood can enjoy.
Share the wealth.
Yes.
Yeah, I mean,
Share
like,
the love.
I like,
No.
people want to go as on a sightseeing tour to the Parthenon, right? Or a star tour and drive somewhere and see a star's
Forest
house
Hills,
and White House.
We have stars in the city?
Well, sightseeing would be some,
Would be
would
a-
become that we're actually going to be coming with some exceptions for sightseeing because that would be different.
Yeah, because that would be an actual, set tour.
Correct.
Set, route.
Well, so I would think we were not allowing the sightseeing tours during rush hour in the downtown loop.
Yeah,
Yeah.
we'll have to come back and better define that, but yes, they are they are creating part of the traffic issues that we're having in the downtown area. But the downtown area really isn't just within the inner loop, y'all need to understand. I mean, our Connect Downtown study that we shared with y'all even exceeds further out. We're going out as far west as 31st, and we're going as far north beyond Jefferson, and we're going out past the inner loop and all the way over to 5th on the east side, and we're all the way down to Wedgwood on the south side. So we are outside the inner loop, and we are looking and studying that through the Connect Downtown efforts because that all has a huge traffic impact at these key times that are actually up here in front of you right now.
Will you go all the way out, like, instead of just the 31st on West End, will you go all the way out?
Right now, the boundary takes it to 31st.
So when we get banned.
That doesn't mean we would.
Michael, need to be recognized by the chair.
I understand it's not a public hearing, but this lady has a microphone and talks nonstop. She's not part of the commission.
Michael,
I understand.
stop.
Yeah, and we don't need the ad hominem, but I understand.
Thank you.
Well, in the interest of moving this forward, can we go with the recommendation that the chairman has made and that Commissioner Warren's made about the rush hour period at this point in time
certainly can.
from 4 to 6?
Most definitely. It's at the will of this commission.
Which is the same as the pedal, the other license.
Correct.
Correct. And again, knowing that all of this is subject to change, but we have to have a base to start with. We don't have one meeting a year, and as we learn, this is, we're trying to establish a base, and we're learning as all the commissions and appointments and everything that we set in place is a learning. It's not concrete.
And we anticipate changes. We gather data. You got to remember, we've never regulated this before. We anticipate gathering data over the next several months, and we'll be coming back with additional changes, suggestions that we learn, so that this is a good idea and we can improve it by doing this. Basically what we'll be doing is saying this is setting a process by which you'll determine what those rush hours are. You'll take this, you'll give it a temporary. Again, you don't have to worry about the morning because you've already a past rule that said 9. So what you say is the afternoon rush hour is today defined 4 to 6, and then NDOT has said they will bring back more information. And if you choose to accept their data, then you can then make the change then, or you could say you don't, but we can bring that in the future.
Will there be evaluation of any of the other, I mean, I think about, I look at your Friday, Saturday data, and that doesn't appear to be
Accurate.
in the core, at least, right? If you think about Second, Third, Broadway, when it's open, I guess it's not right now, but Second, Third, Fourth, Demonbreun, streets that don't flow. I guess, does that come in as you think about routes? And how do you,
I think it had been adjusted once they do come into flow. We can't necessarily calculate what we can't use.
And we do anticipate that there will be a whole nother conversation that we will be having with this commission once we get the recommendations that come out of Connect Downtown that's going to look at all of that. So I want to say, yes, sir, we're looking at it now, but we're also collecting a lot of data for the analysis to make a determination if there's a better way we can do it to fit all the needs that we are being asked to look at that keeps the traffic moving throughout the downtown area, the inner loop, and extending a little bit
yeah,
further beyond.
Midtown.
Yeah, Midtown, because I mean, we have challenges in the Midtown area now as well.
May I make a motion that we take the recommendation F to enhance safety and encourage traffic flow? Vehicles must travel in a manner consistent with the flow of traffic and may not operate during the rush hour period of 4 to 6 p.m. as currently established by NDOT. The rush hour periods will be determined annually based on the highest average peak. Then I think we can continue. You don't want to use that?
No, don't get into the details.
Okay.
Just say subject to MTLC approval.
Okay.
You probably should say Monday through Friday on the hours.
Oh, yeah.
Yeah.
Right.
Yeah.
Rush hour periods Monday through Friday of 4 to 6 p.m.
Why are we not going to 2? And if they're saying that the rush hour starts at 2, I try
Because
to
I'm not accepting their numbers today.
I try to leave to pick up my children from school.
That's
and
anecdotal
it's a parking
evidence.
lot.
That's anecdotal evidence.
Well, school gets out.
That's right. That's why rush
School-
hour starts at 2.
yeah,
That's
school
why
gets
there's
out.
Rush hour starts because a bunch of people get in their car.
That's right.
What do the hours for the pedal taverns apply on the weekends?
They do not.
They do not. So we're talking Monday to Friday, which I assume is why the chair said Monday to Friday. Because I want it to be the same for now. I'm not saying forever, but for now.
If we want to restrict the pedal taverns, when do we have the opportunity to do that?
You'd ask for a public hearing, and we'd have a public hearing, people would have an opportunity to comment, we'd gather data, and then you would be able to make that decision.
So why wouldn't we just go ahead with their recommendation at 2?
Because I don't understand those numbers, and I don't
The
like
motion
the
would
way
probably
the
fail,
methodology.
that's why.
I did numbers for a long
I'm
time. I
guessing.
do not like that methodology.
I
Because
don't
when they
know.
take out the hours where nobody's out, the base is going to increase and those percentages are going to decline. And I don't think that's an accurate way to measure it.
Well, if I may, the good news is we're going to come back with the data to try to answer the questions. If you want to establish for the
Yeah,
current.
I really would
working-
like to get a rule on hours today.
Yeah, I agree, and I think you're.
Rush hour Monday through Friday, 4 to
I'm
6
very
p.m.
Yes, I think we're there.
And I think we'll have a lot more to bring back before this commission with Connect Downtown that we would then want to open up and have another conversation. And we're not quite ready to have that today, so I'm more than comfortable with the recommendation that has been made by the commission at this point. I have no pushback whatsoever.
Does NDOT have strong feelings about or advice about neighborhoods outside of downtown during rush hour or midtown?
We do. There are some challenges. We have received a lot of letter and concerns from area because the dynamics of our downtown has changed dramatically with the landscape. You know, we've actually opened up and have brought close to over 15,000 residents in the downtown that may have not been here, 10 years ago. So, in consideration for their quality of life, we are taking that into consideration when we're looking at consideration for routes. So,
I'm thinking about any IWD zones.
zones that don't have high residential, areas that are not in the core, that are outside of the urban core, that are outside of Midtown, that are outside of the high traffic areas, that don't see a lot of traffic.
I think that would be a great conversation to have with the industry of what they would envision would be a value for their business. It's fine for us. I can always identify outside those areas where we aren't seeing the traffic impacts and say, okay, these are the routes, but that may not be really a good business plan for the industry. So I think that's a conversation I would want to have with the business industry to see what would be viable outside the core where we're seeing the largest traffic impact at this point. That's a direction. We can certainly have that conversation with them. And there may be a win. There very well may be a win in that conversation.
All right, Ms. Williams, would you like to restate your motion?
To enhance, this is NDOT recommended item F, to enhance safety and encourage traffic flow. Vehicles must travel in a manner consistent with the flow of traffic and may not operate during the rush hour periods of between 4 and 6 p.m. Monday through Friday. Additionally, NDOT will set restrictions based on special events occurring in the downtown area, subject to TLC approval or not, Mr. Rogers?
I don't think it's necessary for special events. You already work with them on special events, right, Billy?
Yes, we do.
Okay.
Yeah,
We're part of the special event team.
Yeah,
All right.
which is a temporary period, right? So, I mean,
Yes.
okay. So
4th of
I don't
July,
see-
for instance, with CMA, they're all
Right.
many special.
We don't need,
Okay.
Grand
yeah, we don't need to deal with those.
We have special
You
events.
name it.
Yes. Special events may be 365 a
So
year.
the sentence, so Ms. Williams
So the sentence
is
would
staying
end
in
at...
as is?
Yes.
Okay, the last sentence. Okay. Is there a second?
Second.
All those in favor?
Aye.
Motion passes. That takes us to 070, where last month we passed a rule that was requiring drug testing within a certain amount of time after a crash involving property damage or bodily injury, and NDOT has made some recommendations along with legal to better set out our intention regarding testing after a crash.
This particular rule, after our conversation last month, we decided, and we would turn based on your request, to seek out additional information. We went to Metropolitan Government's HR Safety Division and discussed how employees are treated, how an NDOT driver would be treated if there were a wreck, or a water services. This particular policy mirrors what the Metropolitan Government requires of its drivers, which also mirrors the United States Department of Transportation rules that they require for drivers, over-the-road drivers and so forth, that Mr. Carr knows well about. There's a few deviations, but very few. Metro requires the test to be done within 32 hours, which is what the federal rule is. We're going to require 24 hours. We also have described that this is a policy that the company itself has to establish. They have to establish a vendor that's going to make sure this is available on a 24-hour basis, 7 days a week. They'll have to set that up, then advise us, show us what they've set up, and keep that on file. There was a question about the police involvement. The last thing is that if the police department are involved in the investigation, then the investigation where substance abuse testing of any kind, we would defer back to their investigation and their findings. So this is, again, very close. It's very similar to Metro as well as the U.S. Department of Transportation.
I think some of the determination we were trying to put in place last time, and I believe the officer that we had here also emphasized the fact that they personally will not administer any test without it being bodily injury or.
What they need is what they would.
Criminal implication.
Right, a probable cause for a criminal. What we're saying is if there's a fatality, if there's bodily injury which requires an immediate treatment away, in other words, a trip to the hospital, or where more than one vehicles have been towed, and where there's private property that has been damaged, or the driver receives a citation under state or local law for a violation, in other words, a police ticket. Not a MTLC ticket, but the police would be involved giving him a ticket. So it was not as clear last month. You asked for clarity, and we think we brought you clarity, and we recommend approval.
I would like to point out a typo in the fourth, it begins the paragraph, each ET company must create and adopt a written policy for conducting employee drug screens while remaining, it should say compliant rather than complaint.
I guess we've got complaint on our brain. I'm sorry.
Thank you. I can't tell you how many people read this and we all missed it.
I mean, it's amazing. And we did offer the suggestions based on information from Metro. There may be others, but clearly these are suggestions on who can provide this service.
Mr. Chairman, you're a lawyer. Do you have a problem with that language?
I don't. Would anyone like to make a motion regarding 070?
Move approval of the NDOT recommended changes to 070E with Miss Williams' typo in the last full paragraph.
Compliant.
Each ETC company must create and adopt a written policy for conducting employee drug screens while remaining compliant with the standards instead of complete.
Second.
All those in favor?
Aye.
Aye.
Motion passes.
Changes to 100. Passengers under the age of 21. May not. No, because if they're under 21, it's a may not. It's not a will. It's not a choice. You're not legal drinking age.
I don't say that should be.
Will or
not
shall? Shall.
You're right. May, you're right. May implies, yeah. Right. May not implies you have a choice. Will not.
Or shall not.
Or shall not.
Better legal. So sorry, my little springs down here was, but the recommended C, passengers under the age of 21 may not be permitted for whatever reason that bothers me, so we were suggesting to change it to shall not be permitted. Just as we want defined.
Well, as my lawyer advises me, words mean something, so.
Make a motion,
All right, then I will, unless anybody else has other questions or concerns, I would make a motion that we accept the changes in 100C by striking what was previously in there and adding passengers under the age of 21 shall not be permitted to ride an ATV where alcohol is present.
I second.
All those in favor?
Aye.
Aye.
Motion passes.
And the last one is direct. Oh, that's true.
120. B5.
120 where?
Section 120 violations. Subsection.
And this particular one is describing what a violation would be for a driver, and that would be a violation for a driver 5 instead of what it was. We'd recommend a violation would be allowing a person under the age of 21 to ride in an ETV where alcohol is present. It just reflects directly back on what you just passed.
Okay, and then eject.
I think this here. Is this what we're talking about?
No, scroll, you'll see it's in red. So where they struck that, and then look on the back there.
Oh, okay. She said 2 more. I thought there was another one I missed.
If I could interject, I've got an email sent to me while we've been in our meeting from the lawyer for Honky Tonk Express asking if they will be given a chance to speak. I did want to respond to that. The answer is no. This is a continuation of our deliberation following the closure of the public hearing regarding the adoption of rules related to the operation of ET companies and their vehicles. We have not gotten to the point where we're reviewing company applications yet. We will give you an opportunity to speak when we do that. But this is our deliberations following the closing of last month's meeting, in which we are adopting rules regarding operation.
Because I have it on 120. 120. B. I'll just show it to you, that may be easier. I don't know if I'm just reading anything correctly, because I not believe that that's in accordance with its procedures.
Yes.
Yeah. I think I printed mine out at home, so it's the right one. So it's 120 violations. We have AD.
And it's 420.
Oh, because I'm reading it here, so.
Are you looking at the 420 section?
Why does it go from 120 to 420?
No, that's just referring back to the metro section of the law. I'm sorry. That seems that we're just having that as a reference, saying this is
120 is the
this is
last
what your
one.
authority is based
I'm
on.
so sorry, you're absolutely right.
So it's
Yes,
just a reference.
the width should be in there, that's correct.
Okay, and then where it says, the last sentence, likewise, the citation process described above may also be pursued. Should that be against, or is again correct? Against any unlicensed.
Wait, still in that same paragraph?
The very last sentence, where it starts likewise.
Likewise, the citation process described above may also be pursued against. Yes, ST. I think those are my typos, sorry about that.
Oh, that's okay. When you do stuff like that and you read it, you see, you read it how you know it should be.
Those are good catches.
The only other question I have was on 4, where it has allowing more passengers to be carried in an ETV than for which there is proper seating, and at no time shall the driver allow any passenger to ride in any area of the ETV not specifically designed or designated as a seat. But I think in some of the ETVs, they may not have a specific seat, so should we say passenger area?
All of the ETVs are required to have a seat for everybody.
To have a seat, even though they'll be standing.
Well, and I think that,
Okay,
that particular language, like sitting on a wheel well or something, that isn't a seat.
Yeah, something on
Yeah, that's what we were referring to.
When I struck my comment. Or take it back.
Like the steps going down to the door. Oh my God, that's
So it's just the 5 then. If that is the only one, I will make a motion that we approve the recommended changes in 120 and, B, section B, number 5, to now say allowing a passenger under the age of 21 to ride in an ETV where alcohol is present, as well as changing in B at the very beginning, adding the word with in accordance with its procedures, and then changing again to against, which were just typos.
Is there a second?
Is that a
Second.
motion?
Yes.
Oh, okay.
All those in favor?
Aye.
Motion passes.
I thought you were just telling them what y'all were discussing. My bad.
That's a clarification question on something we've already discussed. Wanted to just pick your brain on a clarification question for, I think we've approved 090 already in the prior meeting, which is sound.
Yes, 090 was already approved.
A and B. A is compliance with the noise ordinance, Title 9, Chapter 20. Title 9, Chapter 20 is 85 decibels within 50 feet.
Mm-hmm.
Yes?
I believe it's 85 decibels. And we said,
It depends what zone you're in, I think.
I mean, we don't have the authority to enforce it. That would be either a codes department or a police department. So we're not as familiar with that.
I'm just thinking it's an opportunity.
I mean, I can look it up if you want.
Yeah, no,
I
well,
think
so
the 85
the
applies to
B,
everything.
so A refers to 85 decibels, and B refers to, in the last two words, approved levels.
So I think there is like a zoning qualification there where like the 85 decibels applies only in certain zoned neighborhoods and not everywhere. And downtown may be an exception.
Yeah. Downtown has an exception for noise, for amplified live music, is my recollection. That there was a big discussion a couple of years ago about music makes our city and live music, and we don't wanna infringe with the live music, but there was concern among people with DJ parties or restaurants in neighborhoods that were blaring pre-recorded music. And so there was a distinction made, is my recollection, in Title 9, Chapter 20 about live versus pre-recorded music. And where I'm getting at is the next section, B, the last two words. So we talk about tampering in vehicles with a locked device above an approved level. Who's approving the level of sound? And how, right? So I think from our perspective, I've been on the street with cars that are fully enclosed that are so loud it'll knock you over. And not buses, but pedestrian cars,
Yeah.
right? Where you can clearly hear it, it's painful. There's been a problem with codes enforcement around this, but I just, in looking at how we, you, your team, codes, Metro, whoever that needs to be, I want to make sure that we're clear on the last two words, approved levels. Sound can't be tampered or raised above approved levels. And
So where it says compliance with the noise ordinance in 920 of the Metropolitan Code is required, I think the relevant subsection is actually 920.020, specifically subsection B, capital letter B thereof, which is motor vehicle noise. Because there are other provisions, including the 85 decibels for fixed buildings. But the motor vehicle noise says no person operating or occupying a motor vehicle, including an entertainment transportation vehicle, on any street, highway, alley, parking lot, or driveway, either public or private property, shall operate or permit the operation of any sound amplification system, including but not limited to any radio, tape player, compact disc player, loudspeaker, or any other electrical device used for the amplification of sound from within the motor vehicle, so that the sound is plainly audible at a distance of 50 or more feet from the vehicle. In the case of a motor vehicle on private property, beyond the property line.
should we clarify 090A to add Title 9, Chapter 20, 020B?
Sure.
We could certainly say that instead of approved levels, we could insert that as your reference.
Well, I'm
Sure.
curious, because if these vehicles are enclosed,
they can be at 110 decibels in the vehicle, provided outside the vehicle you don't hear it.
Correct.
And it just depends on the type of
The test that the operator's been using and sharing with me, in fact, one was shared with you yesterday, is 50 feet. So that is the standard they expect, is the 50 feet audible. So certainly that would be an appropriate way to describe this.
That's what the noise ordinance says that applies to this type of vehicle.
I think it'd be a good add.
I just wanted to make sure between that section relative to noise, because I do think that there are a lot of Nashvilleians who've had a lot of concern about noise and traffic.
Oh, it's been a big topic, of course.
Right? And are we clear with A and B? Because it says that somebody's approving a level, and it doesn't say who's approving the level. It just says raising sound above approved levels. Is that clear in Metro Legal's mind?
I mean, I think referring to 920.020B is fine. I mean, A refers to 920, B does not refer to 920 at all, so sure, that's a good clarification.
And the specific 020B is very specific and very clear. So
We care less, I think, about what is happening in the vehicle from a noise perspective, if it's 90 or 95 decibels. We care if it's, I think the community cares if it's not, really loud outside.
Yeah, so it's the 50 feet from outside the vehicle.
So you would want it to say these devices must be able to be locked in, or would you just want to say must be installed devices that are able to monitor and govern all sound and be in compliance with MCL 920.02.b? And then that second sentence probably wouldn't have as much need.
To allow, I
have a question about that device that you're discussing.
That's not open.
Right now, we're discussing the sound levels being permitted in the vehicles and whether or not the device, the stereo, so to speak, needs to have some type of governor to not go beyond a certain level. And the question raised by my co-commissioner here was, what is the approved level that's currently in the rule? Because it's not clear.
My question is, that device doesn't, like a lock device, doesn't exist on a moving vehicle. There's no way, there's no...
Well, we're considering actually removing the language.
I just was going to ask if you all were going to give us a suggestion of where to get such device from.
I understand.
If I could make a statement and clarify some of that. The new technology that we have today, the decks that we have, the screens that we run, the whole head unit, I have ours where it's...
Why don't you come forward and...
Sure.
And please introduce yourself.
My name is Jay Sanders. I own Glammy's Party Liners. And the device that we're talking about is not a device. They're built into the devices. So, for instance, my audio tech, when they install a system, I use Overkill Auto Garage in Smyrna, Tennessee. They put the deck into place. That's your head unit, like you see in your car with a screen. It's programmed to where it only hits 40% of maximum volume for us. So, like, every vehicle's different. I'm sound deadened. I got 40 grand worth of Dynamat in my bus that keeps it inside the bus, no matter what. I'm tinted, you can't see what goes on, you can't hear what goes on, and that's just the standard. So you can actually dial it in, and no other employee can actually access that deck and change that. It has to be my tech under my rules set by you. Does that make sense? So the law that says 50 feet is absolutely that law, and it doesn't matter what vehicle, even a motorcycle. I don't know if you've heard the motorcycles with the big subs, and 50 feet is 50 feet. Now, if I go do a luxury wedding event, say I go to Wild Turkey Ranch, it's 300 acres, I can set that bus off, drop those windows, and I can take it to 100 with my code, and they can hear it for 3 or 4 acres. But that's what the client's asking for. So to block something when it's for private, like for instance, I'm at NASCAR. Well, NASCAR, they're going to want NASCAR, they want it louder. They can hear the announcers, they can watch the buses. We're right there in the infield, LI 400. Different situation. Go sit at that track and we'll really hear some noise. So we have the ability to control that through the electronics. But there's no governing, a decibel meter. Decibel meters are not applicable. 50 feet is 50 feet. Now, if an officer can hear it 50 feet away, we have a problem. And you notice the law says it has to be clearly distinguishable. You have to hear the music that way. You can't hear a little bloop, bloop. You can't hear that. 50 feet means audibly 50 feet. I can go right here at Broad, 2 blocks up, and I can hear Honky Tonk Central.
Well, it says,
Or
when it
honky
says,
tonk.
distinguishable, it says plainly audible.
Well, you can hear the words, you can hear the music, you can hear the instruments, you can hear everything. That's the way the law is. Now, we go a step further. We lock it down anyway, contain it in a bus. I got witnesses in this room that heard it full blast, sealed up, and didn't even know I was at the curb. So I think it's a standard. I think it's a decision. I think that as a responsible corporate citizen, we have to maintain that no matter who we are. If you pull out of your driveway and you turn on your music and your windows are down and you're heard 50 feet, you'll get a ticket just like I will. So the rules are the rules. So we choose to govern it down to 40. There is no such device that's outside of an electronic audio system that is able to limit it. The deck itself is what limits it. And so we did that way from the beginning. We don't like complaints. I have 0 complaints because I did it proactively. And I think that's where the responsibility comes in. So that's what I wanted to add, just to distinguish that there's no such device, and there's no audible meters that'll tell you. Here's the thing, if you look it up, a conversation in a room in a crowded restaurant is 60 to 80 decibels. Do the math. It's just what it is. Outside of a bus, I heard somebody in a previous meeting, my bus idles at 80. Just idles. It's big, heavy diesel. We all couldn't lift it, and they're loud. But it's just what it is. So are some of these cars, dual exhaust.
Yeah, the muffler and exhaust are separately addressed.
I think, Mr. Chairman, I think if you were to say ETV must have installed devices which are able to monitor and govern all sound applications to be compliant with 92002B. That will cover that. I've spoken to many sound engineers. I've been given different information than you just described, but that's fine. Different people have different opinion. But I think if you'll make, and then we'll eliminate the second sentence, that should achieve what we need to be able to enforce this.
And any factory vehicle that's not modified should have an issue. That's a federal thing. So we're untouched. Just want to make a note of that. Thank you.
Thank you. Thank you. Would you like to make a motion?
Your advice, Mr. Fields, is to eliminate the second, okay, got it. ETVs, so I guess I'd make a motion that 090 sound B is modified to state ETV must have installed devices which are able to monitor and govern all sound amplification so as to be consistent with Title IX, Chapter 20, 020, capital B of the Metropolitan Code of Law, period. Yes. We would strike, these devices must be able to be locked to allow no tampering or raising the sound above approved levels.
I second that motion.
All those in favor?
Aye.
Aye.
Motion passes. All right, I believe that concludes the continuation from last month's meeting in which we enacted several rules of the commission governing entertainment transportation, and that takes us now to reviewing entertainment transportation company applications and invoking our new rules in which we consider whether there's a public convenience and necessity for entertainment vehicles, with a subcategory also for seated sightseeing and charter tour vehicles. Mr. Fields?
Yes, sir. In order to, I'm going to get the applications. Let me defer to Ms. Costonis in terms of the idea of the need to make a determination on certificate. Yep. Or would you like me to describe it?
I'm fine with describing it. So we just adopted a rule, or you all just adopted a rule a little bit earlier to actually make 2 distinct findings of what the public necessity and convenience requires. That is now in section 010, and it again references the definition 040B of the seated sightseeing or charter tour vehicle. And basically, you'll make one determination for all ETVs that's based on A, which is the consideration of any applications to receive a certificate of public necessity and convenience to operate an ET company, ET, or to consider requests from existing certificate holders. So you would make, wait, that's not quite right. Okay, so maybe that's in the code. I think that's in the code, actually. Okay, so in the code, it requires you to make that determination. Do you have a copy of the code printed out? I might have it up.
Yeah, I think we would have brought a hard copy.
Okay, excellent. Okay, so 677. Okay, yeah. So basically, 677.020 basically is the requirement to have a certificate if you're going to operate as an ETV. And 677.030 says, if the MTLC finds that further or additional entertainment transportation vehicle service in the metropolitan government area is required by the public convenience and necessity. So you're making that finding twice under the rule change. So you make that finding once for all the rest of the types of ETVs, and then you make it separately for the seated sightseeing and charter tour vehicles. So that way you might say, like, you know, and you're going to have a public hearing, so you're going to hear from people about, like, you know, what the public necessity and convenience is, and based on that evidence, you can, you know, you can also hear about, like, traffic conditions, whatever is relevant to it. And I would say, and I've said this before, so you probably know, but just at the risk of repeating myself, I would say that I would interpret the public necessity and convenience not to just mean like the tourists or customers of these businesses, but to mean, as I think the director said earlier, and the mayor certainly said last month also, all of the people who live and work downtown as well. They are also part of the public. And so if you make that finding, so you might find like the public necessity and convenience, I've always done it with other sections of the code as a prerequisite finding. So that basically, and we did this for taxis, we've done this for other types of vehicles as well. Basically, you hear the evidence and you make a finding like the public necessity and convenience will justify adding X number of ET vehicles to the metro area. And then once that finding has been made, then you make the second determination, which is
030.
Hang on just a second, 030. And that the applicant is fit, willing, and able to provide such service and to conform to the provisions of this chapter and the rules promulgated by the MTLC. So that's a second finding you're going to make when you hear from all the applicants. Like, some of them may be better qualified under that standard than others are. So in making that finding, you know, you may use that distinction to decide who gets how many permits out of the overall number that you decided the public necessity and convenience requires. Is that?
So we're at the point where we are actually going to consider the applicants?
Yes, but I think they have a right to be heard.
I think what the idea would be that each applicant would have an opportunity to share, basic information, but more than that, actually answer questions from the commission, because it's really, they've already shared the information through their applications. I think this is a place where you look at a minimum of the 10 things where you ask them questions. For instance, their ability to comply. Have there been issues in the past? Have they had a history of violation? What's their experience? Are they a brand new company that's worked for 6 months or a year? Or have they been here for 20 years? And at that point, you start working through that. And then the other issues beyond that is the information you've already gathered about traffic flows, about, what do you believe based on information that's been provided to you, how many vehicles should come on, which is exactly what you've done previously as we've started up new industries over the last 15 years.
All right, so Billy, under the rules, we're supposed to have a public hearing first to determine the public necessity and convenience.
I'm sorry, sir.
So that under our new rule, we need to hold a public hearing to determine public necessity and convenience first before we consider the applications.
Open the public hearing.
Right. All right, well, at this point in time, I'm going to open the public hearing.
Mr. Chairman, before we do that, may we please have a little
You want a comfort break? Okay, that's actually a good recommendation. How's 5 minutes sound?
Yeah, that'd be great.
All right, we're going to recess for 5 minutes. For allowing that short recess, we're going to resume
folks,
our
we're
meeting.
starting back.
Given that it's already 5:30 this evening, it's clear we're not going to complete our agenda, so we're going to poll the commissioners. We're going to hear from the applicants tonight on their ET company applications. We're going to poll the commissioners about a special meeting that we'll have next week, so we can decide the issue and have the public hearing, and also consider all the applications. But we do want to hear from each of the applicants tonight over the next hour or so, and then we'll wrap up. Mr. Fields?
Yes, sir. What we'll do is just do an alphabetic order of the hearing. The applicants, you'd want to come up. You have a couple of minutes to describe, if you want to describe your business, then be prepared to answer questions from the commissioners.
All right, I'll call Big Drag Bus.
Representative for Big Drag Bus.
And don't, just because you're not here, don't take that to assume that that's some kind of mark on the application. We're giving you an opportunity to speak regarding your application. Big Green Tractor Tours, LLC.
Hi.
Hello. If you'll please introduce yourself and try to be brief. We've got about 25 applicants, but we'd like to hear from all of you.
My name is Ronnie Heatherly. I go by Ronnie. This is my son, Cody Heatherly. This is Joe Bryant.
My name is Joe Bryant. I'm one of the owners of Big Green Tractor Tours, but I'm kind of finance and stuff like that. They do more of the operations. I'm kind of the guy behind the guys,
All right.
so they'll probably answer more questions for y'all, okay?
Thank you.
What do you want to know? We'll give it to you.
No, we wanted to give you an opportunity. The commissioners my fellow commissioners may have questions for you, but.
Okay. Technically, we have had this business since 2016 by court records. We started this particular business in 2018. We don't even start running on Fridays till 6 o'clock, and we're out by 11. God willing that the traffic is down to where we can get to our place and drop people off and get out of town by 11. Saturday, we only work Friday and Saturday. Sometimes we work a Sunday or Thursday if it's a corporate. Saturday we come in at 1 o'clock and we're out by 11. We're never working during the day. We're never by the schools. One of the good things that we like is that we give the disabled veterans free rides just for their service. We are a handicap wheelchair accessible. We have entertainment tonight. When they come to town, they come to us when they want to shoot their shows. So we have, you can speak anytime. Go ahead.
I mean, I just feel like everybody that comes to Nashville doesn't come for country music specifically, and a lot of people, you know, don't speak English. Like we get a lot of Hispanic-speaking people that say they get to bring their family somewhere that they can enjoy the music that they like to hear without being stuck in a bar, kind of not hearing music that, you know, more of the stuff they want to, you know, hear.
I think what he's ultimately saying is that we cater to different genres of people. Anybody that gets on our wagon, they're ultimately with their friends and family. And that's what a lot of people come here for anyway. There's only so much country music you can hear, I guess, downtown, even though that's what we are. But like I said, with the years of experience, we've got it since 2016, ultimately 2018 with Big Green Tractor Tours. All the rules and regulations that you all have put forward, we're fine with them. We're already actually in compliance of all that. Anything new in addition that y'all have added recently with the enclosures and everything, that's fine. We've got it done. I think ultimately in the last 4 years, the only ticket we have is a mask ticket that somebody got when the city still had the mask mandate. So, you know, we're not a hazard at all. You know, we've never had an incident, you know. I mean, everything that you all have put forward, you know, we're fine with it. I guess that's what, you know, what we're trying to say. Like I said, if y'all have questions for us, you know, feel free to ask. But like I said, I think until you do something to not get a permit, you know, I don't know why, you know, we wouldn't be considered. So.
One question.
Yes, sir.
You guys use your equipment for anything other than the tours?
You mean like
your tractor?
Oh, no, sir.
Oh, no.
No, my family, no, we have our own tractors on my family's farm.
It's
No.
strictly,
Yes, sir, strictly for the, for the
strictly
business.
for that. And as far as y'all saying 21 and up, we catered to families.
Yeah.
All the way down, because some families want to come in and they don't want the jumble of going downtown on Broadway. They want to get on the wagon. They have their 5-year-old kid. They bring a couple beers. They have a designated person who watches kids. They listen to music, and that's their family time to run around, see the stadium, see downtown, and they're out.
Yeah.
So that's why when you guys said 21 and up, we were like, well, there goes the family tours.
Yeah,
You know?
and my cousin did her 16th birthday party on it. You know,
Yeah.
she can't go to Tootsie's and hang out all afternoon, you know,
Right.
so, you know.
It's only 21 and up if there's alcohol. So
Right.
Yes, ma'am. Yes,
Right,
ma'am.
so that's, I mean, some people, they bring their children and they can't go to the bars, so they'd rather just go on there and hang out, see Nashville, have a couple beers and be on their way.
But yeah, we catered to everybody. We had a church group, you know, a few years ago, so anybody that wants to come, yeah, we're open, you know, for everybody.
We had the news, had the 13th daughter's birthday.
Is that okay?
Where do you guys kind of haul in and out of or load?
Where do we pick up from?
Yes, ma'am.
On 4th Avenue, behind the liquor store over there.
Where?
4th Avenue South.
South around.
And we have porta potties over there, so a lot of times if we have smaller groups, we potty break over there.
So you're on private property?
Yes, sir.
And where does everything go at night?
What, trash or our rigs?
No, ma'am, where do you store your equipment?
The rigs, we take them over off 1st Avenue. We have a parking lot
Yeah,
over there.
we're partnered with the business over off of, I guess it's Gallatin and Dickerson. So it's
Yeah,
across
Dickerson,
the river. It's
yeah.
across the river on Dickerson, and we partner with them and pay them a fee. It's enclosed, it's locked up, and everything's safe there too.
Do you stop during your tours? Or
An hour in, we stop to let them go to the bathroom.
Where do you stop?
We either go to TA, the truck stop, or we go back to our porta potties over there on 4th Avenue.
Or do you do it at TA with their agreement, or?
Yes, sir.
Do they charge a fee? Or they just want you to come and?
Well, no, because people might go in there and buy a snack or.
Does anybody else have anything curious about, just anything?
Thank you very much.
All right, cool.
Thank
Thank y'all.
you.
Appreciate it. Thank you.
Let me ask one, how many vehicles were you operating a year ago?
Two. We've had two since 2019. We had started with just the one in 18, and then within a year we got the second one. That's all we have now, though. Cool. All right. Thank y'all.
Thank you. Dixieland Tours LLC.
Dixieland Tours LLC.
Extreme Experience LLC.
Hey y'all,
Hello.
I'm Tiffany. I'm from Extreme Experience. We also have a shuttle company as well that's under this branch, but it's called the Nashville Shuttle. So anybody have any questions before I get started? Mainly, our biggest thing is we're enclosed. We do have an open bus, but it does have the plexi on the side. We have the rails. We've been running since 2019. We just got our second bus, so it's enclosed. It has the air condition, heat, all those things. Our buses are stored over actually by the lake. I think our people are gone that there's several businesses over there. We store our buses over there at a storage facility. We do more than just the downtown circuit. We also do airport pickups in our vehicles, so that kind of sets us apart from the rest of the crowd. People like that party bus to pick them up at the airport, especially your bachelorettes. We do a lot of like 50th birthdays, 60th birthdays. To date, our oldest passenger is 85 years old. Yeah, she was probably the most fun, actually, if you want to know the truth. So we're a little bit different than most. Obviously, we do downtown, but us being enclosed, we're a little bit different.
Where do you load and unload?
We load and unload over at the old Shoney's. We have a contract with, it's Nashville Hot Kitchen. That's our meetup spot.
Across the river?
Yep, across the river.
On Woodland?
I'm sorry?
On Woodland, is that when you're talking about?
It's actually, the address is 110 Interstate Drive. Yeah.
It's right by the stadium.
Yeah, right by the stadium.
So you guys, I noticed here that you guys are you said you just bought your second bus, but you're requesting 3 permits. Why is that?
Well, because we also have the shuttle. And people like to drink on our shuttles when they go to like Arrington Vineyards, when they go to, we do weddings, all of those things. All the things that you were saying before about if it's going to be an entertainment vehicle, are they going to be sitting? Well, no, when I pick up a wedding party, believe me, they are not sitting when they get back on that bus. Every groom's dad has already had 12 Bud Lights, and they're ready to have a good time because, especially the bride's dad, because they paid for it.
2 buses and a shuttle.
Yes. We also do a lot of giving back to the community. We're a Metro Police community partner. So we do a lot of their give backs for the back to school bash, the trunk or treats, things like that. We work with them every year, and we also do a homeless give back with them every year.
You may have said this and I missed it, but how long have y'all been in business?
Since 2019. We never had a citation, never had a ticket, never gotten in trouble for our sound, knock on wood. Any other questions? All of our drivers are certified. We have 200-mile, million-mile drivers. We have a ex-police officer that's one of our drivers. All of our staff is certified. We have 2 school teachers that work with us every weekend.
Thank you very much.
You're very welcome.
Flanagan Tours LLC, Experience Nashville.
Flanagan Tours.
Freaky Tiki LLC. Gray Line of Tennessee.
Thank you, Mr. Chairman, Commissioners. My name is Derek Free. I'm Executive Vice President, General Counsel for Gray Line of Tennessee. We are excited to celebrate, Lord willing, our 50th anniversary next year. We started in 1973 in the back of a Woody station wagon, and things have grown a little bit since then. We are the only double-decker, we run the only double-decker tour buses here in Nashville. I appreciate the commission and their thoughtful and thorough efforts to provide a regulatory scheme that is fair and effective for everybody involved. We employ over 250 people here in Nashville, a lot of drivers. We also, in addition to our sightseeing division, we have a charter bus division, a school bus division for a number of charter schools here in Davidson County, and also run a black car division, which has been under the watch of TLC for a number of years. We've not had any trouble with TLC. The staff has been excellent and easy to work with, and so we're just excited to stay around for another 50 years here in Nashville. Be happy to answer any questions. Load and unload, that's been one of the questions. We load and unload at the Court of Flags at First and Broad, so Grayline staffs the train station through a partnership with MTA. We do the RTA's train, sell tickets for the train there, and so we rent that space. We work with RTA, MTA, and we load and unload there at the Court of Flags at First and Broad.
Any questions? Thank you very much.
Thank you very much.
May I ask,
yes, sir.
Mr. Chairman?
Yes.
May I ask a question? Yeah. You would consider yourself sightseeing. There is no alcohol in
Thank you.
anybody's seat.
Yes, that's kind of a big deal. Sorry. Yes, we do on our sightseeing tours. We do not allow alcohol, and we also require all passengers to be seated. The double decker. There was some conversation earlier about the capacity on those vehicles. The capacity is around 80. I think about 30 of that is downstairs, about 50 is upstairs. All of those are seat belted upstairs. The rail height, and I appreciate the commission thinking through the rail height piece. The rail height's actually 46 inches, according to my tape measure that I've pulled out over the last few weeks. So I appreciate that accommodation. But that's also, as was pointed out, that's with folks sitting down. And so if you're driving beside us, you're only seeing the tops of somebody's head, possibly. So safety is obviously our number one priority, as you might imagine, as we're carrying around 56 souls in all of our charter buses and 80 plus in our double deckers. That is and will always be our number one priority.
Just looking at Q6 on your application, is the majority owner of your company Mike Schmerling?
Yes.
See, do you know what percentage off the top of your head?
I do not.
Are all those entities related to him?
No, sir.
Not Tennessee Technology Development Corporation, but XMI Clearbrook is Gal Transportation LLC?
So that's Grand Avenue. That's a successor
Avenue.
in interest to Grand Avenue. So Grayline acquired Grand Avenue and its black car division 6-7 years ago. So Carl Haley, who was the owner of Grayline, is also part of our team. Yes.
Yeah, Mr. Haley opened that as a black car service that we licensed for many years at transportation licensing. When Grayline was purchased or merged or whatever it ended up being, they continue to be licensed through the other division that you were speaking of earlier.
And you're already operating 12.
I'm sorry, 12 vehicles?
Yeah, didn't you answer 12?
Is that, I don't have my application right in front of me. You can probably tell me better than I do. Yes, that sounds about right, yes. Yes, because in addition to the double deckers, we also run with some of our minibuses, some of the other tours, and those do go, Homes of the Stars goes all around town, Discover Tour. We also do tours, as some of the other folks have indicated, out to some of the surrounding counties and other attractions. We partner with the Ryman, the Country Music Hall of Fame. Yes, sir.
Thank you very much.
Thank you very much.
Grayline LLC?
Gray Lion.
Not you.
Groove, yeah, maybe my accent wasn't too strong there. Gray Lion. Groove Line Transportation. Hell on Wheels, Nashville.
He just left.
He's coming back, but yes.
All right, if he's coming back, I'll come back to him. Honky Tonk Party Express.
Hello, Grant Rosenblatt, the owner of Honky Tonk Party Express. So I want to say thank you, Billy, and the TLC board for letting us come up and talk today. And I'll just kind of go through a few bullet points. If y'all have any questions, please feel free to ask, and I'll be receptive. We started Honky Tonk Party Express in 2016 when there was no other open-air vehicle on the road. We currently employ 63 employees and growing. We did over 100,000 guest tours last year. That's on the bus and our shuttle services, which has been rapidly expanding. We just invested heavily into a new depot, so we're not loading and unloading downtown. We've got a 10,000 square foot facility where we bring our guests in, and they are behind a fence with 2 off-duty armed security guards. They're checking IDs. Nice, safe place for them to get checked in. A few of you have gone out there and seen our facility. We're still working on the AC. That's good. That's coming. But so we made a big investment in that as well too. We actually partner with the Sexual Assault Center of Tennessee. That's been our charity of choice as of recently. We drug test all of our drivers, and so I wanted to talk about that too. So when we talk about the vehicles that are on the road, we are hiring CDL drivers that come with a P endorsement. If y'all aren't familiar with what a P endorsement is, it's one of the hardest things to attain. It's like being the 1%, the Top Gun, the Maverick, if you will, for party bus drivers. That's really hard to get. My insurance agent, who's in the crowd today too, will testify that one of our biggest barriers to entry is our high-risk insurance. And finding these drivers and having a clean background and clean driving is extraordinarily hard. And maybe some other folks will talk today, but getting a P endorsement is actually becoming very hard or harder in the state of Tennessee. So we're just very lucky that we get to have some of the best drivers on the road. We do shuttles. We've expanded into a shuttle. What we found is big group shuttles are a big thing in Nashville right now. Uber's really hard to get. Gas prices going up. So our shuttle business has been expanding along with our open air party buses that we've got there as well too. I can't even read some of my own handwriting. What makes us very unique is we actually build our buses in-house. We're one of the, if not only companies, I would say in the entire country that's in-house building our buses. So what does this mean for the TLC board in terms of safety? If there's a problem, I can rectify that. If we build a bus that doesn't maybe fit a certain criteria, we could go and rectify that bus. If there's a piece of floor flapping, moving, or something like that, we can go in and fix that stuff. We made that investment very early because we wanted to control the whole build process. I know that might not seem like much, but if you look at it in the grand scheme of things, it's pretty impressive. And it was a lot of risk and uncertainty doing that. And I'm very proud of what we've got. Also with our buses too, we have a lot of partnerships that we've built up, including NASCAR. We're doing a big event with them, which is doing a lot of stuff through downtown right now. I like putting this in here. Our favorite tour that we do is the 50-year-old birthday party. That's the one that gets fought over the most when we assign groups to that. So more on the safety, because I'll talk while I have the podium, is every guest that gets on the bus, they get a safety speech. They get ID'd. We use ID scanners and off-duty police officers. They get wristbanded. They only have to sign a waiver that is stating that they are 21, but we also give verbal instructions on that bus to the guests. And if anything happens, whether they're handing a cup of something over or whatever they're doing, the tour's immediately over. There is no refund, and the guests get fined. And every guest knows that this is part of the process. And our bartenders are incentivized to go and find these things. So we're trying to be the gold standard for what's on the road today. And I understand that there's been a lot of problems recently with some of the things we've all talked about here. And I would hate to have that reflected in what we're doing in our business. And we're trying to to be the leader in that and kind of show you how things can progress and go with that.
Excuse me, how many times have you had to stop a tour?
Not as many as you would think. Yeah. Not as many as you would think, but we did have to suspend a bartender recently because, they were at fault for something, even though it wasn't their fault, but they were still had to take ownership over that, and so it hurt, but we're not afraid to do those things because we want to be a good actor and show you like what this really can, this industry can do. And look, by chance, I started this. Like 2016, I could have never imagined today that it was going to grow into what it is right now. This is like insane to like look back and see what's going on. So I'm up here in awe sometimes, even though we're going through this kind of stuff. But
I have a quick question.
Yes.
You requested 35 permits. How many buses do you have out at one time? I mean, are there 35 out at a time?
We have 34 buses that are in our current fleet. Those buses will also rotate in terms of necessity, meaning use. So sometimes they're coming in for 30 minutes. Sometimes we keep a reserve stash also too, so we can rotate them out. a lot of what we're finding too is getting some shuttling and the tours. We're seeing that these sightseeing tours, like some people have mentioned Arrington Vineyards tours that we're using for these vehicles.
I'm sorry, but some of these 35 beaches for the sightseeing tours.
So
they're
all doing. We have shuttles that are in that fleet as well too, as well as in there. And so.
Well, of the 35 you're seeking, which are you? I guess you need to subdivide that number for us now that you've seen that we've enacted a rule that makes a distinction between a general ET vehicle and a sightseeing vehicle.
Yeah, and since that rule was implemented today, that's what I want to go back and say, like, hey, this is what we have that are running on the road in terms of that open-air bus. Here's what we have in reserve for some sightseeing tours as well, too, and here's what we have for some shuttling service as well. At the recommendation of Billy Fields, we just put every vehicle that we've had tagged, licensed for the last year, put into this. And I've made it a point to reinvest in the business and to grow it, and that's what we've done here today. And yes, those points of interest would be something that we'd go back and look at. I did have a question, and this was something that I wanted to actually bring Clement, our insurance agent. It was just on the liquor liability portion of that, and I just wondered if it was okay for him to just quickly speak on that, because we have gotten a clear answer on it, if that's okay.
What's your question?
We are looking for a standalone liquor liability policy that I believe that y'all have either implemented or about to implement on that. And we've sent an email to Mr. Billy Fields, and we've gone through at least 38 companies that have denied that request because it simply doesn't really exist yet. Or it's a risk when you're just a BYOB, so there's no money in the insurance company to fund that. And we've been very transparent with the companies that we've had and sent, and we're just having a heck of a time trying to find this stuff. And so, I just didn't want y'all to hear it from me. I wanted to hear it from the guy who makes his living off finding this insurance stuff. It doesn't mean that it can't be created once rules are enacted, but we would have to have that time to have that rule so the insurance can kind of catch up to rules that are being enacted. And that's what we're finding is there's just not a whole lot of necessity or need for this thing, so the product doesn't really exist.
Which is it, 030E?
Yeah.
Because right now, under the new rule, you need to have liquor liability insurance of $1 million issued by an insurance company qualified to do business in the state, naming the Metropolitan government as an additional insured and complying with, in all other respects, with the terms of the section. Yeah, we're happy to hear from
Yeah. If you don't mind, that's
yeah.
okay.
If you'll please introduce yourself.
Yeah, my name is Clement Ledbetter. I'm their insurance agent, like he said. I sent Mr. Fields an email. It outlined all the MGAs, which in insurance speak is like a brokerage house. So instead of me having to be individually contracted with each carrier, I contract with an MGA who is then contracted with all the carriers. I think I sent, how many was on there? 8, maybe 9, who they reached out to. The last one I received back said for no amount of money would they consider doing it. One said that if the state required the insurance companies to provide it, then they would provide it then, not requiring the honky-tonk to have it. It's got to be required by the state that they provide it, similar to the way workers' comp insurance is in Tennessee. I even went to bonding houses to see if we could bond a liquor liability policy and have them put up, $250,000 in collateral to write a surety bond for it. No dice.
So it sounds like at a minimum, the companies are needing a period of time in which to acquire the policy after the rules are enacted.
Yes, but more than that, they want y'all to require them to provide it.
I don't think this commission has authority over.
I don't.
It would take a form
Yeah.
from the Commerce and Insurance.
Yeah. So we can require it of the permittees and certificate holders, but that's it.
But what the insurance companies have told me is they would have to be required to provide it.
Different commission.
I'm sorry?
Kind of like flood insurance?
Yeah.
And that information it should be in one of those email packets that you've gotten in the last couple of days.
Right.
Yeah, I mean, I've spent the last 6 months more time than I probably should have for them, but
Insurance and Commerce is, I believe, where you would need to go with that.
But they don't have authority to do it. It'd have to be in statute. I'm guessing.
mm-hmm.
Well, it would be something that would come back to the rule and hold it in abeyance until such time it would be available. Again, it is available for the pedal carriages. Obviously, it's apparently a different market.
Yeah, and that's what we found is what they said with the pedal taverns is they are low-speed vehicles that don't go on the interstate, that haul less people, and, you know, I guess you're working off the alcohol while you're pedaling around, and they're consider them more safe, I guess, because they're not going to get up to a higher speed.
Underwriters.
Certainly something we could visit at your special meeting.
Right.
I'd be curious, as you're thinking about that in the special meeting as well, would a larger umbrella policy cover?
It's going to be excluded on the general liability. And an umbrella policy follows form. Follows form. So if it's not covered in the general liability, then it would be excluded under the umbrella.
And you did explore bond as well?
Yes. Yes, sir.
And just not available?
Nobody would bond it. Next step will be possibly forming a captive to do it, which would be basically a self-insured plan. And I'm working on that now, but those things take time.
Sure.
All right, well, thank you, Mr. Mr. Clement?
Ledbetter, Clement Ledbetter.
Thank you.
Thank you.
And I know I've taken a lot of y'all's time again. Thank you all. And I will let some other colleagues speak for it too. But you know, just addressing the elephant in the room is the enclosure piece of what we're talking about and going through. And I'll just say from my experience, having that enclosure not only will take time, money, and effort to put in, but also the vehicles that I operate only. They didn't even come with AC units. They were school buses. They were the windows that were hanging down. Our drivers do open them for better sightseeing. They also have for airflow. You know, my big concerns with having an enclosure is obviously going to be the safety aspect of heat, but also what happens if an AC unit goes out, or it is, to my other colleague's point, where we enclose them and we can't cool these things down. Then are our guests the ones to pay the price for that? Or are there other solutions and remedies or maybe solutions that we can find to do that? And you know, these are big questions, and I know it sounds very easy. Just enclose them and put an AC unit in there. But it's not that easy. There's a lot of engineering that has to go into that, welding, engineering schematics. I mean, if we put tempered glass on the side, are we going to trust whoever to put that on there that it's just not going to collapse on the street and fall on a car? Or I mean, I'm not trying to be a bearer of bad news on that. These are just questions that we're asking on that. So that was.
You said you built all your units in-house and you can adjust them to whatever needs, and that was one of the things that set your company apart.
Correct.
Have you put an AC unit on any one of the units that you have to test that?
We've looked at the way that would have to cool that, and we've also had some people, Billy Fields has some emails that we've talked to some engineers from Boeing and FedEx as well too, and they're coming back that these things are built and already pre-engineered. Remember, we started business in 2016 to be these open air concepts, so we've extended the roofs out, we've put clear plastic on the sides as recommended by the TLC board, and it's basically turned it into a greenhouse. And then when you add standing bodies there, they're also putting off body heat, dancing, moving. I mean, these things will get up to 18 to 22 degrees hotter than the average temperature outside. And we can try to look at cool those things down. I'm not really, I don't have the greatest faith in that, just from, again, engineers coming back and saying, like, this is what it's going to take, and it's probably not even going to get what you need to. So that I do have concerns on that. And, you know,
have you looked at the schematics for a reefer unit? So in the DOT world, you know, you have semis that haul vegetables, ice cream, everything
Thermo
else.
King.
And they have a huge reefer unit on the front of them that cool that entire unit. Now, they don't have bodies in there, but what's being placed...
They go to zero.
But there is engineering and design there, and if you're building out your units, you might be able to set the standard for everybody. I mean, I'm just asking, have you tested anything?
Yes, we've gone to Thermo King and asked about that concept and looked at it. One, they're not gonna touch that with a 10-foot pole, but the amount of electricity and engineering that would have to go behind that. I mean, we do open air party buses. I mean, we're just giving these guests, an experience and something that they've been in demand, and now y'all are asking us to basically build a house on wheels and recreate the RV. At some point, when does it become impossible? Or when does it become insurmountable, or to the point where we're just putting things together to appease the board, but in reality, like, these things are gonna fall apart or something? I don't know. Like, I don't put in industrial grade freezers on trucks like that. And so, I just come to the board and say, like, I understand noise is an issue. Can we come at it with the scalpel versus the hammer? And I feel like the hammer is being used right now, and instead of just going all in, you have the authority to start piecing this thing together, and if it doesn't work out, we'll start punishing the companies. And I promise you put fines on that, you put some heat on the companies that do it. Billy knows. Sometimes he'll give me a call, and I'm like, Billy, I'm on it, and I'm up out of bed, or I'm handling something that he's been told on. But that's the way I would want to look at it. I just would hate to see what has been built by a lot of these guys, and they're all small business guys in here, just packaged up and saying, like, well, that's it. I'll just put an AC unit on it. Like, it's that easy. Like, y'all figure it out. Like, it's really not. It's a lot of money and investment. And, I would just say, like, please take that into consideration. Like, we're trying to be really good actors, at least most of us. And the ones that can't be good actors, they'll be gone quick. And, that's what I'm here today. I will try to my best to be a gold standard and show you how it can be done logically, reasonably. But, we can't, we can't do the impossible. And I feel like doing all this is asking kind of for the impossible. And again, I've talked a lot, and some other colleagues can testify to that as well too. So anyways, I just want to thank y'all for y'all's time.
Thank you. JCJ Transportainment LLC.
JCJ Transportainment.
Magic Trolley Bus Glammys Party Liner.
Did Hell on Wheels
Good
come
evening.
back?
I'm here, yeah. How long
I'll call on you next.
Okay.
Made it back. I can sit down if you want to.
That's all right.
Okay. All right, well, most of you know me by now. My name is Jay Sanders. I own Glammy's Party Liners. And most of you have received 1 or 2 letters. I sent you a letter, I guess, the last time I passed it around. I sent you one this morning. Hopefully you've had time to look at it. We've talked about some of the points that were brought up in that. We are a exclusive point-to-point transportation company. So we saw what was downtown with party buses and entertainment vehicles. We saw, like my peer and friend Derek, with Gray Line, where you have charter tour buses. And there was nothing that brought the glamorous edge to Derek's type of bus. And so our bus was born. And so I come out of the transportation, school bus transportation in Rutherford County. So I had school buses there, ran them since 2016. I've been an operator. During the pandemic, they condensed the routes, and our contracts were no bid and went to people who would do it cheaper, and we turned them into commercial buses. So our peer, Grant, mentioned CDL drivers. I'm a CDL bus passenger school endorsed driver. I've been driving buses for almost 30 years. My relief drivers, which I haven't actually hired yet because my other bus is not complete, but then I'll need other drivers, so I'll have drivers in rotation. They also come out of the school bus industry, 15, 20, 25, 30 years, spotless records, used to driving 90 passenger buses. That's 90 plus the drivers, that's 91. So these buses are regulated and federally created and regulated by the National Transportation Safety Bureau. That bus is one of the safest buses in the world, 400 times safer than your automobile. You run 400 times more risk taking your child to school than I do in a moving bus with standing people. It's about physics. It's about the weight. It's about the stability. We chose the biggest platform you could choose for accommodation, but then we shrunk down the number of passengers down to 32, which we can seat. We have a restroom. We have 3 air conditioning units, but I have a roof to put them in. Not a dig on my peers, but you know, when you take away that, you have no other place to put it. And so ideas for truck refrigeration units, well, great, you'd be taking out your back emergency exit on a school bus to even accommodate anything like that. So that being said, I didn't cut my bus away at all because I wanted to do long haul, point to point transportation. So when I created this company, it was looking at Derek because I went and did some driver training with Derek's company and with Grand Avenue. I'm always learning. We school bus drivers, we go to meetings, continuing education meetings with the Tennessee Highway Patrol just to get all the current data. We do that every year just to keep the license that we have. So there's not a night that goes by that I don't think about being behind the wheel, especially carrying our children. I have 6 children, 4 of my own and 2-step, and then 3 grandbabies. And they get on buses. And I carry everybody's bus. I've carried 2, almost 3 generations now of children to school. So this is a very important thing for us, and we created our situation where we changed the inside. I added air conditioning, I added lights, and I added sound, and I actually took the actual seats, which are rated for 3 people per seat, and covered them in black patent leather and 6-inch bullion, put in 24-karat gold metal flake in the floor, hung chandeliers, padded, did everything possible. It's the bougiest bathroom you've ever seen in your life. And the point is that somebody has to bring something exceptional. Somebody has to set a standard, and I didn't see any of my peers doing what I actually do. So I run 5 counties. I'll be out there in Gatlinburg and Pigeon Forge, do a wedding. I go to Shelbyville, McMinnville, Jolton, Franklin, Brentwood, Arrington, College Grove, Tullahoma. I'll take them anywhere that they want to go, but I never go anywhere without a destination. And so I'm a point-to-point. The law that enabled this council and what we're looking at today, which I'm sure when you signed up for this was not on your agenda. There's a lot of other things, and I want to commend you for everything that you deal with and that you're here as citizen commissioners to do this kind of thing. I think that's very important, and I commend you for that. But that being said, I'm everywhere else. I've been here 5 times since the last meeting, and I can tell you exactly where I was. I'm doing weddings at the Parthenon. I'm picking up at your best hotels. And I'm carrying them all the way out to all these different venues, over 65 different wedding venues. The children's birthday parties I do, they start at 3 years old and they go all the way up to 15. We consider a 16 and up an adult birthday party. And the destinations, I've got 20 just for children. And we go, and we're partnered with them. We're revenue neutral. So in the letters that I've written you, if you've read them, you can clearly see we do the same thing over and over and over, expecting the same results, and that's excellence. I have a 5-star Google rating. I've never had a single issue. I carry children and families, blended, extended families that come from all around the U.S. and have family. They'll open Christmas on my bus. I do all the Christmas lights tours with my friend Mike at Dancing Lights of Christmas. And I got my own lane. And I go all the way through there, 5 minutes. Y'all wait 5 hours, you get on my bus, you're in there in 5 minutes. And you see it the right way. And just like when you walk into an Applebee's or you name it, if you have a glass of wine and your child is there, same environment. I use scanning scanning technology for licenses. Their parents are right there. It's a family environment. Or it's a corporate environment. I'm doing Ally 400, right? NASCAR. I'm doing, you name the event. I'm working for big companies, big families, and we have a lot of fun doing it, but we do it safely. We have set a standard that's different. I don't do what they do. When I say bachelor party package, they're going, to Top Golf, and then we'll go over and we'll go bowling up here. And you know what I mean? It's already predetermined. I spend as little time here as possible.
Can I make a suggestion? Do we have a time limit?
I spend as little time as possible here. And the 5 times that I've been here, I'm in and out. And I'm in every other county. And I come in here when I'm asked to. But I'm not spending my time down here. This is not where I want to be. I come because my customers need me to. But then I'm out of your hair. Pull all the video. Pull all your city video. You won't see me here hardly at all. And so looking at that law, I'm everywhere else. And I'm point to point. And I paid the $511.50 because if I truly fall, into that, even though I'm here as little as I am, even though I'm serving the greater good for all the citizens in the greater Middle Tennessee area, not just Davidson County. If I truly fall under that, then it's money well spent, and we want to participate. But I'm just simply not doing what everybody else is doing. And that's really what it is. I wanted to define that as a company and let you guys know that, you know, we did that in good faith to see what the laws were, because honestly, we haven't had a lot of dialogue with you. I've talked with Billy, I have a couple other people in the industry, but we haven't been able to really speak and really get down to the bottom of it. All these rules and things that you're proposing, you know, those things are changing. And we're trying to reach these bars that are put in place, like, for instance, general liability insurance. GL is not available, as far as we can tell, through hundreds of insurance agents or brokers in Tennessee for a brick and mortar only, not a school bus. Now, you may have it for a limousine, but that's a different product, and that has to be worked out with the insurance companies and legislated, because that's a product that they just don't go, okay, we'll do that. It's a different animal. So we've done due diligence on all of it. I've carried 1 million in uninsured motorists. There's no such thing as underinsured motorists in Tennessee. That's what we've been told. So uninsured motorists is 1 million. I've carried 3. I had 5. You guys changed it. I went to 3 because the policies, trying to get all these things, the premiums are outrageous. Even for a bus like mine, they know what we're doing. And they know I'm a school bus.
I'm gonna have to cut you short.
Sure. So those are the things that I want to present. But we thank you for doing this in the first place. We think there need to be rules, but we also don't want to be put into the same category when we're not booking parties and going in circles. I'm everywhere else, and that's simply the way we wanted to present it. And I thank you.
Thank you. Hell on Wheels, Nashville.
Geez, that's gonna be a tough one to follow. My name's Nick. I'm the owner of Hell on Wheels, and I think a lot of us get real nervous when we come up here because a lot of times we don't have a chance to speak, and you know, there's a lot of livelihoods involved in this, and this is our livelihoods on the line, so it's pretty nerve-wracking. So please forgive. Came a little better prepared this time. I've got some paper. So, long story short, I understand that for many years there has been frustration amongst locals with party tours, with party buses, and there's been this odd dichotomy of the tourists love us, the locals hate us. And you know, I understand the monumental task that this council has been, you know, set forth on with having to create these rules and regulations and balance what is a pound of flesh from a frustrated local with common sense, safety, and there's a lot going on. And so I understand that it's a loaded deck. Really the main thing that I really want to throw out there is, you know, like the human element, we're all different. You can categorize the industry ETC or ETB or sightseeing tours, but at the end of the day, this is the human element, and we're all different. We're all going to operate differently. We all, you know, approach business differently. With Hell on Wheels, it was literally started. We use military troop transport vehicles, and it was literally started to do good. You know, our tagline is "Party with a Purpose," and so very early on, you know, several years ago, before any of this came to fruition, you know, I approached and had a conversation with Mr. Fields and said, hey, I want to do this right. What rules and regulations do I need to follow? And those were my intentionalities from the very beginning. And his answer kind of was, hey, it's a weird time. It's a state thing, and they're kind of laissez-faire on the whole thing. So those are my, from the launch of Hell on Wheels, I wanted to be by the book. You know, we give a portion of all proceeds goes to the Homes for Our Troops organization. They're absolutely incredible. They build custom homes for severely wounded veterans. You know, we're very proud of the fact that over half of our staff is made up of incredible veterans of the Marine Corps. We do, the list of stuff that we do is really powerful. You know, we're partnered with Creative Vets. We sponsored a child to the Andrew Jackson Police Youth Camp. You know, for the past 2 years, we've donated a ride and a tour to the Metropolitan annual law enforcement talent showcase to benefit the Nashville Children's Alliance. Just yesterday, we were going around to all of the police departments and fire departments of this city and donating care kits to all the first responders of the city. Black Rifle Coffee Company booked the truck, and all day yesterday in the 100-degree heat, we went around to 5 different police stations and 5 different fire departments and showed the first responders some love. You know, it's not just bachelorettes and woo girls. On all of these party tours, people are celebrating things. They're celebrating life. I had a 10-year-old who his father was a Green Beret and wanted to have his birthday party on the trucks. You know, it's graduation parties. We've had people get married on the trucks, propose on the trucks. So I understand that it's a balance of, hey, what are the regulations? This is a unique, cool thing in the fabric of Nashville's story. I understand that in Vegas they're enclosed, or in New Orleans they're enclosed. These open-air party tours, if you were to take a poll of tourists, it's going to be consistently at the top of the list of things they want to do while they're in this city. So I guess I'll end it with, you know, we are small business owners. We have real employees that depend on the wages they make with our business. This isn't just paper and votes, it's lives and livelihoods. And I know safety is at the top of this, it's paramount. This is a busy city, things happen. I'm not finger pointing. A WeGo bus, a pedestrian was hit and killed. You know, there have been multiple deaths on scooters. This is the top year of pedestrian deaths in Nashville. None of those came from party tours of people having a good time. So I just want to end with that. It's a special, cool thing to be stored and not dismembered, dismantled, and suffocated. So thank you guys for your time. I appreciate what you're doing.
I've got a question. Where do you load and unload?
So we're partnered with Frugal McDougal. They give us free ice. Obviously, it's mutually beneficial. We have a home base to pick up on that shoulder in front. And, you know, our folks go in there and spend lots of money. We have a scheduled, I can tell you my route's very easy. We pick up at Frugal McDougal. Okay.
But do you stop during your tour?
Yes, sir, we do. We stop at 6th and Peabody, and that is a scheduled stop. They're aware of us. I have a good relationship with the general manager there. They appreciate us. Again,
I'm sorry, what is
6th and Peabody, Old Smoky Moonshine there on 6th and Peabody.
So it's private property?
Yes, sir. Well, we stop at the street up out of the way. You know, a lot of party buses stop.
On the public street?
Up by the telephone pole. If that's on a public street, then yes, sir. Yes. For a bathroom break. And I believe, what was it? The unloading zone was at 15 minutes. We always make sure that we're well below that. We tell them 10 minutes tops at the pit stop, so we're not there blocking the roadway.
Official loading zone?
Say it again, sir.
Is that an official Metro approved loading zone?
I'm not sure. It may be a bus stop. I'm not 100% certain on that. If you guys have any questions, again, I know all of us love to get up here and talk, but it really is a powerful part of the dialogue. You know, obviously, yes, we're fighting for our existence here, but also we do have experience of the ins and outs. And the final thing I'll throw out about the enclosure versus unenclosure, it's a very hot button topic here. Again, logistically, all of us have designed our vehicles to, people want open air. That's what makes it special and cool. And the railings, it's great. My wife does all of my admin stuff, and she put in my notes that she hears across the board, people would much rather have high railings and lower volumes any day over sweating in the enclosure. I did air conditioning when we had to have the enclosures there, and I just got one of those kind of windowless 10,000 BTU situations, and I had a big generator. That creates logistical situations and health things. The carbon monoxide coming off the generator, where you're out in that, and then the AC, like Grant mentioned, what if, you know, God forbid, what if that goes down? And I get it, some of these are on the business owner. It's like, hey, you started the business, problem solve. I understand that, but there is a fine line of when it's a health thing. It's obviously been very hot here in Middle Tennessee. It's been consistently near 100 degrees. If that thing goes down, I mean, back when it was high 70s, low 80s, it got dangerous back there, and my people were suffering. With that 10,000 BTU air conditioner going, and then 2 professional like air movers blowing air on people's faces, and people were suffering. It was very, very tough. The trucks with the systems, those are like hundreds of thousands of dollars. Trucks designed to haul stuff that are insulated, and the power source, the amount of power that it takes to cool something like that, unless you design it to be airtight, it's tough. It's just a logistical situation. So again, I know it's a very there's a lot of layers to this thing. So thank you for taking the time to speak with us and hear from us.
Thank you. MD Wright Transport, Music City Party Bus. Music City Night Life Party Tours. Music City Party Fire Engine, LLC. Nash Trash Tours. Nashville Bar Bus. Nashville Party Barge.
Trying to extend my parking. It's expired like 3 times on me. I was going to say good afternoon, but good evening. Susan Pizzatolo, the Nashville Party Barge. I'd like to begin to thank you, council members and Mr. Fields, for finally getting us here to this glorious day. I've made notes this time also to try to keep in tune with our normal 2-minute time clock. First and foremost, I want you guys to know that the Nashville Party Barge is a business. We're open 7 days a week, 365 days a year. We were the first entertainment company in Nashville to hit the streets of Nashville as an open-air concept. The Party Barge is not on the water, it's on the road. We get asked that a lot of times. Our motto is float down Broadway with us. Came into business, the previous owner, great friend of mine, Ray Smitherman. Billy's very familiar with him. In 2015, I took over in early 2019. Also want you to know that I am a woman, obviously, woman-owned, veteran-owned business. We are also a family-owned and family-operated business. My husband is also retired military. The Nashville Party Barge is our livelihood, just like the rest of these people in this room. My daughter's livelihood, which I have 2, plus 18 full-time employees and 4 part-time employees. We are not just here for the weekend or just for a piece of the pie. We've been around a long time, and we are a staple in Music City, also running with a 4.9 Google, TripAdvisor, all that rating, good stuff. We provide a unique way for tourists to observe the attractions here in Nashville. And as y'all were speaking earlier, we do also do other city tours. We do tours of the murals, the arts, wine tours, moonshine tasting, all the good stuff that Music City has to offer. We have also 16 affiliated partnerships around the world. We work with 16 different tourist companies, all the way from Japan to Germany, France, that send us customers. I have a guy just reached out from Pennsylvania yesterday, wanting to work with me. We also, just like the other ones in the room, and I won't list off my list because I have a huge list of what we give back to the community. I will say this Saturday is our 5th year supporting the Pride Parade. We drive them every year. We do a lot with the police too. We also do a lot of things with the veterans. The Humane Society is one of my top. I could go on and on and on, but I won't take the time for all that. We have also had no infractions, no accidents. I have served probably about 250,000 customers. I'm asking for 8 permits today. That's exactly what's in my fleet. Don't want no more, don't need no more. My plate is full. I want to take 1 second and reiterate again back on the others about the vehicles. We are all different. I mentioned this last time, the heat and air situation. I'm for it. And I'm for enclosed if I can accommodate that. 3 out of my 8 are enclosed. They have the heat and air. And we have numerous lately customers that are requesting that air. 5 out of my 8 do not. My vehicles are stretched pickup trucks where no room to put a generator, an air conditioning unit, heating unit, or nothing unless I put it on top of my driver's head. I called the #1 company in the city, which is Lee Company, Governor Lee's company, and they came out and they cannot accommodate me. There is no place and no way that my vehicles can accommodate what they're calling is like a 110 AVC voltage unit or anything to be able to plug into my vehicles anywhere or to add anything to accommodate that. I just don't have, I'm a pickup truck. All my trucks are Fords. I just put a new Jeep into my fleet this year. All my vehicles, even my buses, are all Fords. And there's no way 5 out of my 8 I can put a heat and air unit in there with enclosed. I sent Billy, I think, a picture, and my lawyer did a few weeks ago. We put a thermometer in there, and my vehicles reached over 120 degrees with the plastic down, which my plastics are all marine grade 6 mil plastics, and very hot. I'm willing to comply with it. I just got to figure out how. If that's what it's got to be, then I just got to figure out how, or I have to move 5 vehicles out of my fleet, which would be a detrimental loss in my company. Any questions for me?
Where do you load and unload?
I load and unload at my company business at 400 Davidson Street. If you're familiar with the indoor go-karting, the Nashville East Flea Market area, right across the river. Yeah, right across the river. I'm trying to think. And our stop is, I've had an affiliation with Losers Bar and Grill for about 7 years now. So that is now our bar stop, and it's on private property. That's our bathroom break.
Are you no longer doing, didn't you have
Pedal bikes?
pedals?
Yes, I still have them.
You still have
Yeah,
them?
I
as well?
still own the Music City Crawler, which is pedal taverns, pedal bikes, pedal carriages. Let me watch my words. Yes, I still own them.
Okay.
They're parked at the same location, and they operate downtown. Yep, been in business a long time. All right, thank you guys very much.
Thank you. Nashville Party Truck. Nashville Ultimate Party Bus. Old Town Trolley Tours of Nashville. Party Bus Music City.
Hello.
Hello.
How's everyone? Let me get my thoughts together here. I'm a 2-time wrestling state champion. And when I look at y'all, this is the first time I got nervous, so let me get my thoughts back together.
What weight did you wrestle?
171 to 189. All right, here we go. So, I want to start off by saying I was introduced to this business by a friend of mine, Mr. Grant. And I sold a house, and I had a dream to make this thing work. And just so happened, I was out there for, I think maybe about a week, and someone fell off my bus. So I just had to sit on that thing for a long time because of possible lawsuits. But it was nothing that my company did wrong, because I wanted to make sure that we did everything right. First, the railing, they sent the lasers out there, they did everything, they measured everything. So I was getting beat up for a long time because everybody kept pointing the finger saying, "You the bad guy." And I just wanted to assure everybody that we did everything right. You know, nobody would even know that it was my bus. You know, I come in here every day, nobody knew it was my bus that the guy fell off of. And I really felt bad that he fell off the bus. But I put a lot of money in that bus for that railing system. It cost me over $25,000, the guy that built that railing system for me. I worked really hard every day. I poured concrete for years on top of years to get this established. And I just keep hearing everybody say the buses are unsafe, this and that. And I'm just like, wow, what is it that we're doing wrong so we can fix it? I just want to fix it. I just want to hear what it takes to fix it. All I want to do is just fix it, because I've put a lot of money off into this. And so I'm trying to stay ahead of you guys every time you say make the recommendations, just because we're getting the bookings. And I don't want my customers calling and say, oh, because I get the calls, are you sure you're in compliance? Are you sure you're in compliance? I'm like, well, we ready for them, because they said put air conditioners on there, so I done went and spent $20,000 putting air conditioners on this bad boys. And then I figured out the air conditioners ain't doing nothing. I mean, when I say nothing, they don't do nothing. So I put the fans, I got a $10,000 generator up on there to push these big old units that I put up there. So I'm the only bus out there that's, if I'm not mistaken, that has the units up there actually right now. And with people on there, we're sweating up. I start the bus up an hour and a half early just to try to cool it off, but man, that sun ain't playing with that metal. Then you put 15 or 20 people on there oh my goodness. I mean, the driver can't, the fans on there for the driver is no good. So I say that to say, you know, I want to be in compliance. I call Mr. Beard, I call everybody, what is it that I need to do? But I've lost so much money trying to get in compliance, trying to figure out, okay, what is it that they want us to do? Because in my site, I'm saying, I'm doing everything I can to be in compliance. I'm the last person that don't want to be in compliance. I stick out like a sore thumb. I mean, I done had the police come up to my bus. I've been pulled over several times. I got a ticket for impeding traffic, and I'm trying to figure out, Uber stopped in front of me. What am I supposed to do? I don't even know what to do. I just stop and let all 4 doors open up, and then they write me a ticket. I'm like, wow, okay. So they really are hard on the party buses, but I can assure you, we're not trying, at least I know I'm trying to stay out of everybody's way. I just want to, my customers, they who motivate me, they tell me, this is the best time I've had since I've been in Nashville. They can go to bars everywhere, they can visit all these, and they stand in line with these bars. But they're gonna ride that party bus one time for 1 hour, either 2 hours, and then they're gonna go visit all these other bars. So I don't know what it is that we're doing, you know, just so horrible, where we can't even come together and try to make this thing work. I mean, even with all these party bus owners and stuff, we haven't even had the opportunity to sit with Mr. Fields and just round table with him and figure out what can we do. We've been out there so many years to bring it to so he could bring it to the table, the board, or whatever. But it's like, and I don't know if any one of y'all have ever ridden a party bus. I had a group of Belmont professors on my bus, and these ladies, they shook it. I mean, up to about, they had a really good time, you know, and because we know how to adjust to play the music that they want to hear, you know, and they just really had a good time. And so before y'all condemn us and say we this and we ain't doing that, I mean, do the undercover stuff like you do the Budweiser guy. I mean a beer boy guy. Sneak and just ride on the bus and just tell us what you think about it, because we want to be in compliance. I don't want to lose everything I invested in. I sold my house to make this thing work, and so I'm like, man, I just lost $30,000 because these air conditioners ain't working. So I don't know what to do. I mean, so. But like I said, I'm a new business owner, and I'm going to continue to do what I can do to make this thing work. And yes, I know I got a somewhat of a temperament because I done lost so much money downtown, because I feel like I'm the guy everybody pointing at, and I've been getting pointed at. It's because of you, it's because of you. And so now I'm just like, you know what? It is what it is. We just got to make this thing work. So that's why I'm at with it. So that's all I have to say. Any questions?
Where do you load and unload?
I rent from Linus 308 Church Street. Linus Karaoke Bar.
It's on private property?
Linus Karaoke Bar, it's on Church Street.
But are you actually loading on Lonnie's private property, or are you loading?
Well, it's on the street. He got
street?
Yeah, he has a bleacher out front right there, and that's where my clients sit, right there on the bleachers until we pull up. And sometimes
on the street.
Yes, sir.
You're on the
yes,
street.
sir. I have an office also, but it's 1451 M Hill Pike.
Do you stop during your tours?
No, sir. Only for the 1 hour. I'm sorry. We do stop for the restroom break.
Where?
At the TA.
You have a deal with them?
No, just go in there, just let them use the restroom.
Okay,
Yeah. Okay.
As long as they don't care.
You stop in the lane of traffic though, in front of lines, right? Not in the surface spaces that are across the street from it, but like right in front of lines.
Yeah, and so what we do, we have the young lady get off the bus with the party bus shirt on to be recognized, and she go up there and make sure everybody's ready, so when we pull up, we can load them on the bus. And sometimes that works, sometimes it don't, because 9 times out of 10, sometimes it's a lot of people late, and just they get the sticker shock of what it costs to park downtown sometime, and they just start flowing everywhere to try to get back in a timely manner. But we let them know that the clock has started, you know, but we want to be able to pull up there and load and keep going. That's ideal.
Does Lonnie's have a parking lot? Are you looking at?
No, I mean it's just on Church, on the north side of Church Street, between third and fourth.
You could park on top of Lonnie's, so they got the parking garage.
No, just like I think one of the things that we're always cognizant of is your bus takes up a full lane of traffic.
Yes, sir.
And if you stop for 10 or 15 minutes, there's not a way for traffic to get around you without going over the double yellow lines.
Yeah.
And so that's why I think people have been asking about, do you have a parking lot where you load?
Well, last year I did rent a parking lot on the outside of downtown, but when I was hearing the board, and I know it was just a recommendation that they, for its parking, I was thinking that I would have to be downtown, so I've been paying Lonnie $1,000 a month just to use his bench outside, just so I can have an address downtown to load. So I thought that was
You're paying him to park on the street?
I'm paying him to hold my customers there to let them know I'm coming back to pick them up.
It's on the sidewalk.
He has a bench that sits in the public right of way, likely
Yes.
without a encroachment agreement. And he's charging you for it.
You might need to talk to Lonnie about that.
Lonnie probably shouldn't have a bench that sits in the middle of the sidewalk.
Yeah, no kidding.
Because I bet it's not on his property. I bet it's in the public right of way.
Yeah.
And the place where you're stopping, I don't know what the rules are to.
Well, I think he's using his address more than anything.
He is, but I don't know what the rules are about stopping in a lane of traffic to load and unload.
But that could be an easy fix for me though. Just by me going on Google and changing some things, but,
That would be something to look at, but
Yeah.
you're not impeding traffic.
Okay.
Because like you said, one of the big things we're looking at, there's a traffic study that has to do with the flow of traffic and how, be it 1% or 5%, how it impedes the flow of traffic for Nashvillians. Because there's, 50,000-60,000 people live downtown?
There's 67,000 people who work downtown.
That work downtown?
And about 15.
And they're not all on the party bus, and when they get off, or when they're coming to work, 15 minutes blocking a lane of traffic is a huge amount of backup there. And I know you're not directly on Broad, but even where you are. So just as a consideration, and I hear you, you're spending money, you're trying to be compliant. That one particular thing would be something that you might want to look into.
Definitely.
All right, I'm sorry, what was your name?
I'm Ronnie Stevenson.
All right, well, thank you very much.
Thank you, sir. Have a blessed day.
Party Central Nashville AJ's Enterprises. Perks Party Bus, Inc. Rowdy Bus, LLC. Tan Assets, LLC. Oh, sorry, I didn't see you.
Sorry, sir. It's been a long day. Try to be quick here. So I'm the owner of Rowdy Bus LLC. We've been in business for a little over a year.
What's your name?
Chaz Barker. We started a little over a year ago with one bus. We've completed a second bus. One of our buses is kind of like the open air school bus style. The other one has the top on it and is built completely for live music, trying to get away from the normal kind of everyday thing that everybody else is doing. It basically is equipped with every single thing a stage would have in it, where we've just been having like guys come play guitars and do that kind of a cruise around Nashville. Safety-wise, our buses are all equipped with lead tracking devices, so following the routes, speed, stops, all that kind of stuff. There's a tracker on the bus driver at all times. They also have another security system that has like 4 or 5 cameras, which we could get access to anybody if you ever needed to be. In that time, we've done probably 8,000-9,000 customers in the first year. I have 25-30 bookings this weekend. Main concern pickup location, we'll get that off the table. I do use Frugal McDougal, but I use the parking lot that's off of the road.
I'm sorry, I didn't hear what.
Frugal McDougal. Currently, this is what I do. There's also a parking lot across the road that we use. And then Yeehaw Brewing Company allows us to pull in the front of their business, and they kind of monitor that with they have off-duty security guards and stuff that kind of monitor the traffic there and kind of work with the buses, because we all kind of use that location. It's great for us, it's great for their business, and so they all work with us to do that. I'm also
on their private property.
Yeah, well, it is on the street in front of their building, but they are sending their security guards out to kind of help monitor it and make sure everybody's moving forward and doing the things. I'm currently also in the process of securing an office location it's more the North Gulch area off at 8th Avenue, which I should have that done mid-month. Other than that, I would keep it short and sweet. You guys got any questions?
Do you stop during your tour?
We stop in the middle of the tour is at Yeehaw. That's our bathroom break. We do one.
You stop in the street again?
Yes, sir. However, both of the places that we do stop, they are out of traffic. Like, we're not sitting there in front of the middle of traffic where there's cars just honking the horn or doing something like that. We are out of the way. Like, there's no way that I could actually not get bad reviews and reports and things like that if I was just parked in the middle of the road where we're trying to go around and people are trying to get around.
How long do you kind of sit at Yeehaw?
Normally it's probably 5 to 10 minutes, but like I said, they'll have in front of that same street, there's going to be, on a typical time we pull up, there's going to be 7 party buses all right there in front of, and it's right in front of their building. They let it, I mean, they're doing it to, go ahead.
6 of them people out of your both 2-lane streets, so it.
Yeah.
6 or 8 are there at once?
Yeah.
Ms. Alarcon hadn't come after you yet?
No, because I mean, as long as it's not on 6th, it's on 6th is a little different. You can't really park there. Now, if you park right in front of Yeehaw, it's a 200 feet road, and there's not people going up and down it like that.
And just as a reminder to the commission, your rules are now very clear. There will no longer be any street parking. The only parking that's going to be allowed is on public property, have to be approved through traffic parking or on private property. So all that's going to be going away.
And I just real quick want to remind everyone, there is a deferral of any changes to the curve at this point until we complete Connect Downtown.
So private parking is going to be what y'all are going to need to do.
Next thing. We got it. I'm working on it.
All right, well, thank you very much.
Thank you, sir.
I believe I already called 10 assets.
I saw him walking up. You're actually covering 10 assets and TN Transport Holdings. 10 assets is what you guys refer to as the Nashville tractor, which is the big red tractors. TN Transport Holdings is another company that we've used in the past with this commission for the golf carts and some other stuff as well. Answer some of the questions you guys have already thrown out. We office over at 230 Cumberland Bend, which is Metro Center basically. We've got office building out there, warehouse space, repair shop. We've been there since 15. So all of our stuff, when not being used, is out of the way. Hiding 6 big red tractors is a little challenging, so we stick them back there basically by the riverbank. We are in the process, that building has been sold as they're building apartment complexes everywhere in Metro Center. That building is sold, so November 23, we will be out of that building, and we have acquired a space over at 747 Fessler's Lane. It's an old U.S. Bank building with a nice big parking lot. We'll be taking over that building, fencing the parking lot, and we'll have ample room for parking and storage and repair and what have you. We're also we've already negotiated it and have the lease on the property. We've got to rebuild 1034 4th Avenue South. That'll be a 10,000 square foot 3-story bar. That will be our pickup drop-off facility. Basically, it's across from the cemetery if you go down that direction. That will be our property to pick up, drop off, load, what have you. That property will actually be built to service transportation companies. One of the problems we've all had, we all have to mooch off somebody's property for trash, ice, parking. We've all fought that battle for years. So when I decided to build the bar, I decided to build it for transportation companies in mind. So it will have excessive ice capacity, excessive trash capacity, and a 3-story bar for people to hang out in while they're waiting for transportation companies, not only ours, but others. That's another reason why we also lease the U.S. Bank building, is we can help some of our counterparts with storage of vehicles they're not using. So we did all this intentionally to not only fix the battle that we currently have every day, but also some of our peers that are storing vehicles from the lake all the way to downtown just don't have a place to put it. And as you guys know, real estate in Nashville, if you're looking for an acre of ground anywhere, you won't find it. So we've searched for 2 years to finally nail all this stuff down. We operate about 3,000 tours a year.
You said you'll be going into that facility?
Yes, we currently, since 2015, have picked up and dropped off at Dock Holidays, right behind Wild Horse where they park their buses.
Okay.
So
when will you utilize the property you were just talking about?
Well, trying to get it done. We're renovating a 2-story building and adding a rooftop bar to it, so it's a slow, hideous process because we've got to build an elevator, whole 9 yards. So we hope to, by the end of the year, very candidly, be in that space. Dock Holidays has been an amazing partner. We love working with them, but as downtown changes, the bombing downtown, we've had all kinds of obstacles in the last 2 or 3 years with trying to pick up and drop off downtown. We operate a non-stop tour. We do not stop. We pick up and run. Now that may change a little bit once we have some of our facilities. We may change how we do some of our tours, but it'll be on private property, so it won't matter really from your perspective. We have about 3,000 tours a year, about 150,000 riders, plus or minus. So we stay extremely busy from Thursday through Sunday. And like most everybody here will tell you, we have probably 2,000 TripAdvisor reviews, another 700 Google reviews, and we are rated higher than most of the attractions in Nashville, from the Ryman to the Country Music Hall of Fame and everything else. People really do like these things, as annoying as they may be. We've had 3 accidents since we've been operating. All 3 of them was we got hit by a WeGo bus. We got clipped and they kept going. So we actually had to call WeGo and track it down based on the corner so they could tell us what driver actually clipped us. Those are the only 3 accidents we had, and those were just shaving paint off sides of cars. Nobody actually got hurt, and WeGo didn't even stop, so it didn't really matter too much. Those are our only 3 accidents we've ever had. Air conditioned, we operate 1 bus that is fully enclosed, good old-fashioned school bus. It has 11,000 watt generator on it and 3 air conditioning units, and it will freeze you. So you can take a fully enclosed old school bus and make it cold for about $25,000. Take the roof off, you're never going to get it cold. One of our wagons, we operate 6 Honda generators underneath our wagons, obviously the wagon being pulled behind the tractor. We operate 3 air conditioning units on the roof. You can't get it to chill when it's over 85 degrees with plexiglass. So the enclosure is a great idea. Glad to do it. I've already talked to welders, glass people, fabrication, all that good stuff. It will cost us $30,000 to $50,000 per vehicle to have those vehicles custom fabricated to actually hold tempered, tinted glass. That is the only way we can enclose these things and keep them cool, not to mention insulating the bottom sides and everything else, which we're glad to do. We happen to have a roof on ours, so we have to insulate the roof. There's some labor that go into it and probably 3 months of work. So I asked of the commission, while all of us are struggling to figure out how to do this, hopefully successfully, and we don't know until we build it, we will need a window to get these things done. Because I have to have an architect/engineer draw it up. I have to have a welder make it. I have to have a glass company custom cut and build glass with rubber bumpers and all kinds of stuff because we're a moving vehicle to make sure it doesn't shatter as you're rolling. It's a process. And then after spending all that money, we don't even know if it'll cool correctly until we do it. I know the commission's standpoint's going to be, not my problem, buy a new vehicle. I get that. But it's what we've got. And we're glad to try it. But I can tell you with plexiglass, there's no way to cool it. Tennessee, 7% of our ridership is Tennessee. 56% of that ridership is Davidson County. We have a lot of people that use us for pre-parties. They're locals, their friends come in town, because you have more friends when you live in Nashville for some reason. Their friends come in town and they use us to pre-party before they go places. The 4 to 6 window of being closed, I hate it. We can do it, we can abide by it, and we can change how we operate, but not a fan obviously, but we can make that work. You talked about permits earlier. BYOB is currently a permit. You have to, if you're going to BYOB as an enclosed vehicle, you actually still have to get a permit to do so. I don't think it's called BYOB. I think it's BYOB, bring your own or something. I forget what the permit process. They passed that in December at the Metro meeting, as well as mobile beer permits are allowed once you have a certificate from you guys on the enclosed vehicles. So all of us, obviously, once we get a certificate, if we plan to enclose, we'll be running to the beer board to try to get permits for BYOB or to actually mobily sell on board. Class A CDL licenses, currently there are 312 CDL schools in the state of Tennessee. When you sort that by which ones you can get a P endorsement, it's 12. So if you have a Class A CDL and you want to go get a P endorsement, 2 years ago you walk in, you take a test, you leave with your P endorsement, just like getting an F endorsement for a chauffeur's license. Today, if you walk into a CDL school, they cannot help you until August, and if you did not get your CDL there, they want you to go to a 4-week class to get your P endorsement for about $5,000 per person. So we are all struggling, obviously, trying to find qualified drivers that already have P endorsements. I can tell you we are running ads for very expensive pay and signing bonuses and everything else. All of our drivers, we paid for every one of their classes. We took all of our drivers, $6,000 apiece. We sent them to get a Class A CDL. We are now waiting patiently to figure out how to get a P endorsement because there are 12 places in the state you can get it, and none of them, absolutely zero, will see you to get a P endorsement currently. That's about my spiel, unless you guys have questions.
So you're saying that there are no CDL schools now that will give you a P endorsement, or they want you to actually attend their school to get the P endorsement?
I think if I remember the dates right, and Christy in my office researched this, February, I think the rules changed. So we have all of our drivers who went to a CDL school, I think it's in Gallatin, which is not a P endorsement certified school for the thing is Class A. Class B, the rules are much different. Once you're Class A, you're the king of the crowd. The P endorsement is much more challenging. We're doing Class A because of weight and all that kind of fun stuff that we haul. So yes, the school we went to can't do a P endorsement, and the schools that are in operation in Tennessee, as of February, if you did not have your Class A, but for instance, I've had one for 20 years. I could get a P endorsement anywhere because I'm grandfathered, if you want to call it. But if you got a CDL recently, if you do not go to a school that does a P endorsement, you have to go back to school somewhere that can do a P endorsement for a Class A CDL and do a 3/4 week class. None are available until August, even if you want to go. So currently we are talking to Homeland Security, Department of Transportation, anybody we can get a hold of to see, if there's anything that can be done, but so far I've got zero.
And you're seeking this because of your insurance requirement?
Well, we're seeking this because as a tractor, we've never been required to have CDL/P endorsements. Wasn't required by a city and or state. As the new rules, it is a requirement that has been thrown down, and we, as of December, sent all of our people to school to get CDLs, thinking very candidly that the P endorsement was what it's always been. You show up, you take a test, and you get a P endorsement, and off you go. Well, come to find out, the rules changed. So, P endorsements are hard to find. I can tell you for 4 months I've been running an ad for a $65,000 a year job with a $10,000 signing bonus, Class A CDLP endorsement. I've got zero.
Have you had any trouble with your insurance?
No, not required by insurance.
No, not with the P endorsement. I mean, we've heard from some of the people here that they are running into trouble. So you're able to?
Well, I see where you're going with the question on insurance. Sorry, I misunderstood your question. Insurance is challenging for tractors. And that's part of the reason why I think there's a subcategory. When we went to the insurance guy for the city, based on feedback he's got from insurance companies, when you take a school bus that was built, manufactured, engineered, and on the road all over the country, getting insurance is much, much easier. When you take an 11,000-pound farm tractor and pull a 14,000-pound wagon behind it, insurance is a little more challenging. So when you go to a high-risk insurance company and say, by the way, I'd like to go from $500,000 to $3 million or whatever the number is, there are no carriers. I found a carrier when this conversation first started that said he would do I think it was a $3 million policy. For 2 tractors, it was $300,000. 2 tractors. So I think part of the subcategorization that has happened in the rules is the fact you have to subcategorize also by what's available in the market. There is no $3 million policy available in the market for tractors pulling wagons on city streets. So the rules, I think, were spelled out kind of based on what's in the market, what's available. So based on the current rules, I think we're going to be fine. The $2 million in uninsured motorists was not achievable. I think the $1 million, got that out to my insurance agent, possibly is achievable. So I'm not seeing any major red flags, but yes, it's challenging. Liquor liability, whole nother story. I'm sure that one's going to be extremely challenging as well. Because I can tell you, my insurance company will absolutely not cover liquor liability under my current policies.
All right, thank you very much, Mr. Winters. The house party bus?
Good evening, y'all. My name is Matt Barocas. I'm an attorney here in Tennessee, and I'm here on behalf of Mr. Lillard, Justin Lillard, and the house party bus. I apologize. I didn't realize how long this meeting would last, and my phone died since I'm here. Mr. Fields, Mr. Lillard had prepared a statement that he's emailed to you.
And it's been shared.
And it's been shared. And so long as it's been shared, I don't have much to add. We're just going to rest on whatever's in his application. Of course, I've sat through all this, and I notice there's all kinds of, or at least some rules changes, so we'll have to take a look at those and maybe supplement the application. And I think he'd probably like to speak to all the points that were listed on one of the previous slides about the certificate of need. So I think you might just see a supplement to the application come in.
Mr. Lillard's on military orders at the present time, so he's on active duty and was unable to be present.
All right.
Thanks, y'all.
Thank
Appreciate
you. The Music City Roland Jamboree.
Hello, Jenny Carson. I own the Music City Rolling Jamboree. I think I've actually already sent all my information with the initial application. We've been in business 10 years this summer. We've hauled probably close to 100,000 tourists in that 10 years. No incidents, no problems. We pick up over at Marathon Village. We take one break at a private bar, Cabana Taps. We pull off the road onto a loading zone, and then we take them back, drop them off. It's a 90-minute tour. Currently, we have allowed BYOB. If that changes, we're fine with dropping that. I hate to do that, but I will. We do sit down, there's no standing up, and I am fully air conditioned and heated, and we are a school bus with 2 air conditioners. Any questions?
In conversation, I think your intention is to go the sightseeing route, because a lot of what you do is beyond the downtown area, which is sightseeing various places.
We are a sightseeing tour. You do have to sit down. It's an actual show. It's not a party bus per se. We have a singer on there who sings the songs as I tell the story. I, as the owner, am on every single tour. No one else gets on. There are no other people who work that particular tour.
And when you say you tell the story, what you're doing is you're describing what you're taking them to see, and then she's supplementing it with a song about.
It's he, yes,
he
is.
So.
Yes, if we talk about Dolly when we go by RCA, we do a Dolly song and so forth. I am insured with the same insurance company for the entire 10 years. I've had the same agent. I've had the same drivers for the entire 10 years, with the exception of one who left to have a baby, but she's coming back, so I'll have actually the same 3. Does anybody have any questions?
And so you're going to be seeking a sightseeing tour permit, not a
that's
general permit?
really what we are, yes.
So that would mean no alcohol?
I hate to say that, but yes. You know, people come here to drink and have a good time, and even on a sightseeing tour, that's what they like to do, and ours has comedy, and it fits with the comedy. I'm very limited on what they bring on that bus. I do check every bag that gets on there. I check every ID. No one under 21 is ever allowed to board. But if we have to give that up, we will.
All right, thank you.
Thank you.
The Redneck Comedy Tour. Mr. Winters, you were speaking for Tennessee Transport Holding LLC.
Correct.
Were you also speaking for Tennessee Transport Service LLC?
Not me.
Okay. Very, very confusing.
You will recognize them by their other name, Joyride.
Joyride, yeah.
Okay.
Yeah, just doing business as Joyride. My name is Brian Deal. I'm the co-founder of Joyride. We've been in business since 2012. We operate the golf carts, obviously, but we also have the monster trucks and the party buses as well. We're asking for 16 permits. We have 9 party buses. We have 7 monster trucks. We currently have an office we've had now for 5 years, well, 6 years now, on 833 9th Avenue South. We just opened our bar, Low Places LLC, which is over there now. We just opened up This week, we drop off and pick up from there, from our office.
On private property?
It's our property, yes. And then our party bus tours and stuff like that, if we try to make it through the whole trip, if somebody has to go and we're on that side of town, we'll stop by the TA truck stop. But we typically try to always come back to our office for breaks and stuff like that. One thing, I have a question for you guys. Can you have for our monster trucks, for instance, it's families, it's little boys and their dads. It's mainly family tours and stuff like that. We don't really do a lot of party rides on the monster trucks, but can you have both the ET and the sightseeing on those vehicles, or
For the same vehicle?
for the same vehicle? So if we had a group that wanted to book it to go out and party and ride around, but during the day, I mean, you can go into Tootsie's. A family can go into Tootsie's till 7 o'clock during the day every day, but they can't be on the bus together with a beer. Dad can't have a beer, so it's just.
I mean, so you'll make an overall decision about how many permits of each type the public necessity and convenience justifies?
Because during the day it's tours, at night is more party at night, but during the day we have.
The vehicle be permitted with both.
I mean, I guess you could give the company permission to have a certain number, you could allocate a certain number of maybe both kinds of permits to the company, and then, as long as they're complying with the rules when they're operating as a seated sightseeing tour, then I suppose you could use the same vehicle. I've not thought about it
Well,
really.
I have thought about it a little bit. I think the problem you might have is if you're the party vehicle, you could clearly do tours and comply without any problem. But if you're only trying to be a sightseeing tour and you're trying to comply up, or you're trying to change to the other, basically what you're trying to do is go into an area, and in this case requires lower fees and lower, if they're all licensed at the higher level, it wouldn't be a problem. If you're trying to do splits, then what I would recommend is that you could, whatever, this particular vehicle is licensed in this section and this particular vehicle is licensed in that section.
I think we just need to be careful as far as with police and asking them to monitor that, because how do they know if they see them down West
Well,
State?
and that's the reason the vehicles are gonna need to be, they'll be marked separately and have unique numbers, so we're gonna know that this vehicle is a sightseeing vehicle and this is a party vehicle.
That makes
Again,
sense.
in the same instance, if he has the one that is permitted for the party vehicle, but during the day he wants to take them down to see Parthenon, we would have to find a way to make that number associated with both, that they are okay to have that during the day. But I think it is a slippery slope, because if it's enclosed and they can't see in, they don't know if they're drinking in the middle of the day. So
And I would defer to how TDOT does commercial vehicles. I can put an H1 tag on a vehicle and use it commercially or drive it back and forth from my house. But I'm going to the higher level to say if and when I use this as a commercial vehicle, it is licensed, it is in compliance, and if I want to drive it home, so be it.
Yeah, I think we did sort of answer that question earlier when we said if you use it as a party bus part of the time, some of the time.
Right, you have to be permitted.
Then you do have to be
that.
permitted as a party bus.
But I guess my concern is if that's what they're permitted for, and we expect police to monitor that, and we say you can only be, in this whatever blocks, and then they're outside of that, how do the police know that
We could have
tour
an
is not
we'll have an
a-
enforcement issue.
That is a policy decision that you
I remember the
need to
lieutenant,
make.
he was like, keep it simple if you want us to be able to enforce, so.
One or the other.
All right.
No in between.
So your monster trucks are people just sit inside the cab?
No, in the back of the truck. We have cages that we built. We can fit about 12 people in the back of the truck, and they can sit there and they can just drive around, and the kids love it. We do a lot of softball teams, and a lot of younger age people, on those tours. But we also do at night. People want to take them around, and for 2 hours on as a party vehicle, and so. And then as far as the heat, I know everybody's talked about the heat. Our buses, we keep the roofs, like somebody else does too. And we literally just cut the windows out. and we put 2 commercial grade air conditioners on top, and like 2 generators underneath, and it's still unbearable. We've had tours canceled in the middle of a tour because it was just too hot. They were about to pass out. So I know there's nothing to really be done about that right yet now, but just wanted to put that out there. It is an issue.
But I just want to point out, we have had people come before us to say, we have a bus, it's air conditioned, it's cold.
Mm-hmm. Any other questions?
Thank you very much.
Thanks.
Upstage party bus.
Well, hello, friends. How we doing today? Save the best for last. No, I'm just joking, guys. That's what kind of happened with having the U name, I guess. Well, first off, guys, it's been a long day. Thank you for sitting through it all and taking the time to actually listen to each and every single one of us that are here to go ahead and speak. Clearly, they're, well, first off, Patrick Kludak, Upstage Party Bus. I think I said it. I don't know. But anyhow, we do our pickup location over at Nashville Wine and Spirits, which is 529 4th Avenue South. There's a very big parking lot back there. We are out of the way of traffic for that part. We have 2 separate buses. One is called the Upstage Party Bus. It's the big white coach party bus. It is hands down the most expensive bus that has ever been built as far as a party bus goes. As many of you guys know, you start at the bottom. I started in 2003 with a sedan car. That's all I had, just a sedan car. I worked my butt off. I did not go out partying with my friends on the weekends. I didn't do any of that. I was literally at airports picking people up. I was going and taking people to weddings. I was doing everything and working my butt off to go ahead and achieve my goals of being where I'm at today. I am a co-owner of this company. My other owner is my wife. We are a family-run company, and our second bus is called the Avery Grace. The Avery Grace bus is named after my daughter. I built it with her in mind completely from the ground up. We went into Marshall's, and we looked at some stuff, and she pointed at a whole bunch of glitter. I went ahead and I bought a whole bunch of that glitter. She looked at the flowers. I bought a whole bunch of flowers. I went ahead and made a flower wall. I made a shimmer wall. I made a photo booth. I made this thing as girly as it comes. That bus is completely different than the Upstage Party Bus. The Upstage Party Bus was a design concept that we came up with after seeing all the school buses. We decided, what could we do to be different? Now, sure, a lot of people in Nashville do not like open-air party buses. And why is this? Because there's so many of them. They all look the same. They're all over the place. It is what it is. We wanted to be different. That's why Avery Grace is not the same as Upstage Party Bus. Any buses from here on out, they'd be different. Every single one that we would put out would always be different. We have just reached about 50,000 riders, or a couple hundred people short. We have been doing this since 2018 with the open-air vehicles. We haven't had a paper cut, not one injury. This whole entire commission was all put together to write rules and regulations on account of open-air party buses and how to make them in compliance and make it so that way the city is completely happy with them. Again, the city was tasked with open-air party buses. That's what we are, and that's what we hope to continue to achieve to be. I have spent a lot of money to go ahead and get 2 different professionals out, and they actually wrote some emails to you guys. They have been printed up. One is from Tim Jacobs. He is not only a phenomenal mechanic, but he's also involved with owning his own airport hangar that services airplanes. Then there's Garrett Jackson, who as well does work on airplanes and vehicles. Now, why get somebody who works on airplanes? Well, it's very simple. These guys are trained much more professionally than just your traditional diesel mechanic. They specifically have told me, Pat, you got a very large ornament right now. That's what it's going to be. You won't be able to operate. You guys will literally be taking away everything I have worked for, everything my wife has worked for, if you guys make these things enclosed. I personally reached out to the folks over at Sweetwater Sound. Sweetwater Sound is one of those companies that do, you know, like, sir, you had said, why don't you guys do omnidirectional? Figure out sound, figure it out. You test us with that, and I figured it out. Essentially what you need to do is you need to have the speakers at ear volume, aimed down, aimed in. If it's all right with you, I'd like to show you two different videos. One's from the inside of my bus, it's literally like a 16-second video, and then the other one is from the outside at 50 feet away. And you cannot even hear the sound. Now, when we're talking about things like hume fog, when we're talking about things like hospitals and all that other type of stuff, it was the wild, wild west out here for a while. I get that. I mean, people were creating these things in backyards. My bus was professionally made by the people over at Signature Coach out in Lebanon. These folks specifically make buses for, like, the big guys. Dolly Parton has a whole bunch of buses that were made by him. But anyhow, this is a video of us on the inside. You could hear it sounds very theater quality. It's all concert lights on the inside that just only aim on the inside at the current moment. And essentially all it is home surround system sound bars hooked up to a concert stereo system that make it so we could capitalize on this capability. It's a heck of an achievement in this world of party buses, because from the outside, this is what it sounds like and this is what it looks like. Imagine having a conversation. You could hardly hear it. You can't make out what is being said in the music. You can't make out anything other than a little bit of a muffled noise. You guys have been tasked to go ahead and figure out rules and regulations on open-air party buses. This is an open-air party bus. This party bus cannot be enclosed. It just simply can't. Only time you guys would let me operate would strictly be between winter months. We've done it. When you guys asked us to be enclosed, we did it. Ma'am, when you pulled up the records of what are people in New Orleans doing, what are people in Memphis doing, what are people in other cities doing, the simple fact is nobody has open-air party buses. What you found was rules and regulations written for party buses. A party bus is a limousine. They have been created like an airplane, essentially, to go ahead and keep all that cold air in, double argon glass pane windows, all that. Plexiglass. You guys allow plexiglass. I mean, plexiglass is dangerous. You could that stuff could go flying off and hit anybody. We use polycarbonate glass. We use, like, for the most part, what we were using beforehand was vinyl windows that dropped down and they all buttoned against the side of the bus. That wasn't good enough for you guys, and we went ahead and spent $10,000 on an enclosure. This is for my family. This is for the well-being of things to do in Nashville. I want to make it clear just how many times I have had many people tell me, sorry, I got a couple of girls missing out of my group. And why is that? Because they got date raped. They got date raped while in Nashville. You know how many people feel safe on our buses? How many people have private group outings? Are we needed for the city? Yes. Is it a tourist attraction? 110%. We've got 325 five-star reviews on Google. We've got one negative one, and that negative one, you know what that's for? Is because we listened to Mayor Cooper and we closed down during COVID when they asked us to, while other party buses were out. Sure, there's a ton of bad actors. Sure, there's a lot of red tape for you guys to cut through to go ahead and figure out. But there's a lot of good actors in this room, and there's a lot of good people who work very hard. I'm one of them. So, that being said, if you guys got any questions, thank you for taking the time to listen to me. I truly do appreciate it.
Do you make stops?
Yes, ma'am. We stop at 420 North Broadway. We shook hands with Brandon Spain, and the whole entire back of our bus says, "Follow us to Second Fiddle." It is a 15-minute loading zone on Broadway. We realize that traffic is, of course, a problem from time to time. On 5th Avenue North, what we'll do during busier times is we'll go up and around over to the side of the Ryman, which is a bus loading zone for 15 minutes. We do not impede traffic. In the event that we need to utilize a different area because Broadway is shut down, we will go over to to the same place that everybody goes to over on 6th and Peabody, but we typically try to use the Sherman-Williams parking lot to stay off of the road.
Thank you very much.
Thank you, folks.
All right, I think that concludes all of the roll call for the company applications.
So my name's Curtis Carney, and I sent Billy some emails. I missed the deadline, and I've been here since 2016. I apologize for missing the deadline. I was out on a campaign for elections, and I thought my manager had got it done. Come to find out, she quit, and it was not done or turned in. The 14th, 13th, I was actually trying to scramble and get it turned in, and was trying to email back and forth and get everything done, and I was not able to get that accomplished. I wrote Mr. Fields an email, and I asked him for an exception. I said, sir, first of all, I accept responsibility, it's my fault. I said, but we've been in business since 2016. We were the first tractors in town, and I would like to ask the commission to allow that. Like I said, had I been there, or had I thought that it was accomplished, I would not have allowed that to happen.
What's the name of your business?
It's Off the Wagon Tours.
And I'm sorry, I didn't get your name at the beginning.
Curtis Carney.
How many trucks?
We have 4 and a shuttle bus, so 5 total.
Actually, tractors and a bus, right?
Sir?
How many tractors?
No, we have 4 tractors and 1 shuttle bus. Not a party bus, it's a transportation, like drive people back and forth.
The tractor with a wagon?
Yes, sir. Yes, sir. We have 4 of those. I'll tell you this, so we started in 2016. There was very few of us around then. Since then, Nashville has boomed, and we have boomed. A lot of people don't like the transportation industry, but and personally, as I've watched Nashville grow, people were looking for things to do. And Nashville isn't like a lot of other cities. We don't have dinner shows and other things to do. So it's either a bar or transportation. And if you look at the way Nashville's grown, I believe we've played a big part in that. The ones of us who have been around for years, we have put safety first. Now, there's been bad actors that show up out of nowhere. But the ones that have been around, we're around for a reason. It's because we've made an establishment of safety and making sure that we're following the rules for certain things. We've served everybody from church groups, soccer teams, artists, shot plenty of music videos. We stay to 21 and up. That's just our personal preference. Other companies have chosen to go under that. That's their personal preference. We chose to do that for our own reasons. But we turn down quite a bit of tours because people under 21 want to attend, and we just won't allow it. People are like, we've got 2 people that are under 21, and we just won't allow that. I recommend them to other companies that do. We just don't. As a police officer, back in the day, when I started this in 2016, I planned all of our routes for safety. We're making mostly right-hand turns, and we're in places that the tractors can get in and out of, and not have to worry about pulling out in front of cars or blind spots and this and that. And our routes are also designed around emergency vehicle egress. So for vehicles, I had a doctor from Vanderbilt call and was concerned about party vehicles slowing down traffic getting into ambulances going into Vanderbilt. And I said, well, we don't have any vehicles heading that way. They're all heading out of town because of the way we've done our routes. I say stay unenclosed for several reasons. Safety is one of them. You know, at first it was, hey, we're the safest thing in Nashville because when COVID was going on, because we weren't enclosed. And now we're telling everybody to close them back up. So my question is, what is the real reason for enclosure? Because being enclosed, I don't know if anybody saw that ridiculous party vehicle video that went around last week of a bunch of unforeseen things going on. It wasn't any of us here, I can tell you that. But one reason that we try to make people feel safe, and I think that one of the other gentlemen said it earlier, how many people, how many girls and women, and if I was letting my wife go out to another city, I'd rather her be on a party bus than in a bar because of all the things that can go on. Girls can act and be themselves and not have to constantly watch their back because they're around a small group of people that they're used to. So I think, to me, it's a safety thing. To go on with Mike's thing, the CDL stuff, we're just like many other businesses in Nashville trying to get enough employees, and it is hard. And we pay them good to try to keep them, but it's just hard. We've tried to put common sense into a lot of things that we've done. We've learned from each other's mistakes and errors and how we build things because of that. You know, we've built all of our own equipment, the same as Grant and them did with the party buses, because we knew that the safety was the most important. You can't just go buy a wagon and expect it to be safe. So our rail heights are high. They're like 42 inches, well above the standard for everything. You can't even get close to our rails because we've got a bench there for a seat. We've all put a lot of thought into it, and I think common rules and laws, common sense rules and laws will go a long way. One of the greatest things I learned was in Afghanistan, and had the people that were above us actually listened to what we said, a lot of people wouldn't have got hurt. And I think it's important and I appreciate y'all taking the time to listen to everybody in this room, because making a decision blind is extremely hard to do. So thank you guys for that. And that's about it. That's all I got. So thank you.
Did you say you used to be a police officer?
I did, yes, sir.
Well, I want to thank you for your service in both areas. And as your experience as a police officer, by the way, how long were you a police officer?
12 years.
Metro?
Right outside Nashville, 12 years, yes, sir.
So, you think that the standards that you guys are already using, in your opinion, just taking your business out of your mind, if you could, for a minute, do you think that the open air, the whole concept is not only safe for your customers, but for the other customers, which are the people who live in the city?
I'll say this. This is not off the wagon owner. I mean, I guess it is. It's the same opinion, really. The biggest issue that we fight in Nashville is going to be Uber and Lyft. Those are the ones who probably cause the most almost accidents. In 6 years, we have not had any accidents except for 2. One was hit by a Metro bus, and the other one was somebody rear-ended. The issues that we've seen, loud noise, that I agree with. Hey, because people shouldn't be annoying people who are living in the high-rises with ridiculous music. I agree with that. I agree with staying out of the neighborhoods and staying in certain places. Then closures, you know, there can be a lot of common sense things that we can all come together on. But as a police officer, I think, as a police officer, I talk to these guys all the time, and they don't usually have a problem with us. Again, you've got the certain people who do bad things, like stop in the middle of the road everywhere and certain things like that, but that's a personal problem of that own business, I guess, so.
Thank you.
Yes, sir, thank you.
Thank you. All right, we need to set a time to meet next week, and during the break, I had suggested to Mr. Fields that perhaps we try to meet Thursday afternoon, if that's okay with.
So that would be June the 30th.
Yes, if that's okay with my commissioners here.
We'll have, we need to make sure there are 5 members present. I've polled, Mr. McNally is still doing the federal court. Ms. Westlake will still be out of town in a family situation. Ms. Powell has a limited time Thursday afternoon, so we basically would need, and I know Mr. Hayes said he would be out of town next week, so we basically need the remainder being present. Is there another day next week you could?
Yeah. You said Wednesday afternoon?
Wednesday afternoon.
Okay.
We'll just have to find a meeting space, but we'll find it.
Let me double check.
If I can change the call, I've got something scheduled, I'd have to see if I can change that, but.
I can make Wednesday work.
1:30 Wednesday at 1 o'clock? 1:30?
1:30.
1:30. So that would be June the 29th, 1:30.
Does that work for you, Freddie?
Yeah, that's about the only day that would work actually is Wednesday.
June the 29th? So Wednesday,
Well,
June the 29th?
Yeah.
Right, Thursday, the 30th you wouldn't be available, Ms. Warren.
Right.
But the 29th you would be.
If I can change this work call, I can.
I've got lots of confidence.
Well, it's not my, I did not
And
originally
Mr. McNally,
call this.
and Mr. McNally may be available on Wednesday because his trial,
He's got COVID.
but not by next week. He'll be out of isolation.
I'm gonna put a mask on.
And the purpose of this meeting will be?
So, continuation of this hearing, the public hearing, for us to consider the public need and necessity, and if we say yes to that public need and necessity, considering the application.
Okay.
And that'll get sent out to the world so people will know about it.
And we will find the location. I do have one piece of other business, if I may. I'm happy to report that Mayor Cooper reappointed your chair, Mr. Hernandez. He was confirmed by the Metropolitan Council on Tuesday evening for one more term to see us through these issues.
We appreciate your
So thank you.
Absolutely.
I would also tell you on July the 5th, Mr. Carr will be appearing with the Metropolitan Council. So
Really good luck.
I have no other business. We will get this information to you as quickly as we can set the location.
Can I
All
ask
right.
a clear weedish question so that we know?
Sure.
Whenever you have your meeting and you smack the gavel, is that the point where we know what permits we do or don't have?
Yes.
Yes.
And will we know the effective date when all of those rules and things that are passed?
Like enclosure modification, just as an example.
Right.
Well, some of them were set today, but of course, they're not enforced because you don't have a permit.
Yeah, but if I get a permit tomorrow, it'll take me 3 months to actually be able to abide by it.
You do have one question. Mr. Carney asked if you would consider his application. He did miss the deadline. I did not accept it because he failed at the deadline.
The reason I would ask is because we're still under development and I.
We'll take it.
We'll consider it.
Thank you.
The commission will have to take a vote.
We'll have to take a vote.
You set the deadline, you'll have to take formal action to accept it.
Well,
I
does
make a
anybody
motion
make
that
wanna
we,
make a motion?
If I may make one more suggestion.
Hang on a second, we got a motion on the table.
I make a motion to accept Mr. Carney's application.
Thank you, sir.
Is there a second?
I think I'd like more discussion. It kind of was brought up to us at the end, and I know that's not helpful, but.
Well,
I'm not saying it to
and I'm
people.
saying accept it because we still, I mean, it's an application and we still haven't issued any and we're still.
And this is gonna sound like don't wanna do this. We had 2 or 3 others that missed as well.
Oh.
I didn't accept
It's not fair
it.
to the people who did.
Well, I'm not sure I can.
But I'm the only one that showed up also.
Well, I'm not sure I can identify them as the biggest
I'm
problem.
sorry.
I mean, I just want to make sure we're
unaware.
fair.
I was
That's
unaware.
all I'm concerned about.
I thought with this extensive list, everybody
I
that
would-
wanted to get in.
I would like to add, the reason I asked is because we're understood as the development process. Even with the permits, we don't have anything that on rules or standards, so we went into it blind.
I would still put it out there.
Yeah, it's
Second,
commission decision.
nay, yay, I'm gonna still
Move
leave
we
it out there.
adjourn.
All right, the motion fails, there's no second.
There you go.
Sorry.
No, you're not.
Sorry.
I perfectly understand.
So Billy's, I'm sorry, Sally.
And I'll get the information to you as soon as I can find the location.
29th at 1:30.
And you owe us pizza.
We'll shoot for this room.
Yeah. We haven't adjourned yet.
I move we adjourn.
So Mr. Fields, I got a question, for,
We did not make a motion to adjourn?
Yeah.
Billy, I'm sorry, you
excuse
need
me.
to finish meeting.
I have a question for you, Mr. Fields.
Yes.
On, looking for my agenda here. Just wrote it down.
While you are looking for that, are we also going to determine numbers of permits that will be issued?
That would be, the plan would be
That will
make
be
it,
next, that will be on the agenda for next Wednesday.
Who would be able to hear from other people who weren't here? 'Cause I'm not sure I want to vote on anybody I can't.
that would be your
Prerogative.
prerogative.
Di-
So I'm gonna ask them the same question.
Mona Lisa, you said you wanted to defer deciding whether or not to accept Off the Wagon's application as
Oh, I
timely?
was just saying, I at least wanted to think about it a little
Okay.
more, but, you know, my
Well,
thought
do you
is,
wanna,
I didn't realize
Freddie,
Billy.
do you wanna make a motion we defer his request to our special meeting?
Sure. I would like to make a motion to defer any applicants specifically,
Well, I'm talking about Off the Wagon tours.
off the wagon tours.
Well, but I think that was also before, I heard he also told other people they couldn't.
Right, so if we're gonna defer.
Well, it's your
okay.
motion, I'm not, go ahead.
So,
But did the other people show up to the meeting and sit to the
Right.
meeting the whole time? He's been here the whole time. I don't work for him,
understand
but I'm just
that.
saying.
We don't need any adding on here.
So I'd like to make a motion to defer any applicants specifically that have not already applied to the next special meeting.
and we're saying we
I'll certainly
decide
try to
then.
identify all the others. I don't know that I can, but I'll do my best.
I think you want to phrase that
Who-
motion that they.
Who've already submitted, but they're late.
Right.
Right.
We're not asking for new applications.
No,
There are-
sorry. I'm sorry. Long day.
Thank you.
I'd like to make a motion to defer any applicants who have already applied.
There are none. I didn't accept any of them.
Oh, you did not accept.
So there's no way, I can't, that's the problem. If I had them, I could say, sure, here they are. I just,
Mr. Fields hasn't talked to you.
I'm sorry?
I was saying that you haven't talked to
Yeah,
them.
I know, I get you.
I mean, I talked with them when they came in, denied them, and they left.
It's almost impossible to make it inclusive with.
Again, I'm not opposed to it. I'm just saying, I just,
I am.
Well,
It'd be, yeah, in that
sorry.
case, it'd be opening a can of worms if you don't know.
Yeah, and my office was consulted about it, and our opinion is a deadline is a deadline.
Yeah.
yeah, I mean,
I
we didn't do it
withdraw.
lightly. That's the problem.
I would try.
Move we adjourn.
All right. All those in favor?
Aye.
Motion passes.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.